4, 2, 3. List 1 or list 2?
List 1.
ಯಾಕೆ 19 ನಮಗೆ ಬರುತ್ತೆ
27 ನಮಗೆ ಬರುತ್ತೆ
ಇವತ್ತೇ ಇದೆಯಾ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಪೇಜ್ ವೈಸ್ ಕರಿತೀನಿ ಅವಾಗ ಮೆನ್ಷನ್ appeal acquitted. ಬೇಡ ತೆಗಿತಾ ಕಾಲ್ ಬಿಡು ಉಳ್ಕೊಳ್ಳೋದು ಒಂಚೂರು ಬಿಡುತ್ತಲ್ಲ Any memos?
No, I'm up for settlement. Criminal petition.
Hello. Look on date.
Tomorrow. Tomorrow.
Ma'am, tomorrow. Edit. Any adjournment? List 2, page 5, serial number 17 to 20.
My lord, serial number 20, my lord.
Serial number 17.
17.
Yes, ma'am. The last time.
Counsel for the petitioner prays for time and undertake to address his argument immediately after vacation. Thus,
Madam, candidate.
list finally as a last chance.
My lord, serial number 20.
20.
My lord, serial number 20.
Yes.
Senior's wife is hospitalized.
You are representing whom?
I am representing the petitioner, my lord.
The same. Yes. next.
Serial number 19, my lordship.
19. You are for?
You're for petitioner, my lordship. 1 week
Petitioner
time.
prays for time. Okay, same. Next. Page 6, serial number 22.
I'm not serial number 22, my lord. I pay for the petitioner, my lord.
Yes,
I pay for an agreement in this case, my lord.
prays for time. Yes, next. List 1, page 1.
That's serial number 24. 27. Sorry, 27 minutes. It should be connected with another matter before quota number 7.
27 in
27 in list 2 minutes.
list number 2.
Yes. I appear for art.
27.
I appear
Counsel for the petitioner and respondent. Number 2, submit in unison that this matter is connected with so and so. Office is directed to list both the cases together. Yes.
Great. That's the IO is there.
Yes. Interim order iddalli extend. Yes. List number 1, page 1.
Serial number 1, Abhishek K. Non-compliance for first time.
Absent.
But in this case, charge sheet has been filed, my lord, they had challenged the FIR.
Pass over.
Serial number 2, Kiran V. Ron.
For the petitioner. All objections were complied with, only 2 objections are remaining. I seek for a week's time.
Pays for a week's time. Next.
3, H.C. Shivramu.
Waiting for petition, my lord, 2 weeks time, my lord.
Pays for 2 weeks' time. Next.
Obliged.
Non-compliance for third time. Serial number 4, Kamaluddin.
Absent, no representation. Petition is of the year 2020. Office objections are not yet complied with. List finally as a last chance. Next.
5, Naushad Pasha.
Lord, in this case, my lord, the accused has been convicted, my lord, the case is closed.
Convicted.
Yes,
Learned counsel for the petitioner is absent, no representation. Learned HCGP submits that the petitioner being the accused is already convicted by the trial court. Hence, the petition is infructuous. Submission is placed on record. Petition is dismissed as the same is rendered infructuous. Next.
6, Matthew P.M.
Absent, no representation.
7, Nishant Devi.
Finally, as a last chance.
Petition, of course. Only 2 office objections are remaining. The typed copy was already given for typed copies. Pray for a week's time, but I'll comply.
Finally,
Madam,
is posted finally today. Pass over, I'll pass over. Please comply with that.
time I'll typed copies are yet to come, my lord.
Get the type to copy, sir.
My lord,
Before
so,
before 4:30 you file it.
but
Thereby
today
you
it-
comply with. That is the only objection.
There are other minor objections which are.
Then
but
you
typed
said only
copies-
objection.
typed Copies are the 2.
ನೋಡೋಣ
days I
ನೋಡೋಣ
want.
ಅದೇನು ಫೈನಲ್ ಇದೆ ತಾನೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ 2020 matter, even after 4 years you are not bothered to comply with that.
My apologies, madam.
There are still 4 more objections.
Somewhere complied. madam.
Pass over, look into that. Next.
Serial number 8, Venkatramana M.K.
ಏನಾಗಿದೆ ಫೈನಲ್ ಇಲ್ಲ ಅಬ್ಸೆಂಟ್ ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫೈನಲಿ as a last chance of the full ಹಾಕೊಳ್ಳಿ
9, Gangabai V.
my lord, type please, my lord. Waiting for the petitioner, during the course of the day, we will do the compliance, my lord.
Only that order sheet, only.
One
The
minute.
stage is showing that, my lord, they have pleaded guilty and case has been closed, my lord.
Yes,
Then verify with that.
the petition will not be survived.
Check it.
Verify, pass over.
10, Sunita M.
Appealing for the petitioner.
A charge sheet has been filed, my lord, in this case, in the year 2020.
I'll dismiss.
Withdraw it, my lord.
File a memo. Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record. Petition is dismissed as withdrawn.
Serial number 11, Sheikh South.
In this case also, my lord, charge sheet has been filed.
Pass over.
12, Girisha N.
Absent, no representation. Finally, as a last chance.
13, N. Praveen Kumar.
The petitioner, my lord, pray for the week's time. You have complied with further objection raised. I'll look into that and a week's time I will grant.
If the
Finally, as a
case
last
has been
chance.
committed to sessions court, my lord, they had challenged the cease.
Charge sheet has been questioned, my lord, and
Not only charge sheet is filed now,
Still
matter is already committed to the sessions court. We don't know the stage before the sessions court.
and I'll verify and
The
make some.
court will proceed.
Taken up
Why
next
this
week.
petition is to be kept pending?
Next week, my lord, I'll verify the stage and I'll make service.
Counsel for the petitioner prays for time. The matter is listed for the 3rd time for compliance of petitions. Then at HCGP submits that the matter is now already committed to the trial sessions court for trial. Counsel for the petitioner undertakes to verify the stage, public comply with the office objections, and make its submissions on the next date of hearing without fail. List finally as a last chance. Finally, it is posted. Next.
14, Prakash M.H.
Absent, no representation, petition of the year so and so. Finally, as a last chance.
Non-compliance for 4th time, serial number 15, Satyanand B.S.
My lord, I am for petitioner in this matter. May I make this submission, my lord?
Yes.
B report is already filed in this case.
Yes.
I may be permitted to withdraw this petition.
Counsel for the petitioner seeks permission to withdraw the petition as B report is already filed by the investigating officer. Submission is placed on record, petition is dismissed as
Please.
withdrawn.
Much,
16.
much.
This matter I appear for the petitioner, only typed copy not, it is ready, madam, 3 days time maybe.
If it is ready, why 3 days time is required?
NOC.
To file it in the office, 3 days it is required.
Other not index and all, I have to change not, index and all.
Sir, it is posted finally, sir.
But-
Pass over.
I
Please
may-
look into it, pass over. Next.
17, Shiva Prasad YS.
Counsel for the petitioner is absent, no representation. Order sheet dated 1/7/2024 reads as under. In spite of that, the office objections not complied with. It appears petitioner is not interested in prosecuting. Dismissed. Then extract ಮಾಡಿ 1/7/2024.
18, Shanmukha Reddy.
That this case has been closed under section 258 of CRPC.
258.
Yes.
Counsel for the petitioner is absent, no representation. Then at HCGP submits that the case before the trial court is already closed under section 258 of CRPC. As the petition has become infructuous, the submission is placed on record, petition is dismissed as the same is rendered infructuous. Next.
19, Bhargav G. Finally.
Pass over.
20, Sampath.
My lord, appearing for petitioner, my lord, kindly seek the submission of a memo for withdrawal. Memo for withdrawal.
Withdraw. Counsel for the petitioner filed a memo seeking permission to withdraw the petition. Memo is placed on record, petition is dismissed as withdrawn. Yes.
21, Rangnath Reddy.
Here for the petitioner, Lord, I've complied with all the office objections, but the office objection in respect was which was before the magistrate court. Now the case is committed to the special court, transcribing court. The proceedings, entire proceedings are.
You have complied with that.
Lord, I have not complied. Kindly make
Pass
a
over.
vote.
Pass over. Preemptory order is there. Be careful. Pass over. Next.
Serial number 22, non-compliance for 8th time, Karunakar Appi.
My lord, pray for 2 weeks time.
Finally. Pass over.
List 2, serial number 1, Avin TH.
And for petitioner, my lord,
ಏನಾಗಿದೆ? Police report? Yes, what happened to the police
so
report?
I'll verify.
Await police report. Next.
Serial number 2, Sheshagiri Rao. Office objection. Sir.
Yes, office objections on statement of objections.
My lord, can I kindly have it password, my lord.
No, she
I'll
has
serve the copy.
done at HCGP praised for time to comply with the office objections raised on the statement of objections. List on. Next.
Serial number 3, Sudarshan AM.
Counsel for the petitioner is absent, no representation.
Office objection.
The PF and petition copy. The annexures are not furnished for issuance of notice to respondent number 2. Office objections are also not complied with. The petition is of the year 2020. I do not find any reason to adjourn the matter, however, to afford final opportunity. Next.
4, Sumana Naganand.
Lord, may I request this matter to be taken up with serial number 25, my lord. It's between the same parties. We want to report settlement.
Do you report settlement?
Yes,
1108.
5, Syed Ahmad Nilufar.
Paying.
Parties are present.
R2 is present.
Yes, ma'am.
Finally, she is present.
Sorry for the delay.
Good. Yes, agree for the terms. ಬರ್ದಿದ್ದಲ್ಲ ಸರಿ ಇದೆಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದಲ್ಲ. Yes, what about compromise ಆಗಿದೆ? You received 3 ಲಕ್ಷ ರೂಪಾಯಿ ಬಂದಿದ. ಮತ್ತೆ what about site? ಏನಿದು? Whereby husband is paying a sum of rupees 8 lakh.
Yes, yes.
ಬಂದಿದೆ. And what about the site 30 by 40? You have received it. Nothing is due from him. You agree to withdraw everything, all the allegations.
Yes.
You also agreed for divorce.
Yes.
Yes. So, petitioners 1 to 5 and respondent number 2 are present with their counsel. The parties are identified by the respective counsel. The learned counsel for petitioner and respondent filed the joint memo and the joint affidavit shown by petitioners 1 to 5 and respondent number 2, which reads as under. The talaknama, public divorce deed dated 29th August 2024. Declaration of appointment of guardianship. Dated 29th August 2024. Gift deed dated 18/9/2024. Copy of the RTC. Aadhaar card of petition, Aadhaar card of petition number 1 and respondent number 2. No, it is produced here.
Aadhaar card.
No.
Aadhaar card.
Whose Aadhaar card? It is produced. Aadhaar card pertaining to petition number 1 and respondent number 2 are produced along with joint affidavit. On inquiry, petitioners 1 to 5 and respondent number 2 admit the terms of the joint affidavit and also submit that they have agreed for the said terms. Next, respondent number 2, when specifically inquired about the terms of compromise, she admits that she has received rupees 3 lakh in cash, as mentioned in para 4, rupees 8 lakh. And the site measuring 30 by 40, as mentioned in para 5 of the joint affidavit. She submits that she has no claim whatsoever against any of the petitioners, plus petition number 1. She also admits that she has agreed, she has given talaq to petition number 1. Satisfied with the terms of the joint memo, same is accepted. Joint affidavit, same is accepted. In view of the above, the petition filed by petitioners 1 to 5 is allowed. The so and so is quashed. Yes, allowed. They have to sign the order sheet and you have to identify the parties.
Please.
Yes, next.
Serial number 6, Kanchan Jainandan. Permission.
Subject no representation. Petition is of the year 2019. For issuance of notice to respondent is not furnished. List finally as the last chance.
Serial number 7, Suyo Gerele.
May appear for the petitioner. Not in the connected matter, my lords, 29406. The same respondent has been served, my lords, and she remains.
29.
Connected matter, 2946 WP.
Huh.
In that, my lords, the very same respondent, my lords, has been served and remained unrepresented.
Learned counsel for the petitioner submits that respondent number 2 in the present case is respondent number 2 in the connected WP 29406 of 2019. The said case, respondent number 2 is duly served and remained unrepresented, and hence he seeks dispensation of issuing fresh notice to respondent number 2 once again in the present petition. Submission is placed on record. The note issuance of separate notice once again to respondent number 2 is dispensed with the risk of so and so. Yes.
My lords, may I request for tomorrow? Matter is covered by
decision. To show the name of so and.
My lords, may
May
I request for tomorrow? Short date, my lords. Covered by decision, my lords, of your lordships. 420 is the allegation, my lords.
Learned counsel for the petitioner submits that there is urgency in the matter and prays for a specific date. Huh? Yes, Monday.
Please, interim orders may be extended.
Yes, interim order is the extent. Next,
Date,
Grateful.
Sakshi Muchande.
No, my lord, apologies, but we were not aware of the matter because the name in the cause list is spelled wrong. The respondent advocate called us only then we got to know about it.
whom you are representing,
Siddharth B. Muchandi, my lords, the petitioner.
name is mentioned in the cause list.
My lords, the spelling of Muchandi is
Okay.
wrong. My lords, we searched.
Don't search for lame excuses.
No,
You should be happy that your case is listed.
much obliged,
There
my
are
lords.
thousands of such cases where the learned counsel are waiting for listing.
Much obliged, my
Huh?
lords. It's
And when it is listed, you search for some lame excuses.
not at all, my lords. We will carry on the compliance, my lords.
Huh?
We search from the name Muchandi, my lords, that's it. I request that the name may kindly be amended, my lord.
16/1/2022 filed by advocate for petitioner reporting death of accused number 2. Learned counsel for the petitioner filed memo dated 16/1/2022 reporting the death of respondent accused number 2. Accused number 2 are petitioner number. Petitioner. Petitioner body. Who is this petitioner?
My lords,
What is his rank as an accused?
my lords, now one of the accused is deceased, my lords, and the cause title has to be amended.
No, whether his party, whether deceased is a party in this petition,
Yes, my lords.
party as,
Party as accused, my lords, accused number 2.
in the petition, there will not be accused. There will be petitioners and respondents.
My lords, he was accused number 2 in the crime, my lords, and here,
How I am concerned about that?
much obliged.
He is not a party before this proceedings.
My lords,
And whether he dies or not, how I am concerned? Admittedly, he is not a party.
much obliged.
Then it is noticed that accused number 2 is not a party in this petition. Hence, the memo is rejected. Memo is ignored. Next ಏನು? Next ಏನು?
My lords, my humble request.
Non-amendment of cost title ಏನೋ ಇದೆಯಲ್ಲ 14(7). You amend the cost title immediately.
Much obliged.
Pass over.
My lords, I request the name also. Like
Counsel for the
the
petitioner
name in the
submits
cause list.
that the name of the learned counsel Shri Siddharth B. Muchundi is not spelled correctly. Office is directed to spell it correctly. Yes, first amend the cost
Much
title.
obliged.
Serial number 9, Satyanarayan Chalke.
My lords, I appear for the petitioner, my lord. I'll do the needful during the course of the day, my lord. I'll furnish the PF when you
Pass over.
My
10,
lord, my lords, may I make a mention, my lords? By my colleague in the morning by mistake mentioned list number 1, serial number 20 instead of list number 2, serial number 20, my lords, because senior is not available today because he's taking his wife to the hospital. He made a mistake by mentioning the matter in list 1, my lords. It is actually list number 2, serial number 20.
Already adjourned, sir. Next. Next, serial number 10.
10, Lata Shetty.
Appearing for responding a memo for deletion of these respondents, my lords, 4, 7, 8, 9, my lord, they're all co-accused and no relief is being sought against them, my lord. So they're not
You are
necessary.
for the petitioner.
Please, my lord.
Learned counsel for the petitioner filed a memo seeking deletion of the names of respondent number 4, 7, 8, and 9,
Please.
against whom the petitioner had not sought any relief. Memo is placed on record. The names of respondent number 4, 7, 8, and 9 are ordered to be deleted. Counsel for the petitioner is directed to carry out the amendment today itself.
Please, my lords, I request if any date may be fixed for,
Huh?
any date may be fixed after.
First carry out the amendment.
I will do that.
Later we'll pass over.
My lords, interim order is there, my lords.
First carry out the amendment. Pass over. ಅದು 10 ಅದೇ ಸೇಮ್ ಅದನ್ನು ಪಾಸ್ ಓವರ್.
11, yes, Vinod.
Issue notice to respond, furnishing PF.
Counsel for the petitioner is absent, no representation. PF for issuance of notice to respondent is not furnished, even though the petition is of the year 2021. List finally as the last chance. Next.
12, M. Srinivas Murthy. Issue notice.
ಅದು ಎಲ್ಲದರಲ್ಲೂ 11, 11.2 ಎಲ್ಲದರಲ್ಲೂ 12. Counsel for the petitioner is absent, no representation. PF for issuance of notice to respondent number 2 is not furnished, even though the petition is of the year so and so. List finally as the last chance. Next.
13, Hanumantappa Ravi.
Same. Then.
Hearing on IA, serial number 14, Vinay Kuttappa, M. Sunil Shastri.
Appearing for the petitioner, my lords. My lords, I filed 2 applications, one for delay in filing the recall of the order, my lords. In last hearing date, respondent number 2 sought time to file objection, but they have not filed any objection till date, my lords.
The 527 days delay.
My lord, is it serial number 14, my lord?
Yes, 14.
My lord, I seek for a short accommodation to file objections, my lord, because we have not got instructions from the client yet, my lord, that being the reason.
My lords,
You are for respondent number 1, is it?
2, my lord,
respondent number 1, my lords, here I read as
Number 1. 2 is state.
stay, okay, yes, ma'am.
Senate counsel for respondent number 1.
my lords,
Raise the
one
time
humble
for
request, my lords.
objections. Filing
They have
of-
sought time on 27/8/2020.
Maybe there is delay of 527 days
My lords,
in filing the application by
my
you.
lords, respondent number 2 is taking coercive step against me, my lords. I was unaware of this
Yes,
order.
yes.
That's the reason I've stated my
Letter
application.
file
May be
objections.
taken up on Monday, my lords,
No,
at a
no.
shorter date. My lords,
My lord, such short
no.
accommodation cannot be
Date to approve.
My lords, one humble request, my lords, they got 1 month time to file their objection, my lords, they have not come up.
Sir,
My
again,
lords,
I am saying you took more than a year.
My lords, the
to file
reason,
the
I was
application.
not aware of the default taken place, my lords, and there is a change in council, my lords, maybe taken
Now
up
it
on
is already adjourned, not before vacation, after vacation.
a
Next.
date may be fixed, my lords.
Date will be fixed. Date will be fixed. Next.
Number 15, Jeevan Jain.
Much
eligibility.
obliged.
ಏನಾಯ್ತು? Objections ಎಲ್ಲ ಆಯ್ತಾ? ಇಲ್ಲ, ಅದು ಅದೊಂದು objection ಮಾಡಿ
Your lordship, the objections have been complied, your lordship.
ನೋಡಿ verify ಮಾಡಿ. Verify. Yeah, all objections complied
Yes,
with,
your lordship.
that will be verified.
Rajendra K.R. Gopal Krishnamurthy.
I appear for petitioner in this case, Lordship. Lordship, it's already, matter is heard and the respondent has filed the impleading application in this, Lordship. Section 141 of the NI Act does not attract in this case, Lordship. The only ground is that company has not made the party and the check is issued for the security purpose, Lordship. No legally bounded debt on that, Lordship. We have filed objection for the impleading application filed by the respondent, Lordship.
Impleading of company,
Company, Lordship.
counsel for respondent.
Based upon the merit, Lordship, the case may be disposed, Lordship. It's already heard.
Pass over.
Yes, Lordship.
Let him come.
Please.
Preliminary hearing D group, serial number 17 adjourn, 18 Vikas M.
I appear for the petition. I have filed invasive wakalat, my lords, on 21/9/2024, my lord. That has not been put up, my lords.
So and so submits that he has filed a wakalat with NOC. Office is directed to delete the name of so and so and show the name of so and so.
Lords, I may be permitted to file the applications, my lord, since respond number 2 against notice has been dismissed. I may be permitted to file the recall application and extension of interim order, my lord, in the registry, my lord.
ಅವೆಲ್ಲ ಈಗೇನಿಲ್ಲ.
I will take hand summons, my lord, in respect of respond number 2, my lord, and I will serve, my lord.
Next. Next, file it in the office.
Please, my lord. Any date may be given, my lords.
Next.
Please.
21 reporting settlement, Mahesh Pratibha KM.
Pass over.
I appear for the petitioner, my lord.
Yes.
My lord, there's lack of instruction. The respondent had informed that they have settled it, my lord, but I was not
I
able
will
to contact
dismiss
the
the
petitioner.
petition, sir.
My lord,
I'll
I have
dismiss it.
written,
Let them-
I have
let them
written,
settle.
I have written a letter to him, my lord. Only a week's time, my lord.
No,
If he
no,
does not
nothing.
communicate, I'll file my memo of
Nothing,
retirement,
sir,
my lord.
nothing, nothing.
Because I've already
If you
written a
want to
letter to him.
report settlement, please report it, otherwise I will dismiss this.
Lord, he's not receiving my phone calls, my lord. I've sent a letter. I'll place it on
I
record,
will
my lord.
record your submission that you are not receiving any instructions
Please, my lord, that may be recorded, my lord.
and dismiss the petition.
My lord, I maybe pass over, my lord. I'll file a memo, my lord. Based on that, it may be
Pass over.
dismissed, my
Next.
lord.
Pass over.
Much obliged.
Serial number 22 adjourn, 23 for admission.
That's kindly for the petition in this case.
Hmm?
Charge sheet has been filed.
23.
House, charge sheet has been placed against the petitioner.
Hmm.
Am I permitted to withdraw the petition?
Counsel
It's a
for
liberty to
petitioner
file.
filed the memo seeking permission to withdraw the petition. Memo is placed on record. Petition is dismissed. I will. Yes.
24, Keshav, Ian Jagdish.
Appearing for respondent number 2, my lord. We are ready with the arguments, but the counsel on record she's held up in court till 15, so kindly requesting for a pass.
No, you are for respondent.
Number 2, my lord.
Who is for the petitioner? We are for the
I
petitioner.
appear for the petitioner's counsel, my lord.
Serial number 24.
Yes, my lord.
Hmm.
There was a civil dispute, my
The counsel for respondent is held up in the other case.
lord. Only short point, my lord, there is no ingredients of SC/ST Atrocity Act. Lord, there was a civil dispute pending. Lord, on that score, my lord, now a criminal case has been filed. My
Let
lord,
him,
taken up tomorrow or my lord.
let him come. Pass over.
Pass over.
Oh, my lord.
Pass over.
Grateful.
Like before 2:30. 2:30 other matters are there.
Please, my lord, very well.
Come before 2:30.
Sriranga Raj, Nityanand Vinayak.
For the response. In serial number 4 also, both the parties have entered into amicable settlement.
Hmm.
To withdraw all the cases also.
Where are the parties?
And parties
Parties are present.
One of the petitioners is not present. His father-in-law passed away.
What about respondent?
Response, sir.
What is the offense?
And her offense is 409, 409,
Huh.
420 month. It was a business transaction between the two parties.
In serial number 4, petitioner is accused number?
Accused number 1, 2, and 3 month.
1, 2, 3 in serial number 4.
4.
In this petition,
Same, my lord. It's between the same party.
there are two complaints.
Lord,
Mega
in
weeks
this
are-
also, accused number 2, accused number 1, Ibrera.
Whether there are 2 FIRs,
Yes, my lord, there are 2
2 FIRs.
2
Crime number?
Crime number 14 of 21 is serial number
4.
serial number 25, my lord.
Then in serial number 4,
Password.
ಏನ ಕೇಳಿದ ಕೂಡಲೇ ಪಾಸ್ ಓವರ್.
First one, it's 220 of 20.
Where is the respondent? Complainant is same in both the cases.
Same.
How many respondents are there?
There are
In one case, 4 respondents. In one case, one respondent.
one Deepak MG is the
There are 4 respondents
my lord, it
There
was
are
the
the directors.
company, directors of a company.
represented by directors.
They have filed the check case also. As per the compromise, they are required to withdraw the check also. I have enclosed a copy of the memorandum of settlement also. Now they are handing over the demand draft of.
What about
20
petitioners 1 and 2?
Lord, petitioner
Is petitioner number?
petitioner number 2 is present.
1 is not.
One,
present.
his father-in-law passed away, so he's in Srirangpatna today.
What about respondents 2 to 5?
2 to 5.
All are present?
Yes, sir.
Nodi, Deepak, Vinod. Who is Deepak? Vinod? Nadeem? Ramesh? And your Balaji?
He's bad.
Petition number 2 and respondent number 2 to 5 are present. They are identified by their respective counsels. They have filed the memo. They have better. Respondent number 2 to 5 have filed a memo stating no objection to allow the criminal petitioner to quash the criminal proceedings initiated against the petitioners. There are only 2 accused.
There are only 2. accused.
Only 2.
Yes.
They have produced a memorandum of settlement dated 13th September 2024. And submit that. As per the memorandum of settlement, the parties have amicably settled their disputes. On inquiry, respondent number 2 to 5 submit that they have settled the dispute amicably and they have no objection to allow the petition. So petition number 2 submits that petition number 1 was unable to attend the court as there is bereavement in his family and raised petition.
2 and 4. 2 and 4.
look into the memo filed by respondent number 2 to 5, along with the memorandum of settlement dated 13th September 2024. I am satisfied that the dispute between the parties is amicably settled. Hence, the petition is liable to be allowed. Accordingly, petition is allowed. Criminal proceedings in so and so is quashed. Secondly, same parties.
Same parties. Idral only
Petition
one
number two.
respondent.
Only one respondent.
One respondent.
Petition number 2 is two and respondent number 2 are present. Petition number 2, they are identified by the respective counsel. Petition number 2 submits that petition number 1 could not appear before the court as there is bereavement in his family. Both the respondent number 2 filed a memo which reads as under allu extractment. This is under. The memo is enclosed with a memorandum of settlement dated 13th September 2024. Petition number 2 and respondent number 2 admit the terms of settlement and admit these terms of settlement. Respondent number 2 has no objection. Adella haki. Petition allowed.
That one submission.
They have to sign the order.
Yes. One submission. Criminal petition 5468, my lord. I filed the wakalat for respondent number 2 and 5, my lord. The wakalat, I will present the wakalat for respondent number 3 and 4 also.
File it.
Please, I will file it.
File it. Only your name?
Nityanand Naik.
Shri Learned Counsel Shri Nityanand Naik submits that he has filed wakalat even for respondent number
3 and 4.
What about 5?
3, all the 4 respondents I have filed.
For all
For
the
2 I
respondents.
have filed. For other 2 I am filing right now.
No, there are respondent number 2 to 5, no?
Please, my lord.
Ah,
For respondent
we are
number
having
2,
wakalat
2 and
only-
5 already filed, my lord.
2 and 5.
I am
already.
filing for 3 and 4 now.
As per cause list, it is only for respondent number 2. Verify that.
No, no, that is in criminal petition number 5468, my lord.
Huh?
546. In serial number 4, my lord. 546.
4. Ali ideyalla.
Yes.
Okay. 3 and 4 you file it.
Yes. I am
Yes,
presenting right.
He has filed wakalat for respondent number 3 and 4. Office to take note of the same. Yes. Both the petitions allowed.
Presentation.
Yes.
Serial number
They have
2.
to sign, respondent.
Yes.
The petition number 2 has to sign and you have to identify them. Next.
Number 26, Rajesh Sheshadri.
Respondent in this case, Lordship. Petition, kindly pass over the
Pass over
seniors and of another court.
after vacation.
My lord, kindly pass
For
over.
the petitioner prays for time. This time, after vacation.
Serial number 27, Arjan. 28, Venkatesh Soma Reddy, Shankarappa, BP Party.
May it please, my lord. Appearing for the Learned Counsel for the petition, my lord. There is
The
a
respondent For the respondent number 2, your lordship, requesting for a short accommodation, your lordship.
Lord,
senior-
learned friend has come now, just now, my lord, so Mr. Patil is there. My lord, this is covered by section 17, capital A, the Prevention of Corruption Act, my lord. Directly FIR is ordered to be registered by the learned special judge. The petitioners before my lord are police officers. Allegation against them is that they did not conduct the investigation properly. That is the investigation. That is the allegation.
My lords, the issue at hand is the complaint is these police officers gave the complainant recorder in terms of twice, and they apparently even recorded it, but they never registered an FIR. And
What
that
was
is why.
recorded?
My lord,
No, my
it
lord.
was the demand and acceptance. Demand and acceptance. Because as per the trap formalities. Now, based on that, my lords, the complainant was constrained to go under 200 CRPC to the jurisdictional court. There, my lords, he has very rightly arraigned not just the first 2 accused as such, the revenue officials who were making demands. He has even arraigned these police officers as 3 and 4.
For not registering the.
For not registering the FIR and being in hand in glove for one or the other reason. This is all an issue in investigation to get into. Now 17A here, my lords, I don't know how 17A fits in. Nevertheless, my lords, they want to make a submission that 17A is their plank of submission.
Please, now.
My counter also is ready, my lords. Fine.
Please, may I make
Yes.
my submissions, my lords? My learned friend is justifying the registration of the FIR against the police official in this present case. My respectful submission is this: the complaint allegations are that complainant says, my lord, he lodged certain information with the police for trap. Kindly go to the complaint, my lord, please. Page 11, my lord.
You are referring to the private complaint.
Private complaint, my lords. Page 11. Now, my lord, number one district tribal officer, my lord, is accused. Page 11. Number 2, manager of district tribal welfare office. So and so. Number 3 is the petitioner before, my lord. 3, DYSP of ACB. Number 4 is inspector of ACB. Number 5 is police constable. Number 6 is another police constable not named. The entire gist of the complaint is this, my lord. He says, I went and said, please ride. I gave the information, etc. And tape record was also given. And that they did not conduct a successful raid. Entire gist of the allegation is this. I will not go to the other merits, my lords. Now he says, therefore, I am not.
Before conducting the raid, whether there was an FIR.
No, my lords. Now he says FIR is not registered and therefore they are.
That is the allegation, sir.
That is the allegation. That is the allegation. They did not register the FIR. Now the question is. Pardon me, my lords.
It is not the question of riding. You have not registered the FIR.
My lord, as far as registration of the FIR is concerned, my respectful submission, it is the duty of the police officer, my lord, to decide whether there are proper materials, credible materials to register FIR and proceed ahead with the matter.
Have given such endorsement.
No, my lord, as far as prevention of corruption, your lordship may kindly see.
Information is not proper. It is
Prevention
not
of
format. It does
that's
not
also.
disclose any cognizable offense.
Please. Now, my lords, now we are at this stage, my lords, as far as the order of the learned magistrate, the special judge is concerned, may I beg to direct to take the order that has been passed.
Here the respondent number 3 to 6 or ACB or either Lokayukta Agbekkalla.
Then it was ACB, my lords, as on the day of the incident.
Yes.
Currently it is Lokayukta.
Lokayukta. No amendment is necessary here.
There is amendment is necessary, my lords, at this juncture. And also my counter is ready.
Now they are the employees under Lokayukta.
No, my lord, I will submit amendment was permitted, my lords, by this honorable court.
Already permitted.
Amendment. I feel respectfully submit it was.
Amendment was carried out, my lords.
When?
At the last date of hearing itself.
Original
amended cost title. Amended cost title is not given to us.
Amendment is not given. Petition ಯಾವುದು? ಯಾವುದು? ಇದೆ. ಇದರಲ್ಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಯಾರಿದ್ದಾರೆ? ಅಷ್ಟೇ. ಅಲ್ಲಲ್ಲ ಈಗ ಹೇಳೋದು ಇಲ್ಲಿ ಈ ACB ಇದನ್ನ ಮಾಡೋದು ಬೇಡ. ಅದಕ್ಕೆ ಕೇಳಿಲ್ಲ. There are 2 petitioners.
Please.
Three petitioners, my lords. 3 petitioners.
3 petitioners.
Oh, they are accused number 3, 4, and 5.
2 are officers of ACB.
All are officers of ACB. Both, all the 3.
The petition. Cost title.
Cost title, at that time they were ACB officers. At that time they were ACB, my lords. As far as petitioners are concerned, my lord. Now they are no more in. Some of them are not in ACB, my lord.
No, I'm asking whether any amendment is necessary or not.
No, my lord, it was at that stage, my lords. They were arrayed as DSPs of ASB, ASB at that stage, my lords.
Yes.
At the registration of the FIR, my lord.
Yes.
Now, my lord, if we have satisfied, my lord, about the amendment, etc., your lord may kindly permit me to proceed. Please, my lord. Now,
1 minute.
please.
Yes, proceed.
Grateful, my lord. My lord, on page number 11 itself, there is an endorsement on the same day when the complaint is filed, my lords, by the Honorable Special Judge, my lords, that typed copy is at page 38. Complaint is presented by the counsel for complainant. Complaint is present, heard the counsel, peruse the complaint, and documents produced. Cognizance for the offence under section 7(2) AC 13(15) of Prevention of Corruption Act, read with 120B of IPC. Register the case, refer this matter under section 153 to ESP ACB Chikballapur for investigation. My lord, learned special judge took cognizance of the offences as per this order.
Yes.
Has taken cognizance and thereafter was referred.
Cognizance was taken only for the purpose of referring it to for investigation.
Now, my lord, the two aspects, my lords. Now, for what purpose and how it is taken is reflected in the order, my lords. That's true, my lords. As far as referring the complaint as such is concerned, cognizance should not be taken. Once cognizance taken, section 200 CRPC of the old, my lords, so it comes into play. Now here, learned special judge has taken cognizance and thereafter was referred, which is totally impermissible in law. He cannot take cognizance. The Honorable Court cannot take cognizance. Once taken cognizance, 153 CRP is not applicable.
No, at the most, it may amount to procedural irregularity.
Please.
Now, my lord,
Vitiate the proceedings.
I humbly beg to submit, my lords. Once the cognizance is taken, there is the matter which he has to be decided.
Show me the position of law, whether it vitiates the further proceedings. It may be a procedural irregularity.
Lords, for that matter, the only cognizance part may be set aside. It may be sent back for investigation. Let them complete the investigation and file a proper report. Because, my lords, per se from the complaint amendment,
See, it is the settled position of law that the cognizance, even if the cognizance is taken twice, it can be ignored.
Taken twice can be ignored, my lords. Here,
Initially once taken as the case in hand.
Please.
Later, when the charge sheet final report is filed, again cognizance is taken.
That
Even
in
in
that
that
case,
case, the apex court has clearly held.
that's true. But my lords, whether the learned magistrate can, magistrate or the honorable special judge can take cognizance and thereafter refer the complaint to the police for investigation. My lord, what my learned friend is suggesting that delete cognizance and then justify this order. This has to emanate from the learned special judge. We don't know what you do. You would even.
Please show the position of law, exact position of law. According to me, I think it is only a procedural irregularity, which will not go to the root of the matter. It will not vitiate the further proceedings.
Does not warrant the interference of this court.
To differ with that, please place on record any decision or.
We will, my lords. On that point, we will. And let my learned friend also serve the copy. Now he says my lord is ready with the objections. Let it also served, my lords. I will place those decisions, my lords. That
Counsel for respondent submits that the counter statement is ready and he will file in the office. He will file in the office?
Yes. I'll file it in the registry.
Registry. List down. Yes.
interim order may be extended, my lords.
Interim order, they extend.
Next week, my lords.
After vacation?
As
May
my-
not be possible, sir. Very few working days are available.
Please, my lord.
Oblige.
Yes.
Grateful, my lords.
29. Manapasana
Submission, my lord. Till about 26, my lord. Interim order may kindly be extended, my lord.
26 idre madi. If it is in force today, it will be extended. Otherwise, it will not. Yes, 29.
Serial number 29.
Absent, no representation. This one. Next.
History. Serial number 1. Non-compliance of office objection for first time. Serial number 1. M. Charas Chandra.
For the petitioner, my lords. My lords, initially, the petitioner filed 438, my lords. During the pendency of this petition, my lords, the accused is arrested. Subsequently filed 439, my lords. Counsel on record, my lords, now for withdrawal in that application, my lords.
Why maintainability?
Two petitions pending before this honorable court, my lords.
Which is the other petition?
My lords, the 438 application, criminal petition number 4769 of 2024.
Ah.
That in that
Still
application,
pending?
my lords,
That is still pending?
still pending, my lords.
Then counsel for the petitioner submits that criminal petition number 4769 of 2024 is connected with the present petition. Office is directed to list both the cases together. It will be listed and thereafter you file the application.
Please, my lords, issue notice to R2, my lords. 376 is there, my lords.
In the meantime, HCGP to take notice for respondent number 2. Issue notice to so and so. ಅದೇ ಎರಡು ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಇದು ಮಾಡ್ಲಿ.
On date may be given, my lords.
Yes. ಅದೇ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಲ್ಲ ಫಸ್ಟಿಗೆ ಇದು ಇದಾಗ್ಲಿ ಅದು ಫಸ್ಟಿಗೆ ಬರ್ಲಿ.
On date may be given.
ಡೇಟ್ ಕೊಡ್ತಾರೆ ಸರ್.
Serial number 2, Syed Khalil Pasha.
Absent no representation. Office objections are not yet complied with. List finally as elections after vacation.
Orders first time matter, serial number 3 to 6.
HCGP to take notice for respondent. Yaar on audit private idre.
My lord, serial number 6. My lord, I may be permitted by the request to serve the copy to the counsel for the respondent number 2.
Who is representing respondent number 2?
My lord, she had personally approached this court for cancellation of bail. So hence, the notice as ordered by the court.
Pending.
No, my lord, that has been cancelled.
Then whether the counsel will accept notice?
My lord, but
I have
he
my
has been
own-
arrested since the cancellation of bail.
Maybe, sir. Suppose you are the counsel representing respondent number 2. Sought for cancellation of bail. That is already disposed of. And tomorrow your friend comes and asks you to take notice. Whether you will take it?
Got it, my lord.
What will be the what will generally be the response of the counsel? Is it not?
Yes, my lord.
Then take out notice. Let it go.
My lord, pray to list this matter, a date may be given before vacation, my lord.
Before vacation. Serve ಆಗ್ಬೇಕಲ್ಲ sir. If
My
you
lord,
can
he's
serve
been-
it, I will list it. I have absolutely no objection. But service is a difficult task.
Yes, my lord.
Issue notice to respondent number 2. Then counsel for the petitioner seeks permission to serve the copy of the notice to respondent number 2 on the counsel who was representing respondent number 2 in a different proceedings. He is permitted to do so apart from serving the notice through court. In
Much obliged.
addition, you can serve.
Much obliged.
Yes.
For order, serial number 7, Sameer SN.
Are you ready? 3 5 hours are ready. Petitioner.
I appear on behalf of the petitioner, my lord.
Yes.
My lord, accused number, bail petition for accused number 12 and 15, my lord. Lord,
Petitioner, sir.
accused number 12 and 15.
In all, how many accused are there?
My lord, totally almost 20, my lord. 20 accused.
Charge sheet is filed.
Charge sheet is filed, madam.
For which offense?
My lord, for offenses, the section 120B, 363, 395, 397, 114, 75.
When they were arrested?
My lord, they were arrested, my lord, on 9/12. It's 9/12.
Huh?
9/12.
Which year?
9/12/2023, my lord. Lord, allegations against them is at page 78, my lord. Page 78, in page 52, my lord, of the charge sheet. 52, that the date of occurrence is on 8/12/2023. 8/12/2023. So accused number 12 and 15, they were not there on the scene of the crime on that day, my lord. Similarly placed accused, my lord. Accused number 14, he is already
What
on
is the
bail, my-
allegation as per charge sheet?
My lord, as per charge sheet, allegation is that accused number 12's vehicle was used. Accused number 12's vehicle was used, and if I can read, my lord, at page 78, ನಂತರ ಅದೇ ದಿನಾಂಕ 8/12/2023 ರಾತ್ರಿ ಸಮಯ ಸುಮಾರು 8:15 ಗಂಟೆಯವರೆಗೆ.
Where you are reading page number?
My lord, page number 78, my lord.
No, charge sheet column number 17 is at.
Column number 17, my lord, may kindly come to in page 52 of the charge sheet, my lord. Right hand bottom side, the page number is indicated.
Till then, it does not refer to this petitioners.
No, it doesn't refer to this petitioners, my lord. And my lord, similarly, my lord, accused number 14 is granted bail by this honorable court, my lord.
Where is reference to accused number 12 and 15?
My lord, that is that in page 52, my lord, that second para. ನಂತರ ಅದೇ ದಿನ 8/12/2023 ರಾತ್ರಿ ಸಮಯ ಸುಮಾರು 8:15 ಗಂಟೆಯವರೆಗೆ ಎರಡನೇ ಆರೋಪಿ ಮೈಸೂರಿನಲ್ಲಿರುವ 3 ಮತ್ತು 5ನೇ ಆರೋಪಿಗಳಿಗೆ ಈ ದಿನ ಮಿನಿ ಕೂಪರ್ ಕಾರು ಮೈಸೂರಿಗೆ ಬಂದಿದೆ, ಎಲ್ಲರೂ ರೆಡಿ ಆಗಿರಿ ಎಂದು ಹೇಳಿದ್ದು, ಈ ವಿಚಾರವನ್ನು 3ನೇ ಆರೋಪಿ 1ನೇ ಆರೋಪಿಗೆ ತಿಳಿಸಿದ್ದು, 1ನೇ ಆರೋಪಿ ಹೇಳಿದಂತೆ ಉಳಿದ ಆರೋಪಿಗಳು ಕಾರು ಮತ್ತು ಪಿಕಪ್ ಜೀಪಿನಲ್ಲಿ ತಿತಿಮತಿ ಟೌನ್ ನಿಂದ ಸ್ವಲ್ಪ ಮುಂದಕ್ಕೆ ಗೋಣಿಕೊಪ್ಪ ಕಡೆಗೆ ಖಾಲಿ ಜಾಗದಲ್ಲಿ ಕಾರು ನಿಲ್ಲಿಸಿ ಕಾಯುತ್ತಿರುವಾಗ ತಡರಾತ್ರಿ ಸಮಯ ಸುಮಾರು 1:30 ಗಂಟೆಗೆ ಮಿನಿ ಕೂಪರ್ ಕಾರು ಬಂದಿದ್ದು, ಆರೋಪಿಗಳು ಮಿನಿ ಕೂಪರ್ ಕಾರನ್ನು ಫಾಲೋ ಮಾಡಿದ್ದು, ಆರೋಪಿಗಳು ಪ್ಲಾನ್ ಮಾಡಿದಂತೆ ರಸ್ತೆ ಬದಿಯಲ್ಲಿ ಕೆಟ್ಟು ನಿಂತಿದ್ದ ಸಿಮೆಂಟ್ ಲಾರಿಯ ಬಳಿ ತಲುಪುವಾಗೆ ಅವರ ಮುಂದೆ ಒಂದು ಲೋಡ್ ಆದ ಒಂದು ಟಿಪ್ಪರ್ ವಾಹನ ಹೋಗಿ ರಸ್ತೆ ಜಾಮ್ ಆಗಿದ್ದು, ಕೂಡಲೇ ಆರೋಪಿಗಳು ಮುಂದೆ ಇದ್ದ ಮಿನಿ ಕೂಪರ್ ಕಾರನ್ನು ಟಿಪ್ಪರ್ನ ಹಿಂದೆ ಸೈಡ್ಗೆ ಅಡ್ಡ ಹಾಕಿ ನೋಡಿದಾಗ ಟಿಪ್ಪರ್ ಮುಂದೆ ಪಿಕಪ್ ವಾಹನವಿದ್ದು, ಪಿಕಪ್ ವಾಹನವು ರಸ್ತೆಗೆ ಅಡ್ಡಲಾಗಿ ಬ್ಲಾಕ್ ಮಾಡಿ ನಿಂತಿದ್ದು, ಆಗ ಸಮಯ ಸುಮಾರು 2 ಗಂಟೆ ಆಗಿದ್ದು, 7ನೇ ಆರೋಪಿ ಚಲಿಸುತ್ತಿದ್ದ ಅರ್ಟಿಗಾ ಕಾರಿನಿಂದ 18, 19 ಮತ್ತು 20ನೇ ಆರೋಪಿಗಳು ಕೂಡಲೇ ಇಳಿದು ಟಿಪ್ಪರ್ ವಾಹನದವನಿಗೆ ಬೈದು ಗಾಡಿ ತೆಗೆಯಲು ಹೇಳಿದ್ದು, ಆತನು ಕೂಡಲೇ ಟಿಪ್ಪರ್ ವಾಹನವನ್ನು ಮೂವ್ ಮಾಡಿದ್ದು, ಅರ್ಟಿಗಾ ಕಾರಿನಿಂದ ಇಳಿದ 20ನೇ ಆರೋಪಿ ಮಿನಿ ಕೂಪರ್ ಕಾರಿನ ಮುಂದಿನ ಎಡಭಾಗವನ್ನು ಗಾಜನ್ನು ಆತನ ಕೈಯಲ್ಲಿದ್ದ ಒಂದು ಕಬ್ಬಿಣದ ಸುತ್ತಿಗೆಯಿಂದ ಒಡೆದು ಹಾಕಿದ್ದ. ನಂತರ 18ನೇ ಆರೋಪಿಯು ಆತನ ಕೈಯಲ್ಲಿದ್ದ ಪಿಸ್ತೂಲನ್ನು ತೋರಿಸಿ ಕಾರಿನ ಚಾಲಕ ಸಾಕ್ಷಿ ಒಂದರವರನ್ನು ಹೊರಗಡೆ ಇಳಿಸಿ ಆತನ ತಲೆಭಾಗಕ್ಕೆ ಪವರ್ ಮಾಡಿ ಏಮ್ ಮಾಡಿ ಎಳೆದುಕೊಂಡು ಬಂದಿದ್ದು, ಅಷ್ಟರಲ್ಲಿ 8ನೇ ಆರೋಪಿಯು ಸಾಕ್ಷಿ ಒಂದರ ಕಾಲಿಗೆ ಮತ್ತು ಕೈಗಳಿಗೆ ಸುತ್ತಿಗೆಯಿಂದ ಹೊಡೆದಿದ್ದು, 19ನೇ ಆರೋಪಿಯು ಕಾರಿನಲ್ಲಿದ್ದ ಸಾಕ್ಷಿ 2ರನ್ನು ಕೈಯಿಂದ ಹೊಡೆದು ಎಳೆದುಕೊಂಡು ಬಂದು ಅವರ ಪೈಕಿ ಸಾಕ್ಷಿ ಒಂದರವರನ್ನು ಅರ್ಟಿಗಾ ಕಾರಿಗೆ ಸಾಕ್ಷಿ ಮತ್ತು ಇಲ್ಲ ರೆಫರೆನ್ಸ್ ಅಂದ್ರೆ ಅವರು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ದಾರೆ ಮೀಟಿಂಗ್ಸ್ ಅಲ್ಲಿ ಅಂತ, ಕಾನ್ಸ್ಪಿರಸಿಯಲ್ಲಿ ಇದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಎಲ್ಲಿದೆ ಸರ್ ಎಲಿಗೇಷನ್ಸ್?
Allegations, my lord, at the previous page, my 51, my lord.
ಫಸ್ಟ್ ನೀವು ನೋಡ್ಕೊಳ್ಳಿ, ಆಮೇಲೆ ಹೇಳಿ.
51
ಎಲ್ಲದನ್ನು ಓದ್ತಾ
ಇಲ್ಲ 51 ಅಲ್ಲಿ ಅಲಿಗೇಷನ್ಸ್ ಇಷ್ಟಿದೆ. ಪೇಜ್ ನಂಬರ್ 51 ಅಲ್ಲಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಆರೋಪಿ ಹೇಳಿದ ವಿಚಾರವನ್ನು ಹೇಳಿದ್ದು, ವಿರಾಜಪೇಟೆಗೆ ಹೋಗಬೇಕು. ಅಲ್ಲಿ ಕೆಳಗೆ 5th ಲೈನ್ ಅಲ್ಲಿ ಆರೋಪಿಯು ತನ್ನ ಸಹಚರರಾದ 18ರಿಂದ 15ವರೆಗಿನ ಆರೋಪಿಗಳನ್ನು ಮತ್ತು 18ನೇ ಆರೋಪಿಯು KA-12 MB 2462 ಬಿಳಿ ಬಣ್ಣದ ಸ್ವಿಫ್ಟ್ ಕಾರು ಮತ್ತು 14ನೇ ಆರೋಪಿಯು KA-13 B79 ಪಿಕಪ್ ಜೀಪ್ಗಳನ್ನು ರೆಡಿ ಮಾಡಿ ಈ ವಿಚಾರವನ್ನು 1ನೇ ಆರೋಪಿ 6ನೇ ಆರೋಪಿ ಈಗಾಗಲೇ ಕೊಲೆ ಮತ್ತು ಕೊಲೆಗೆ ಅಷ್ಟೇ ಇರೋದು ಅಲಿಗೇಷನ್ಸ್. 12 and 15 one vehicle. That is on the previous days, my lord. That is on 4/12 meeting ಮಾಡ್ತಾರೆ. 4/12 ಮೀಟಿಂಗ್ ಮಾಡಿದಾಗ ಅವರು ಕಾರನ್ನು ಯೂಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
What is the role played by them in the commission of the offense?
My lord, their role is not mentioned in that para, my lord. The para that I already read, my lord. ಅದ್ರೊಳಗೆ
and my lord, they have arranged for the cars.
ಅರೇಂಜ್ ಫಾರ್ ದ ಕಾರ್ಸ್ ಅಂತ ಅಷ್ಟೇ. ಅಲ್ಲ, ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 12 ಹ್ಯಾಸ್ ಅರೇಂಜ್ ಫಾರ್ ದ ಕಾರ್ ಅಂತ 15 ಬಗ್ಗೆ ಏನಿಲ್ಲ. ದೇ ಹ್ಯಾವ್ ಜಸ್ಟ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಅಂತಾರೆ. ಆನ್ 1,50,000 ಅವ್ರ ಹತ್ರ ರಿಕವರ್ ಮಾಡ್ತಾರೆ. ಕಾರು, ಮೊಬೈಲ್ ಮತ್ತೆ ಮನಿ ರಿಕವರ್ ಮಾಡ್ತಾರೆ.
Which car was seized?
ಸ್ವಿಫ್ಟ್ ಇದೆ. ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 12 ಕೈಯಲ್ಲಿ.
And what is the amount?
1.5 lakhs. 1.5 lakhs. ಮತ್ತೊಂದು ಮೊಬೈಲ್ ಫೋನ್ ಸೀಸ್ ಮಾಡ್ತಾರೆ. ಫ್ರಮ್ ಅಕ್ಯೂಸ್ ನಂಬರ್ 12. ಇಲ್ಲ ಇವ್ರ ಕೈಯಲ್ಲಿ ಕಾರ್ ಸೀಸ್ ಮಾಡಲ್ಲ. ಅಕ್ಯೂಸ್ ನಂಬರ್ 15 ಇಂದ ಏನು ಕಾರ್ ಇಲ್ಲ.
And what is seized from accused number 15?
15 ಅಲ್ಲಿ ಮೊಬೈಲ್ ಮತ್ತೆ ಅಮೌಂಟ್ 1,50,000 ಇರೋದು.
1,50,000.
ಹೌದು.
What was the allegation against accused number 14?
ಅಲ್ಲಿ 14 ಸೇಮ್ ಎಲಿಗೇಷನ್.
Same allegation.
ಸೇಮ್ ಇದೆ. ಐ ಆಮ್ ಪ್ರೊಡ್ಯೂಸಿಂಗ್ ದಿ ಪ್ಯಾರಿಟಿ ಮೇಡಮ್.
ಇಲ್ಲಿ connected matter ಇದೆ. Connected ಇದೆ. Para number 4. Petitioners are arraigned as accused number 12 and 15. They were apprehended on 9/12/2023. Since then, they are in judicial custody. ಅದು ಮುಂದಿಂದ ಇದನ್ನ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Pencil ಅಲ್ಲಿ mark ಮಾಡಿದ್ದೀನಿ, ಅದನ್ನ change ಮಾಡಿ. The allegations made against these petitioners are that they have arranged for the cars, public vehicles, for commission of the offense. And during investigation, the Swift Desire car, cash of rupees 1,50,000 and the mobile handset were recovered at the instance of accused number 12, and cash of rupees 1,50,000 and the mobile handset were recovered at the instance of accused number 15. ಅದ್ರ ಮುಂದಿಂದೆಲ್ಲ ಸೇಮ್. ಪೇಜ್ ನಂಬರ್ 4 ನಲ್ಲಿ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಪಾರ ಹಾಕಿ. Admittedly, accused number 14 against whom similar allegations are made is already granted bail in the criminal petition number 4230 of 2024 with a order dated 28th May 2024. Since the allegations made against accused number 14 and these petitioners are one and are similar, I am of the opinion that the petitioners are entitled for the benefit of parity, and they are to be enlarged on bail subject to conditions which will take care of so and so, so and so. Yes. Allowed subject to conditions.
Serial number 8, Chetan S.
Nine. Next.
9, Padmavati N.
Last time I admit the matter that not CW6 alone is the eyewitness. Proclamation was ordered. Proclamation was duly executed and now he's dropped.
Who is the petitioner?
Petitioner is accused.
Sole accused.
Sole accused.
What is the offense?
Offense is 302, my lord, unknown persons.
When he was arrested?
Arrested on 12/6/2022.
22.
13/6, sorry. 13/6/22 was arrested.
Earlier you approached this court?
Yes, my lord.
Early the order.
And produce ಮಾಡಿದ last time.
Last time ಏನು ಮಾಡಿದ್ದಾರೆ?
ವಾಪಸ್ ಕೊಟ್ರು ನಂಗೆ.
ಕೊಡಿ.
Madam, order sheet. Last time ಕೇಳಿದ್ದು. Order sheet.
CW6 is the eyewitness.
Sole eyewitness. Not it. Page
Is already examined.
ಇಲ್ಲ ಯಾರು is not proclamation is ordered. That's duly served.
ಎಲ್ಲಿದೆ ಅದು?
Page number 32, madam. 27, sorry. Page 27 in the order sheet. Proclamation was issued on returnable by 23/8/2024. Issue proclamation against TW6, 11 and 12.
Yes.
And on 23/8/2024, 23/8/2024, my lord. Proclamation 28, page number 28. Proclamation issued against TW6 is duly served. Perused this report. Same is accepted. The evidence of TW6 is dropped.
Yes, what do you say?
There is a CCTV footage, which has clearly captured.
No, that you can prove from placing the materials on record. Mainly the earlier similar petition came to be dismissed to safeguard the interest of CW6, being the sole eyewitness. Now that apprehension is not there. How many witnesses are there in all?
There are 31 witnesses.
31.
Sorry, 37 witnesses.
Now how many witnesses are examined?
9 witnesses are examined. 9 witnesses.
Now remaining witnesses are
Sorry,
official witnesses.
11 witnesses. 11 witnesses are examined.
Remaining are official witnesses.
ಇಲ್ಲ official witnesses, doctors, punch witnesses.
ಏನು ಪಂಚನಾಮ?
Mother witnesses are there, doctors are there, IOs, apprehension.
Petitioner, being the sole accused, is seeking grant of bail. He was apprehended on 13/6/2022. Since then, he is in judicial custody.
Initially, 325 was registered. Initially, case was registered under section 325.
Initially, the FIR came to be registered against the petitioner for the offense under section
325.
25 of IPC.
After his death, converted after nearly 15 days.
302 of IPC was invoked. It is the contention of the prosecution that after investigation, charge sheet came to be filed for the said offense. It is the contention of the prosecution that the petitioner had parked his vehicle at a wrong place when the same was objected by the deceased, being the security guard, The petitioner assaulted him on his head and other parts of the body and also fisted. Later, the injured was taken to Apurva Hospital at Yelahanka and thereafter shifted to Victoria Hospital. Despite taking treatment, the injured succumbed to the injuries on 18/6/2022. As per PM report, he sustained as many as 7 injuries and death was due to head injury sustained. The cause of death could be attributable to the overt of the petitioner. Next paragraph. The petitioner had approached this court by filing criminal petition number 12549 of 2022, seeking grant of bail. The said petition was came to be dismissed with a order dated 9th February 2023. It was noticed that CW6 is the sole eyewitness to the incident. And the investigating officer has secured the CCTV footage of the place of incident. Under such circumstances, it was held that the petitioner is not entitled for grant of bail. Next paragraph. Now the learned counsel for the petitioner has produced additional documents, including the order sheet of the trial court in SC 1878 of 2022. As per the order sheet dated 27/7/2024, proclamation was issued against CW6 along with CW11 and 12. As per order sheet dated 22/8/2024, the proclamation issued against CW6 was duly served and the report of the police was accepted and CW6 was dropped from examining before the trial court. Therefore, it is clear that the sole eyewitness is dropped by the prosecution from examining before the trial court. Now the prosecution is placing reliance on the circumstantial evidence, including CCTV footage, to prove the guilt of the accused. But it is not the contention of the prosecution that the detention of the petitioner in custody is required for any purpose. Admittedly, the trial has begun and as many as 11 witnesses are to be examined. In such circumstances, I am of the opinion that the petitioner may be enlarged on bail subject to conditions which will take care of so. Petition is allowed.
Serial number 10, Pawan Chandra Shetty.
(439). Earlier, your lordship has successive bail petition, my lord.
Petitioner is accused number
4, my lord. Arrested on 21/5/2024.
What are the offense?
Offense under section 143, 144, 147, 506, 324, 307, and 149 of IPC.
Now, how many accused?
5 accused, my lord. Arrested on 21/5/2024. Charge sheet filed on 30th/6/2024. My lord was first dismissed on dated 4th July 2024.
Earlier order?
Earlier order, yes, my lord. That is, all accused approached, my lord, before this honorable court. And this honorable court pleased to observe that investigation is still pending and nature of and he has not surrendered before the police officer. And my lord, interrogation is required. Accordingly, my lord has pleased to rejected the my lord bail petition for all 5, my lord.
Order dated?
Order dated 4th July 2024, my lord.
That is in respect of accused number 1,
1,
2, 3, and 5.
1, 2, all 5, my lord. I'm having copy, my lord. Shall I place, my lord?
No, against accused number 4 is dismissed as withdrawn.
That is yes, my lord. Yes. One more accused. Arrested on 21st/5/2024, my lord. BA graduate, my lord, from Aluvas, Mudabidre, my lord. Material before this honorable court. At column number 17 of the charge sheet, my lord, wherein state
Sought for anticipatory bail
before this honorable court. Yes, my lord, it was dismissed.
earlier.
Now it is a regular bail, my lord. Arrested on 21st/5/2024, my lord. Charge sheet filed on 30th/6/2024, my lord. The specific allegation which has been recorded by the respondent police at Megana Hospital, Shumoga, by the, my lord, complainant Pradeep T.N., and wherein he has stated, my lord, at paragraph number 17 of the charge sheet, my lord. Your lordship may kindly peruse, my lord.
1 minute.
Running page number 9 of the charge sheet.
Where is the charge sheet, column number 17?
17 is speaks about, my lord, one weapon, my lord.
Where is page number?
Page number 9, running page number 9. ಅದರಲ್ಲಿ 4ನೇ ಲೈನ್ ಆದ್ಮೇಲೆ ಸ್ವಾಮಿ, ಸಾಕ್ಷಿ ಒಂದರವರನ್ನು ಕೆಳಗೆ ಬಿಡಿಸಿ ಒಂದರವರನ್ನು ಕಾಲನ್ನು ಎತ್ತಿಡಿದು ಅದೇ ಸಮಯಕ್ಕೆ A1 ಮತ್ತು A2 ಅವರು ತನ್ನ ಕೈಯಲ್ಲಿದ್ದ ದೊಣ್ಣೆಯನ್ನು ನಿನ್ನ ಸಾಯಿಸದೆ ಬಿಡುವುದಿಲ್ಲ. A1 and A2, my lord. ಎಂದು ಸಾಕ್ಷಿ ಒಂದರವರು ಎಡಗಾಲಿಗೆ ಹೊಡೆದು ತೀವ್ರ ತರದ ಗಾಯವನ್ನು ಉಂಟು ಮಾಡಿದ್ದು. ಆಮೇಲೆ ನಾವು ಕೈಗೆ ಹೊಡೆದಿದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. 3 ಮತ್ತೆ 4 ಸದರಿ ದೊಣ್ಣೆಯನ್ನು ಕಸಿದುಕೊಂಡು ಅದೇ ದೊಣ್ಣೆಯಿಂದ ಆರೋಪಿ ಅನ್ನು ಸಾಯಿಸದೆ ಬಿಡುವುದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದಾರೆ. My lord, the nature of the weapon, my lord, it is my lord, material placed, my lord. Running page number 41, my lord. Areka tree stick, my lord. One weapon used, my lord, at a time 4 person, according to the prosecution, my lord. Or the nature of weapon, my lord, Areka tree stick, as per report given by the, my lord, doctor. Running page number 41, my lord. Total 20 witnesses are there, my lord. My participation is, my lord, I have involved, my lord, and made a threat of to kill him.
Where is the wound certificate?
Wound certificate, running page number 30.
How many injured? Only one.
Two. Running page number 31, my lord. ಅಲ್ಲಿ Karnataka medical, my lord.
31 is charge sheet.
Charge sheet, yes, my lord. Wherein
Wound certificate.
ಅದೇ wound certificate 31 ನಲ್ಲಿ ಇದೆ, running page number 31 of the charge sheet. Running page number. ನಮ್ದು ಇಂಕ್ ಅಲ್ಲಿ ಹಾಕಿದೀವಿ.
Yes.
In my opinion, above said injuries, one is simple, second one is grievous in nature. Now, your lordship, ಅದಕ್ಕಿಂತ ಮೊದಲ page, my lords, sorry, that is the running page number 41, my lord.
1 minute.
Sorry.
What are the injuries?
Injuries, my lord,
Page number 31.
31, my
One
lord.
is tenderness present over lower,
Lower limb,
lower,
back.
back.
Yes, my lord.
Then second one,
According to the discharge summary, swellingness and fracture.
really the ಇದ್ರಲ್ಲಿ ಕಾಣ್ತದೆ.
ಫ್ರಾಕ್ಚರ್ ಅಂತ ಈ ತರ ಲೈನ್ ಹಾಕಿದಾರಲ್ಲ, ಈ ತರ ಲೈನ್ ಹಾಕಿದ್ರೆ ಫ್ರಾಕ್ಚರ್ ಅಂತ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಕೆಳಗಡೆ ಲೆಫ್ಟ್ ಪ್ರಾಕ್ಸಿಮಲ್ ಟಿಬಿಯಾ ಫ್ರಾಕ್ಚರ್ ಅಂತ ಬಾಟಮ್ ಅಲ್ಲಿ
ಲೆಫ್ಟ್ ಪ್ರಾಕ್ಸಿಮಲ್ ಟಿಬಿಯಾ
ಫ್ರಾಕ್ಚರ್. ಎಸ್ ಮ್ಯಾಮ್.
Okay.
Now your lordship may kindly come.
Sure.
Simple in nature.
Yes, what do you say?
The leg of the injured man, then assaulted man.
Any criminal antecedents? No. Subject to conditions.
Please, ma'am.
Petitioner being accused number 4. Petitioner being accused number 4 is seeking grant of bail. He was apprehended on 21/5/2024. Since then, he is in judicial custody. The FIR came to be registered on the basis of the statement of the injured.
Yes, my lord. Pradeep TN.
Statement of the injured was recorded while he was taking treatment in the hospital. The FIR came to registered against accused numbers 1 to 5. After investigation, charge sheet came to be filed for the aforesaid offences. As per Quashing, the specific overt act alleged against this petitioner is that he had assaulted the injured with a club and caused injuries. Similar allegations. It is alleged that accused number 1 and 2 have held the injured CW1 with his legs and assaulted him with the clubs. Accused number, the petitioner being accused number 4, criminally intimidating, assaulted CW1 on his left and right shoulder, and accused number 2, 4, and 5 together assaulted him all over his body and also on left head and all over his body. Next, the injury certificate pertaining to the injured Pradeep disclosed that he had sustained 2 injuries. Injury number 1 being tenderness present over lower back is simple in nature, whereas injury number 2, that is left proximal tibia fracture, being grievous in nature. The other injured Archit sustained 3 simple injuries. 3 simple injuries. Admittedly, the injured are already discharged from the hospital and the matter is pending for trial. The prosecution has cited how many witnesses?
20.
Huh?
20.
Cited as many as 20 witnesses to prove the guilt of the accused. Admittedly, the petitioner is not required for further investigation, nor his presence is required for any purpose except to ensure his presence before the trial court during trial. It is not the contention of the prosecution that he is having criminal antecedents Considering all these facts and circumstances, I am also feeling.
Deeply obliged.
Three passed over matter, serial number 8, Chetan S.
Counsel for the petitioner is yadu 8. Counsel for the petitioner is absent, no representation, even when the matter is passed over twice, and again called at 12:04 p.m. The order sheet dated 18/9/2024 reads as under. In spite of that, there is no representation. Petition dismissed. Like 3 ನಲ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ, 1 ನಲ್ಲಿ ಯಾವುದೂ ಇಲ್ಲ. ಆಮೇಲೆ ನೋಡೋಣ. This 2 ನಲ್ಲಿ correct. ಯಾರಿದ್ದಾರೆ? Correct.
These two passed over matter. Serial number 8, Siddharth B. Muchandi.
Amended. Amend ಮಾಡಿಲ್ಲ. Counsel for the petitioner submits that has amended the cost title and also filed amended cost title. Is to verify. ಅದು ಬೆಳಿಗ್ಗೆ ಒಂದು ಫಾಲ್ಟ್ ಹೇಳಿದ್ದೀನಿ ನಾನು ಅದರಲ್ಲಿ ಅದನ್ನು ಅರ್ಲಿಯರ್ ಇದು ನೋಡ್ಕೊಂಡು ಅದನ್ನು ಜಾಯಿನ್ ಮಾಡಿ ಲಿಸ್ಟ್ ಆನ್.
Serial number 9, Satyanarayan Chalke.
ಏನಾಗಿದೆ?
Lata S. Shetty.
ಮಾಡಿಲ್ಲ. 10.
10, Lata S. Shetty.
Filing amended cost title also.
Have you amended?
I am amending.
Counsel for the petitioner submits that he has amended the cost title and also filed amended cost title office to verify. This term. Next.
Interim order may be kindly
Interim order will be extended. Yes.
Both are mine.
Yes. If it is in force, it will be extended. ಅದು 10.1 ಎರಡರಲ್ಲೂ.
Serial number 15, Jivan J. Neralgi. Office objections are complied.
Counsel for the petitioner submits that he has complied with the office objections. Officer, ಏನಂತ ಮಾಡಿದ್ದಾರೆ? Already are look at this term. Next.
Serial number 16, K.R. Rajendra Gopal Krishna Murthy.
Sorry, I was in the quotal number 2 in 3.
You filed the application
Yes, ma'am.
for impleading.
Yes, ma'am.
Why?
Because,
How
madam,
the company is responsible?
because, madam, before the honorable trial court, madam, the trial court advocate, madam, he has not made the company as a party to the proceedings.
Why the company should be party?
Madam, according to them, madam, under section 141 of the NI Act, so it is a mandatory regarding to make the company as a party.
Issued the check.
Madam, the managing director, that is the petitioner only, on behalf of the company as.
Records ಇದೆಯಾ?
Yes, madam, they have filed it, madam.
ಬಂದಿಲ್ಲ. ಕಾಲ್ ಮಾಡಿಲ್ಲ.
They have produced the documents, madam, all exhibits.
And why the trial court dismissed the complaint?
No, madam, they have approached the sound court only on that ground that, madam, since the complainant has not made the.
You are the complainant.
Yes, madam, I am
You are the
the.
complainant.
Yes, madam. But since all the further.
Objections are filed?
Yes,
on
they
your
have filed,
complaint?
madam. They have filed the objections.
What is that objection?
Madam, their objection is, madam, it is not a curable defect. So that is the reason application cannot be entertained. That is their arguments. As your lordship is very well aware, my lord, it might be irregularity, my lord. It is not illegality, and the proceedings cannot be initiated only on the technical ground, my lord. Because, my lord, the Honorable Apex Court in so many catenav decisions has taken a view that.
Petitioner, ಯಾರು ಅವರು?
One Mr. Rajendra.
Rajendra KR. We pass over the matter.
Please, ma'am.
Accused is the managing director.
Yes, my lord.
Present accused is managing director.
Managing director. That fact they are not denied, my lord. Only the company, they are not made as a party before the honorable trial court. It is their contention. And we have specifically mentioned that represented by company only. Managing partner, that are specifically mentioned managing director of Measures Gayatri Structural and Roofing Private Limited. That he has not denied. In the cost title, we have not made the company as a party. Only on that ground, they are before this honorable court. It's a curable defect, my lord. Moreover, my lord, when there is a substantial justice and technicalities are pitted together, that the substantial justice can be upheld by this honorable court. Because, my lord, it might be a mistake if I learn trial means advocate. For that, my lord, client should not suffer, my lord. That's my humble request.
How long we can hold like that?
Right?
How long we can hold like that?
But, my lord, because
Not in one or two cases.
immediate, my lord, has come.
For the fault of the accused, the parties shall not be punished.
Because, my lord, it is purely technicality, my lord. They have filed it, and they have issued
They
notice,
filed.
and for that they have replied. And moreover, my lord, the fact is that he has entered into agreement also. For that, they have produced all the documents to show that work order has been issued. He has completed the work. For that, my lord, he has handed over this disputed check in question. He has raised the technical ground before this court.
Oh, you want to amend the cost title in the complaint before the trial court?
Only in respect of the cost.
Complaint is not before this court.
Because that is the reason, my lord, since your lordship has got the discretion under 482, my lord. But on that ground, Allah Swami, ಯಾಕೆಂತ ಹೇಳಿದ್ರೆ trial court ಅಲ್ಲಿ, since proceedings have been stayed by this honorable court, my lord, we cannot do anything. In fact, we have tried it, since the honorable trial judge has said, since honorable high court has stayed the matter, I cannot take up your application. So immediately I filed the application before this honorable court.
Have you filed any application there?
My lord, they have not taken it, my lord, because further proceedings have been stayed, my lord. That is the technicality has come. ಒಂದು ಸಣ್ಣ ಮಿಸ್ಟೇಕ್ ಇಂದ ಇಡೀ ಕಂಪ್ಲೇಂಟ್ ಸ್ಟಾಲ್ ಆಗಿ ಕೂತಿದೆ ಸುಮಾರು 2.5 ವರ್ಷ ಆಯ್ತು. When in fact, my lord, I told my advocate for the trial court, we should have done all these things in the honorable trial court itself.
No, pass over.
Please.
Let him come.
Serial number 21, Mahesh, Pratibha.
Sir, my lord, I have written letters to him also, my lord, is not communicable.
ಯಾವುದು 21?
21, my lord.
ಏನದು?
The respondent informed me that the matter has been settled, my lord, but I have not been able to contact the petitioner. He is not received. I have filed a memo seeking to withdraw, my lord, may be taken on record and permit pass. I had written letters to him also, my lord. He is in Orissa.
ಇದೇನು ಮೆಮೊ ಏನು?
I have actually filed a memo for retirement, my lord, because I am not able to get any instruction, my lord. I have, my lord,
withdraw ಅಂತಂದ್ರಲ್ಲ. You are seeking permission to retire or seeking permission to withdraw?
I'm seeking permission to retire, my lord, because I am not.
Counsel for the petitioner filed a memo seeking permission to retire from the case. As per learned counsel submits that after filing the petition, he has not received any instructions from the petitioner. Even they are not responding to his calls. The notice sent to the petitioner, notice sent to the petitioner through RPAD was returned unserved as the address is not proper under such circumstances. He seeks permission to retire from the case. For the reasons stated therein, memo is accepted. Counsel for the petitioner is permitted to retire. Next petition is of the year 2018. Matter was posted for reporting settlement. Till date, there is no progress in the matter. Is petition dismissed? Petition dismissed.
Much obliged.
Serial number 24, Keshav Bhatt, BN Jagdish.
There are two, my lord.
My lord, in the FIR, my lord, 5 accused were there.
You are the petitioners?
All the 5 are petitioners. 2 passed away during the pendency of the petition, my lord. I should point out this, my lord. My lord, petitioner number, my lord, 2 and 3 in criminal petition number 7922, my lord. Accused number 2 and 3. No more, my lord, are there.
No, in 7922.
Yes, my lord.
Accused number 1, 2, 1, 2, 3 are the petitioners.
Yes, my lord. Accused number 1, 2, 3 are the petitioners. Among them, my lord, accused number 2 and 3 passed away. Now, originally, their name was not there in the FIR. They were subsequently included in the charge sheet.
Connected ಯಾವುದು?
Connected.
7145.
ಹೌದು.
Their petitioners, sir?
Accused number 4 and 5. Their husband and wife, my lord, adjacent owners of the land. Allegation is that they have removed the arecanut plant and not intervened with the possession, trespassed.
FIR is against?
FIR is against, my lord, originally 5 accused, my lord. But,
Who are they?
my lord, A1 is the, my lord, adjacent landowner. Then his father-in-law.
No, whether they are the same accused number 1 to 5?
No, my lord, only accused number 2 and, my lord,
2 and
2 and 4, my lord, are dropped in the charge sheet. Original FIR accused, my lord. 2 and 4 are dropped. Instead of that, my lord, they have implicated these 2, my lord, 2 and 3, who are died, my lord. Now, therefore, my lord, 3 accused are before your lordship, my lord, in all. Even, my lord, the sections invoked in the FIR and charge sheet are, my lord, changed. Originally, they invoke, my lord, 3 clause 1. R and S, my lord. Original allegation that ಜಾತಿ ನಿಂದನೆ ಮಾಡಿದ್ದಾರೆ by the
It is not yet filed.
charge sheet filed, my lord.
ಎಲ್ಲಿದೆ?
My lord, that is at page annexure D, my lord, at page column at 48. My lord, criminal petition 7922 is with me, my lord. Annexure D is the charge sheet. I'm referring, my lord, this petition. 7922. Annexure D, page 39 onwards. These 2 provisions, my lord, invoked in FIR has been dropped. Section 3 clause 1 R and S. The original allegation that ಜಾತಿ ನಿಂದನೆ ಮಾಡಿದ್ದಾರೆ. Then, my lord, by virtue of the further statement, the complainant, his wife and daughter says, my lord, they went to the police, they went to the lawyer first. They instructed the lawyer to lodge the
Column number 17.
17, my lord.
Page number 46.
46.
Please read that.
Yes, my lord. ದೋಷಾರೋಪಣಾ ಪತ್ರದ ಅಂಕಣ ನಂಬರ್ 12ರಲ್ಲಿ ವಿಳಾಸ ನಮೂದಿಸುವ ಆರೋಪಿತರು ಮೇಲಿನ ಆಪಾದನೆ ಏನೆಂದರೆ ಆರೋಪಿತರ ಪೈಕಿ 1, 4 ಮತ್ತು 5ನೇ ಆರೋಪಿತರು ಪರಿಣಿತ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿದ್ದು 2ನೇ ಆರೋಪಿತರು ಭಿಲ್ಲವ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿ 3ನೇ ಆರೋಪಿತರು ಸೋಯಣ್ಸು ಜಾತಿ ನಾಯಕ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿರ್ತಾರೆ. ಚಾಸ 1ನೇಯವರು ಪಂಗಡ ಮತ್ತು ಮರಾಠಿ ಜಾತಿಗೆ ಸೇರಿದವರಾಗಿರ್ತಾರೆ. ದಿನಾಂಕ 13/1/2021 ಬೆಳಗಿನ ಜಾವ 2 ಗಂಟೆ ಸಮಯಕ್ಕೆ 1, 2 ಮತ್ತು 3ನೇ ಆರೋಪಿಗಳು 4 ಮತ್ತು 5ನೇ ಆರೋಪಿತರ ಕುಮ್ಮಕ್ಕಿನಿಂದ ಬಂಟ್ವಾಳ ತಾಲೂಕು ಬೆಳಿಯೂರು ಗ್ರಾಮದ ದೊರ್ಮೆ ಎಂಬಲ್ಲಿ 5ನೇ ಆರೋಪಿಗಳ ಟೊಯೋಟೋ ಕಂಪನಿ ಇಥಿಯೋಸ್ ಕಾರು ನಂಬರ್ 7 ಹೋಗಿ ರಸ್ತೆ ಬದಿಯಲ್ಲಿ ಕಾರು ನಿಲ್ಲಿಸಿ ಚಾಸ 1ನೇಯವರ ಬಾತು ಜಾಗ ಸರ್ವೆ ನಂಬರ್ 139/1B ಅದಕ್ಕೆ ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಸದ್ರಿ ಜಾಗದಲ್ಲಿ ಚಾಸ 1ನೇಯವರು ನೆಟ್ಟಿದ್ದ 250 ಅಡಿಕೆ ಗಿಡಗಳನ್ನು ಕಿತ್ತು ತೆಗೆದು ಆರೋಪಿತರು ಬಂದ ಕಾರಿನಲ್ಲಿ ತುಂಬಿಸಿಕೊಂಡು ಹೋಗಿ ಅಲ್ಲೇ ಸ್ವಲ್ಪ ದೂರದಲ್ಲಿರುವ ಗೊರ್ಮೆ ಒಳಗಡೆ ಬಿಸಾಕಿ ಕೃತ್ಯ ಎಸಗಿ ಚಾಸ 1ನೇಯವರಿಗೆ ಸುಮಾರು 50,000 ನಷ್ಟ ಉಂಟು ಮಾಡಿದ್ದಾಗಿದೆ. ಚಾಸ 1ನೇಯವರು ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಸೇರಿದವರೆಂದು ತಿಳಿದರೂ ಕೂಡ ಆರೋಪಿತರು ಸಮಾನ ಉದ್ದೇಶದಿಂದ ಸೇರಿ 4 ಮತ್ತು 5ನೇ ಆರೋಪಿತರ ಕುಮ್ಮಕ್ಕಿನಿಂದ 1, 2 ಮತ್ತು 3ನೇ ಆರೋಪಿತರು ಚಾಸ 1ನೇಯವರ ಜಾಗಕ್ಕೆ ಅಕ್ರಮ ಪ್ರವೇಶ ಮಾಡಿ ಚಾಸ 1ನೇಯವರ ನೆಟ್ಟಿದ್ದ ಅಡಿಕೆ ಗಿಡಗಳನ್ನು ಕಿತ್ತು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ ಹೊಳೆಗೆ ಬಿಸಾಕಿ ಅವರಿಗೆ ನಷ್ಟ ಉಂಟು ಮಾಡಿ ದೌರ್ಜನ್ಯ ಎಸಗಿದ್ದಾಗಿದೆ. ಆದ್ದರಿಂದ ಆರೋಪಿತರ ಪೈಕಿ 1 ಮತ್ತು 2ನೇಯವರು ಕಲಂ 143, 447, 427 ಜೊತೆಗೆ 149 IPC ಕಲಂ ಮತ್ತು 3 clause 2 clause 4 Roman 4 ಮೇಲೆ 3 clause 2 Roman 5A SC/ST Protection of Prevention of Atrocity Amendment Act 2015 ಶಿಕ್ಷಾರ್ಹವಾಗಿರುತ್ತಾರೆ. ಮತ್ತು 3ನೇ ಆರೋಪಿತರು ಕಲಂ ಸೇಮ್ ಲಾರ್ಡ್ ಆಲ್ ದ ಸೇಮ್ ಅಲಿಗೇಷನ್. Lord, the original allegation kindly come to my lord the complaint where they say ಜಾತಿ ನಿಂದನೆ ಮಾಡಿದ್ದಾರೆ. This complaint according to the complainant has been drafted by an advocate on his instruction. Interesting thing is my lord they say my lord ಬೈದಿದ್ದಾರೆ, ಆಮೇಲೆ ನಿಂದಿಸಿದ್ದಾರೆ, ಅವರೇ ಬಂದು ಜಾಗಕ್ಕೆ ಎಂಟರ್ ಆಗಿ ಅಡಿಕೆ ಗಿಡ ಕಿತ್ತಾಕಿದ್ದಾರೆ. Everything they say in the complaint. At page 36 my lord complaint. This is my lord typed complaint drafted by an advocate. Page 36 may be relevant my lord. 38 last paragraph. ನಿನ್ನೆ ದಿನಾಂಕ 12/1/2022 ಸಂಜೆ 6 ಗಂಟೆಗೆ ಆತನ ಮನೆಯಲ್ಲಿ 13 ಜನ ವ್ಯಕ್ತಿಗಳನ್ನು ನಿಲ್ಲಿಸಿ ಬೇರೆ ವಾಹನಗಳನ್ನು ಸಹ ನಿಲ್ಲಿಸಿ ಎದುರುದಾರರ ಮನೆಯಲ್ಲಿದ್ದ ಅವರ 2 ಕಾರುಗಳಲ್ಲಿ ಆತನ ಮನೆಯಿಂದ ಬಂಟ್ವಾಳ ಕಡೆ ಹೋಗಿ ಒಳ ಸಂಚು ಮಾಡಿ ರಾತ್ರಿ 2 ಗಂಟೆ ಸಮಯಕ್ಕೆ ನನ್ನ ಮನೆಯಲ್ಲಿ ಬಂದಿದ್ದ ಏನೋ ಶಬ್ದ ಹೊರಗೆ ಲೈಟ್ ಹಾಕಿ ನೋಡಿದಾಗ ಕೃಷ್ಣರಾಜ್ ವೆಂಕಟರಮಣ ಮಾರಕಾಯುಧ ಆದ ತಲವಾರು ಹಿಡಿದುಕೊಂಡಿದ್ದು, ಗಣೇಶ ಎಂಬುವನು ಬಾಳು ಕತ್ತಿ ಹಿಡಿದುಕೊಂಡು, ವೈಶಾಲಿ ಎಂಬಾಕೆ ಹಾರೆಯನ್ನು ಹಿಡಿದುಕೊಂಡು, ಲಲಿತಾ ಎಂಬಾಕೆ ಕತ್ತಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು 36 my lord page complaint.
Yes.
ಎಂಬಾಕೆ ಹಾರೆಯನ್ನು ಹಿಡಿದುಕೊಂಡು, ಲಲಿತಾ ಎಂಬಾಕೆ ಕತ್ತಿಯನ್ನು ಹಿಡಿದುಕೊಂಡು so and so.
Krishnaraj Bhatt is accused number 1.
Now A4 my lord.
A4. Then Venkatramana Bhatt.
In my lord FIR he was accused number 1.
Venkatramana Bhatt.
Venkatramana has been dropped in the charge sheet. Ganesha is A1 now.
Ganesh is A1.
He was A5 in the FIR.
Vaishali.
Now A5 my lord. Lalita has been dropped. Thank you. 4 A4. Lalita A4 now dropped.
Ideno Dharnappa.
Dharnappa is complainant my lord.
Me my lord. Okay.
All these allegations they make in the complaint my lord without any sense of responsibility my lord. This is primarily my lord allegation of abusing the caste. 2 ಗಂಟೆ ರಾತ್ರಿ ಬಂದು ಬೈದಿದ್ದಾರೆ ಅಂತ ಅಲಿಗೇಷನ್ ಇರುತ್ತೆ. ಕೊಲೆ ಮಾಡ್ತೇವೆ, ಬೈದಿದ್ದಾರೆ, ಹಾರೆ ಹಿಡ್ಕೊಂಡು ಬಂದಿದ್ರು, ಕತ್ತಿ ಹಿಡ್ಕೊಂಡು ಬಂದಿದ್ರು. Now my lord kindly come to my lord the further statement of the very same my lord the complainant. It is a specific case in the complaint that, my lord, they so and so only come to, my lord, annexure E, page 49. The same complainant, after 3 days, my lord, there is a delay in lodging the complaint also, my lord. The incident, according to them, happened midnight at 2 a.m. The complaint has been, FIR has been registered in the evening next day, 6 o'clock. Distance is only 6 kilometers from the police station.
Then,
And it reaches next day, my lord, on 15th it reaches. 14th. 14th it reaches to the magistrate. That is one aspect. My lord, now kindly come to page 49. Annexure E, the further statement of the same complainant. My lord, 3 witnesses, my lord, they have recorded the statement.
49 now?
49, my lord, of Annexure E, criminal petition number 7922.
51.
Criminal petition 7922 ಅಲ್ಲಿ page 49.
7922 ನಲ್ಲಿ page 51 is annexure E.
ಆಯ್ತು.
Further
ಸರಿ.
statement of?
Yes, my lord. ಧರ್ನಪ್ಪ ನಾಯಕ. Yes, my lord. Dear my lord, ನಾನು ಮೇಲೆ ತಿಳಿಸಿದ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ಹೆಂಡತಿ ಮಕ್ಕಳಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನಾನು ದಿನಾಂಕ 13ರಂದು ವಿರುದ್ಧ ದೂರು ನೀಡಿದ್ದು ಸದರಿ ದೂರಿನಲ್ಲಿ ನಮೂದಿಸುವಾಗ ಗಡಿಬಿಡಿ ಹಾಗೂ ಸರಿಯಾದ ಅರಿವಿಲ್ಲದೆ ಕೆಲವು ವಿಷಯಗಳನ್ನು ಹೆಚ್ಚು ಕಮ್ಮಿಯಾಗಿರುತ್ತದೆ. ಹೆಚ್ಚು ಆಗಿದೆ, ಕಮ್ಮಿಯೂ ಆಗಿದೆ, ಎರಡೂ ಆಗಿದೆ. ನನಗೆ 3 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳಿದ್ದು, ಒಬ್ಬರಲ್ಲಿ ಕೂಡ ಮಕ್ಕಳಾದ ಪ್ರತಿಭಾ ಹಾಗೂ ಕಾವ್ಯಳನ್ನು ಮದುವೆ ಮಾಡಿ ಕೊಟ್ಟಿದ್ದು ಆಕೆಯ ಗಂಡನೊಂದಿಗೆ ಬೆಂಗಳೂರಿನಲ್ಲಿರುವುದಾಗಿದೆ. ಕಾವ್ಯಳು ಆಕೆಯ ಗಂಡನೊಂದಿಗೆ ಮುಂಬೈನಲ್ಲಿರುವುದಾಗಿದೆ. ಸಣ್ಣ ಮಗಳು ಬೆಂಗಳೂರಿನ ಉದ್ಯೋಗದಲ್ಲಿರುತ್ತಾಳೆ. ಮನೆಯಲ್ಲಿ ನಾನು ಮತ್ತು ನನ್ನ ಪತ್ನಿ ಮಾತ್ರ ಇರುವುದಾಗಿದೆ. ಮಗಳು ಕಾವ್ಯಳಿಗೆ ಸಣ್ಣ ಮಗು ಇದ್ದು ಮುಂಬೈಯಿಂದ ಆಕೆಯು ನನ್ನ ಮನೆಗೆ ಬಂದು 2 ತಿಂಗಳಾಗಿದ್ದು ಈಗ ಮನೆಯಲ್ಲೇ ಇದ್ದಾಳೆ.
ಆಯ್ತು, come to the
ನೆಕ್ಸ್ಟ್ ಲೈನ್ ಇಸ್ ಇಂಪಾರ್ಟೆಂಟ್. ನನಗೆ ನನ್ನ ಮನೆಯ ಸಮೀಪ ಇರುವ ಪಿತ್ರಾಜಿತಿಯ ಸ್ವಂತ ಜಾಗವಿದ್ದು ಸದರಿ ಜಾಗದ ಪಕ್ಕದಲ್ಲಿರುವ ಸರ್ವೆ ನಂಬರ್ 139 1B ಯಲ್ಲಿ ಸರ್ಕಾರಿ ಜಾಗಕ್ಕೆ ನಾನು ಮೊದಲಿಂದಲೂ ತೆರಿಗೆ ಕಟ್ಟಿಕೊಂಡು ಸದರಿ ಜಾಗಕ್ಕೆ ನಾನು ಅಕ್ರಮ ಸಕ್ರಮ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ್ದೆನು. ಅದರಲ್ಲಿ 1.61 ಎಕರೆ ಜಾಗವು ಸರ್ಕಾರದಿಂದ ನನಗೆ ಮಂಜೂರಾಗಿರುತ್ತದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ನನಗೆ ಮನೆ ಕಟ್ಟಿದ್ದು ಅಲ್ಲದೆ 2019ನೇ ಇಸವಿಯ ಅಕ್ಟೋಬರ್ ತಿಂಗಳಲ್ಲಿ JCB ಮೂಲಕ ಅಗೆದು ತಟ್ಟು ಮಾಡಿ 330 ಅಡಿಕೆ ಗಿಡ ನೆಡಲು ಹೊಂಡ ತೆಗೆಸಿ 250 ಗಿಡಗಳನ್ನು ನೆಟ್ಟಿದ್ದೇನೆ. 80 ಹೊಂಡಗಳು ಹಣವಿಲ್ಲದೆ ಗಿಡ ನೆಡಲು ಬಾಕಿಯಾಗಿದ್ದವು. ಸದರಿ ಜಾಗದ ಪಕ್ಕದಲ್ಲಿ ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ 75 ಹಾದು ಹೋಗುತ್ತಿದ್ದು ಸದರಿ ರಸ್ತೆಗೆ ಲಗತ್ತಾಗಿರುವ ಉರಿಮಾಡ ಕೃಷ್ಣರಾಜ್ ಎಂಬುವರು ಖರೀದಿ ಮಾಡಿರುವ A4 ಖರೀದಿ ಮಾಡಿರುವ ಜಾಗವಿರುತ್ತದೆ. ಸದರಿ ಜಾಗದಲ್ಲಿ ಉರಿಮಾಡ ಕೃಷ್ಣರಾಜ್ ಅವರ ಸಂಬಂಧಿ ಭಾವ ಗಣೇಶ್ ಭಟ್ ಎಂಬುವರು ಗ್ರಾನೈಟ್ ಅಂಗಡಿ ಮಾಡಿಕೊಂಡು ವ್ಯಾಪಾರ ನಡೆಸುವಾಗ ಹಲವು ವರ್ಷಗಳಿಂದ ಕೃಷ್ಣರಾಜ್ ಅವರ ಮಾವ ವೆಂಕಟರಮಣ ಭಟ್, ಕೃಷ್ಣರಾಜ್ ಭಟ್ ಹೆಂಡತಿ ವೈಶಾಲಿಯು ನನಗೆ ಅಕ್ರಮ ಸಕ್ರಮ ಮಂಜೂರಾದ ಜಾಗವನ್ನು ಅವರಿಗೆ ಬಿಟ್ಟು ಕೊಡಬೇಕೆಂದು ನನ್ನಲ್ಲಿ ಹೇಳುತ್ತಾ ಬೆದರಿಸುತ್ತಿದ್ದರು. ಅಲ್ಲದೆ ನನಗೆ ನಾನಾ ರೀತಿಯಲ್ಲಿ ಕಿರುಕುಳ ನೀಡುತ್ತಾ ಭಯ ಹುಟ್ಟಿಸುತ್ತಿದ್ದರು. ನಾನು ಸದರಿ ಜಾಗದಲ್ಲಿ ಕೆಲಸ ಮಾಡಿಕೊಳ್ಳುತ್ತಿರುವಾಗ ಆಕ್ಷೇಪಿಸುತ್ತಾ ಇದ್ದರು. ಅಲ್ಲದೆ ಈ ಬಗ್ಗೆ ಅವರು ಮಂಗಳೂರು ಸಹಾಯಕ ಆಯುಕ್ತರ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ದಾವೆ ಕೂಡ ಹೂಡಿದ್ದು ಮಂಗಳೂರು ಸಹಾಯಕ ಆಯುಕ್ತರು ವಿಚಾರಣೆ ನಡೆಸಿ ಮುಂದಿನ ಆದೇಶದ ತನಕ 2 ಕಡೆಯವರು ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡುವಂತೆ ನಂಬರ್ NCR 30/2019-20 ದಿನಾಂಕ 27/12/2019ರಂತೆ ದಿಸ್ ಡೇಟ್ ಈಸ್ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್. 27/12/2019ರಂತೆ ಆದೇಶಿಸಿರುತ್ತಾರೆ. ದಿನಾಂಕ 12/1/2020ರಂದು ರಾತ್ರಿ ನಾನು ನನ್ನ ಮಗಳು ಊಟ ಮಾಡಿ ಸುಮಾರು 12 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಎಚ್ಚರವಿದ್ದು ಬಳಿಕ ಮಲಗಿದೆನು. ದಿನಾಂಕ 13/1/2020ರಂದು ಬೆಳಗಿನ ಜಾವ ಸುಮಾರು 2 ಗಂಟೆ ಸಮಯಕ್ಕೆ ನಾನು ಎಚ್ಚರವಾಗುವಾಗ ದಿಸ್ ಲೈನ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಮೈ ಲಾರ್ಡ್. ಎಚ್ಚರಗೊಂಡಾಗ ನಮ್ಮ ಮನೆಯ ಎದುರು ನಾನು ಅಡಿಕೆ ಗಿಡ ನೆಟ್ಟಿದ್ದ ಜಾಗದಲ್ಲಿ ಏನೋ ಶಬ್ದ ಕೇಳಿ ನಾನು ಎದ್ದು ಮನೆಯ ವಿದ್ಯುತ್ ಲೈಟ್ ಹಾಕಲು ಹೋದಾಗ ವಿದ್ಯುತ್ ಇರಲಿಲ್ಲ. ನಾನು ಮನೆಯ ಎದುರು ಬಾಗಿಲು ತೆರೆದು ಸಿಟ್ಔಟ್ಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ನಾನು ಗಿಡ ನೆಟ್ಟಿದ್ದ ಜಾಗದಲ್ಲಿ ಯಾರೋ 3 ಜನ ಆಚೆ ಈಚೆ ಹೋಗುವುದು ಬೆಳದಿಂಗಳ ಬೆಳಕಿನಲ್ಲಿ ಕಂಡಿತು. ಲಾರ್ಡ್, he was unable to identify. ನೆಟ್ಟಿದ್ದ ಜಾಗದಲ್ಲಿ ಯಾರೋ 3 ಜನ ಆಚೆ ಈಚೆ ಹೋಗುವುದು ಬೆಳದಿಂಗಳ ಬೆಳಕಿನಲ್ಲಿ ಕಂಡಿತು. ಅವರು ಯಾರೆಂದು ಗುರುತು ಸಿಗಲಿಲ್ಲ. ನಾನು ಒಳಗೆ ಹೋಗಿ ಮಲಗಿದ್ದ ಪತ್ನಿ ಮಗಳು ಕಾವ್ಯಳನ್ನು ಎಬ್ಬಿಸಿ ಅವರು ಕೂಡ ಸಿಟ್ಔಟ್ಗೆ ಬಂದು ನೋಡಿದರು. ನಮಗೆ ಅಲ್ಲಿಗೆ ಹೋಗಲು ಹೆದರಿಕೆಯಾಗಿ ಮನೆಯೊಳಗೆ ಹೋಗಿ ಬಾಗಿಲು ಹಾಕಿ ಭದ್ರಪಡಿಸಿ ನಾವು ಮನೆಯೊಳಗೆ ಮಲಗಿದ್ದೆವು. ಬೆಳಗ್ಗೆ ಎದ್ದು ಗಿಡ ಜಾಗಕ್ಕೆ ಹೋಗಿ ನೋಡಿದಾಗ ನಾವು ನೆಟ್ಟಿದ್ದ ಎಲ್ಲ ಅಡಿಕೆ ಗಿಡಗಳು ಕಿತ್ತು ತೆಗೆದುಕೊಂಡು ಹೋಗಿರುವುದು ಕಂಡು ಬಂತು. ಅಲ್ಲದೆ ನನ್ನ ಮನೆಯ ಎದುರು ನಾನು ನಿಲ್ಲಿಸಿದ್ದ ಸ್ಕೂಟರ್ನ ಹಿಂಬದಿ ಚಕ್ರದ ಗಾಳಿ ಕೂಡ ಹೋಗಿತ್ತು. ಬಳಿಕ ನಾನು ಉಪ್ಪಿನಂಗಡಿಗೆ ಹೋಗಿ ನನ್ನ ವಕೀಲರಲ್ಲಿ ಹೇಳಿದೆನು. ಅವರು ಯಾರು ಕೊಂಡು ಹೋಗಿರಬಹುದು, ಯಾರ ಮೇಲೆ ಅನುಮಾನ ಇದೆ ಎಂದು ಕೇಳಿದಾಗ ನಾನು ಮೊದಲಿಂದಲೂ ಸದ್ರಿ ಜಾಗದ ಬಗ್ಗೆ ನನ್ನಲ್ಲಿ ತಕರಾರು ಮಾಡ್ತಿರುವ ಕೃಷ್ಣರಾಜ್ ಅವರ ಪತ್ನಿ ವೈಶಾಲಿ, ಮಾವ ವೆಂಕಟರಮಣ ಮತ್ತು ಅತ್ತೆ ಲಲಿತಾ ಅವರ ಭಾವ ಗಣೇಶ್ ಚಂದ್ರ ಮೇಲೆ ಸಂಶಯವಿರುವುದಾಗಿ ಬೇರೆ ಯಾರಿಗೂ ಈ ರೀತಿ ಮಾಡುವ ಸಾಧ್ಯತೆ ಇಲ್ಲ ಎಂಬುದಾಗಿ ತಿಳಿಸಿದೆನು. ಅದರಂತೆ ವಕೀಲರು ಒಂದು ಫಿರ್ಯಾದಿಯನ್ನು ತಯಾರಿಸಿ ನೀಡಿದರು. ಸದ್ರಿ ಫಿರ್ಯಾದಿಗೆ ಸಹಿ ಮಾಡಿ ನಾನು ಉಪ್ಪಿನಂಗಡಿ ಪೊಲೀಸ್ ಠಾಣೆಗೆ ಹೋಗಿ ನೀಡಿರುತ್ತೇನೆ. ಅಲ್ಲದೆ ಆ ದಿನ ಕೃಷ್ಣರಾಜ್ ಪತ್ನಿ ವೈಶಾಲಿ, ವೆಂಕಟರಮಣ, ಲಲಿತಾ, ಗಣೇಶ್ ಚಂದ್ರ ಇವರು ಗಲಾಟೆ ಮಾಡಿರುತ್ತಾನು. ನೆಟ್ಟ ಗಿಡ 3 ಜನರು ಮಾತ್ರ ಬೆಳದಿಂಗಳಲ್ಲಿ ನೋಡಿದ್ದು. ನಾನು ಗಿಡ ನೆಟ್ಟ ಜಾಗದಲ್ಲಿ 3 ಜನರನ್ನು ಮಾತ್ರ ಬೆಳದಿಂಗಳಲ್ಲಿ ನೋಡಿದ್ದು. ಅವರು ದೂರದಲ್ಲಿದ್ದುದರಿಂದ ಅವರು ಯಾರೆಂದು ನನಗೆ ಪರಿಚಯ ಸಿಕ್ಕಿರುವುದಿಲ್ಲ. ನಾನು ನೆಟ್ಟಿದ್ದ ಅಡಿಕೆ ಗಿಡಗಳನ್ನು ಮಾತ್ರ ಕೃಷ್ಣರಾಜ್ ಭಟ್ ಅವರು ಕಿತ್ತು ಹಾಕಿರುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಈ ಕೃತ್ಯದಿಂದ ನನಗೆ ಸುಮಾರು 50,000 ನಷ್ಟವಾಗಿರುತ್ತದೆ. In the same line, my lord, the other 2 so-called eyewitness also same law.
That is
Therefore,
his wife and
daughter, my lord. Now, only one document, my lord, the order of the assistant commissioner, my lord. What happened is, my lord, background is this.
one.
In respect of the same,
One.
yes.
Page 73 in the AC order. It is for course. December. When complaint AC is decided, the entry made in the order of the committee, recommendation to another.
Yes.
Lord, it is a undisputed fact that there was a proceedings before the assistant commissioner.
Yes.
Where, my lord, I have called in question the Sagwali chit and the grant of land, my lord, in favor of the
Accused number 1.
A5, my lord.
A5.
Vaishali is the, my lord, person who is a co-applicant for the same land. My lord, what happened is, my lord, there were 2 applications. One is filed by the complainant, one is filed by Vaishali.
Yes.
Now, the application filed by complainant was, my lord, decided without affording any opportunity to the Vaishali. But therefore, she called in question before the assistant commissioner. Now, kindly see the order, my lord, at annexure J, page 73. But in the complaint itself, he says, my lord, the status quo order was there. Then now, kindly see, my lord, the annexure J.
Page number
73, my lord. It's order of the assistant commissioner, my lord, dated 25th June 2020. Page 73. Vaishali's appeal, my lord. And, my lord, the operative portion is, my lord.
appeal was allowed.
Appeal was allowed, my lord. The grant in favor of the complainant was set aside. And the mutation, Lord, the revenue authorities are directed to mutate the same in the name of government. And, my lord, they directed to club both the applications and decide afresh. There, my lord, para 10 at page 82. The interim order granted, my lord, 27/12/2019 status quo order also vacated, my lord. Kindly see at page 83, operative portion.
Yes.
The interim order of status quo, my lord, stands vacated by virtue of this order. Now, para 10, my lord, only for limited reference, page 82. On perusal of the Sagwali chit register, it appears that there is a correction in the register. It is seen that previous entry is struck off and new entry is inserted. That is, name of the respondent number 1 is inserted. On perusal of the certified copy of the Sagwali chit, it is observed that the Sagwali chit number is not mentioned. These aspects give reasons to suspect the genuineness of the proceedings and grant order. My lord, this order was challenged before the deputy commissioner by the complainant respondent. That has been, my lord, dismissed. Against which, my lord, he approaches KAT. KAT, my lord, the proceedings are pending, but the interim order is not granted. Against the refusal of interim order, my lord, a writ has been filed. That is also pending. Now, my lord, 2 proceedings are pending. One is in KAT against this order, my lord, assistant commissioner's order, DC confirming the same. And
KAT has not given.
KAT has not granted interim order in favor of the respondent in his appeal. These are all undisputed facts.
Challenged before this court
This court, my lord, to the limited scope, my lord, so far as rejection of interim prayer
by KAT.
by KAT. That is pending, but there is no interim order. This, my lord, modifies the section, the alter and file charge sheet, my lord, mechanically without, my lord, considering the statement, further statement,
Yes,
and nothing on record other except this, my lord. They themselves say they have not seen anyone.
yes.
And at this juncture, my lord, it is purely a civil dispute given color of a criminal case. Therefore, it is a abuse of process of law. It is nothing but, my lord, a settling scores, my lord. Such a exercise is impermissible in law. Therefore, my lord, it is a pit case for quashing under section 482 law. Absolutely, there is no chance of conviction also because they didn't identify. They can't improve before the trial court, my lord, identifying anybody because they, in their own statement, they say they didn't see anybody. There was no light. They didn't see anybody. And complaint was drafted by an advocate. Then, my lord, the version of the original complaint has been denied in their further statement. Ultimately, matter is revolving, my lord, in and around civil dispute, which is also a subject matter, my lord. No title, clear title. Even assuming, my lord, without conceding, if they trespassed, section 427 is another section invoked. So therefore, either, my lord, section 427 or, my lord, the special act is attracted in the case. There are few judgments also, my lord, which says, my lord, abuse of a process of law, in especially, my lord, when the civil dispute is pending. George.
Yes, which is the citation?
Yes.
Why 6 decisions?
And only to say, my lord, abuse of process of law, my lord.
How the one then Madi, which is to be relied on?
My lord,
Which is the
your
best
lordship,
evidence
my lord, 2023, my lord, 5 SCC 360, page 38, para 13.
Sarabjit Kaur.
Para 13. To settle the civil scores,
The
criminal
page number.
relevant page, my lord, 363, 41.
Done.
Our pagination 41, my lord. Page, paragraph 13.
ಯಾವಾಗ್ಲೂ pagination differs ಆಗುತ್ತಲ್ಲ ಯಾಕೆ? Here page number 38.
Starting
Relevant is at, my lord, page 41.
Starts from page 38.
38, lordship are absolutely right.
You are referring to page number 41.
Yes, my lord. Para 13.
Yes.
A breach of contract does not give rise to criminal prosecution for cheating unless the fraudulent or dishonest intention is shown right at the beginning of the transaction. Merely on the allegation of failure to keep a promise will not enough to initiate criminal proceedings. From the facts available on record, it is evident that the respondent number had improved his case ever since the first complaint was filed, in which there was no allegations against the appellant. Rather, it is only against the property dealers, which was subsequent complainants, and that the name of the appellant was mentioned. On the first complaint, the only request was to return the amount paid by the respondent number 2. When the offense was made out on the basis of the first complaint, the second complaint was filed with the improved version, making allegations against the appellant as well as not there in the earlier complaint. The entire idea seems to convert the civil dispute into criminal and put pressure on the appellant to return the amount allegedly paid. The criminal courts are not meant to be used for settling scores or pressurize the parties to settle civil disputes. Whenever ingredients are not met. The other one is, my lord, the coordinate bench, my lord. But at page 74 onwards, 2023 SCC online. ಇನ್ನು ಮೂರು ಸರಿ ಹೇಳಿ. Page 74, my lord, SCC. Page 84 is relevant.
Page.
Page 84 is a relevant page.
Yes.
Section 3(1)(f) directs whoever wrongfully occupies or cultivates the land owned by scheduled caste. Petitioner are in possession of the property for the last 50 years and they are in peaceful enjoyment of the land. Therefore, they have not wrongfully occupied the land belonging to either member of the scheduled caste or tribe complainant herein. Section 3 clause 1p deals with institutes false, malicious or vexatious suit or criminal or other legal proceedings against the member of the scheduled caste or scheduled tribe. The petitioners have on their own right instituted the proceedings, both civil and criminal, against the complainant alleging harassment by him and disturbance of peaceful possession. It can neither be malicious nor vexatious or even false. Therefore, the said provision also cannot be invoked in the case at hand. The other provisions are section 3(1)(r) and S of the Act, shouldering the abuse of abuses in a public place or place of public view. Neither of them are present in the case on hand, as the property of the petitioner and the complainant abut each other. The ingredients of clauses R and S are sought to be pumped into the complaint and summary of the charge sheet only to wreak vengeance against the petitioners for having registered. Yes.
Yes.
Therefore, the provisions of the provisions under the clauses R and S are only counterbalanced to what is aforesaid. Now coming to section 3 clause 2 5A, this is also invoked in this case, my lord. Now coming to section 3 clause 2 5A of the Act, whoever commits any offense against a person or property, knowing that it belongs to a member of scheduled caste or scheduled tribe, becomes liable for punishment. It is again understandable how the said provision could be invoked, as the complainant and the complaint governments pursuant to the certain sale deeds and the petitioners were put in possession of the property not today but decades ago. Therefore, the said provision is loosely laid against the petitioner. Para 23. On the entire gamut of consideration made herein above, what would unmistakably emerge is misuse of abuse of provisions of the Act. This case forms a classic illustration of scores of cases where the provisions of this Act are misused for ulterior motives or pressurize the accused in collateral proceedings. Therefore, none of the offences either under IPC or under the Act are present on in their foundational basis, let alone be building a castle on such a foundation. In the teeth of the aforesaid fact, if further proceedings are permitted to continue, it would be putting a premium on the abuse of process of law by way of a complaint in a manner which on the facts, if it on the face of it, civil in nature. If the impugned crime is not a case where a civil proceeding is dressed with the color of crime, I fail to understand what else can be. Next, para 27. Well, it is settled law, Lord. There are a number of judgments wherever in a kind of this cases, my lord.
Yes.
Now, my lord, apart from civil dispute, he was unable to identify yaar bandru, yaar hogidru, avaru helike. In page 92 also one para, my lord, where some observations. Para 20. In the light of the aforesaid facts, glaring in of they are what would unmistakably emerge is that This would be form a classic illustration of misuse of provisions of the Act and the penal provisions under the IPC. It is such a cases which clog the criminal justice system and consume considerable time of courts, be it the magistrate court, sessions court, or this court, while genuine cases where litigants are actually suffered would be waiting in the pipeline. Therefore, such cases, which on the face of it is an abuse of process of law, are necessarily to be nipped, failing which it would be heavily burden on the criminal justice system, apart from it becoming harassment to the petitioner and ultimately resulting in miscarriage of justice. Therefore, my lord, the proceedings may kindly be quashed in this case, my lord.
Yes. My lord, there is a further statement on 18/8/2020 that has not been placed by the petitioner's counsel. There's one further statement after the further statement read by my learned senior on 18/8/2020, where the complainant has named these petitioners again. In any case, my lord, these are all matters of trial. A detailed investigation has been conducted, and going so far as to drop some of the FIR named accused and adding certain accused. That means there was material, there were circumstances to show that these people had committed these offenses, my lord. Whether 3, 4, 5, the charge sheet is revealing this. And admittedly, there is a civil dispute between them, which is still pending. But merely the existence of a civil dispute, my lord, cannot be a reason why there is no criminal cause of action when there has been so much damage to his property. In fact, it gives more rise to an intention for them to damage their property, my lord. Given this
further statement is specifically stated by the complainant and 2 eyewitnesses that they could not identify, there were only 3 persons and they could not identify any of them.
There is one more further statement, my lord, on 18/8/2020.
Can it be believed, madam? What is the allegation in the first information? Very serious allegations are made.
Yes, my lord.
Referring to so many persons that FIR is against accused number 1 to 6 and 13 others. What should happen to them? Is it a fancy?
No, my lord, of course not, my lord, but there was...
Why such allegations were made when why FIR was registered against so many persons?
Because that was his suspicion, my lord, due to the property dispute.
There is specific overt act alleged in the first information.
Yes, my lord, and
What
then
was
the charge sheet...
basis? What was the basis? The
Because of
informant
this
says,
history-
I could not identify anybody. There were only 3 persons.
There was a history between them.
Be the intention of the complainant. Prima facie it shows.
No, my lord, I may be permitted one short accommodation to respond in detail on Friday, only for one reason, my lord.
To argue in detail. I am
Please,
not
my
in a
lord.
hurry.
Yes,
I will hear you leisurely.
please, my lord. On Friday, I will
No,
respond.
today.
No, the reason is the
No
council...
question of adjourning, ma'am. I am not
I'll
in the
just make a
habit of.
short submission.
I
Why?
am not in the habit of adjourning the matter
understand,
after
my lord.
hearing one side.
I understand, but the reason I'll tell you, my lord, please hear me.
Whatever may be the reason, I will not adjourn.
Counsel on the record is additional SPP, my
No.
lord. We've got this
Whoever
file
it-
after a long
No,
break, and I
It
don't have the
should
citation.
be your submission at the beginning.
I know, my lord,
Not
but the
at
senior
this stage.
counsel started arguing
after
just
after
2 days,
hearing-
my lord.
No, sorry. No, sorry.
Afternoon, my lord. I'll argue
No,
at
after
length in the
2:30
afternoon.
already matters are fixed,
My
ma'am.
lord, please, Friday,
Specifically-
my lord, I will complete my submissions. I don't have the citations copy also, my
Please
lord.
do that. I'm not in a hurry. I will hear you up to 1:30. I can sit up to 2 o'clock. Please address the argument.
I have got the file in the morning, my lord. There is a reason I need to peruse.
Nothing. After hearing the other side at length and after
I
noting so many
apologize, my
things,
lord. I didn't want to interrupt. That's why.
don't be under the impression that.
No, my lord. I'm not trying to waste this court's time.
Then
I'm
what
just
else it
asking
is?
for 2 days
What else it
to
is?
please
I will not. I will.
And to seek instructions on those civil
Have
proceedings from the
anything to
client.
say, please go on. Otherwise, I'll start dictating.
No,
There's
my lord.
only two options.
Please, my lord, or
Yes.
at least a short pass over,
No,
my
sir,
lord.
sorry.
Let me
2:30 I
peruse the
request
papers, my lord. I got it only in the morning. Please understand, my
Petitioners.
lord. I don't have the citation copy either. It has been sent to my senior.
in petitioners in criminal petition number 7922 of 2020 or accused number 123 and petitioners in criminal petition number 7145 or petitioner or accused number 4 and 5 in a special case number 5036 of 2020 pending on the file of the learned 5th additional district and sessions judge D.K. Mangaluru sitting at Putturu are seeking to quash the criminal proceedings initiated against them on the basis of the first information lodged by respondent number 2. The facts of the case are that respondent number 2 filed the first information with Uppinagadi Police on 13/1/2020 at 6 p.m. alleging that accused number 1 to 5 named therein are the criminals. They have cheated several persons and purchased agricultural land which is adjacent to the land belonging to the informant. It is also stated that accused number 1, 2, and 5 have abused or in the habit of abusing the informant by referring to his caste, since he is belonging to scheduled caste, and was criminally intimidating to give up the land belonging to the informant or to face their consequences. They even held out life threat to the informant to give up his right over 1.61 acres of land in survey number 139-1B situated. The land is situated at which place? Which
Dharme village, my lord,
Survey number 139.
139 1B.
1 acre 61.
Yes, my lord. 1 acre 61.
Situated at?
Dharme village.
Parne village.
Bidiyuru village.
Bantwal.
Dharme Bidiyuru village.
ಎಲ್ಲಿದೆ ಅದು?
Bantwal taluk.
Bantwal taluk.
ಅಲ್ಲ ಅದು ರೆಫರೆನ್ಸ್ ಎಲ್ಲಿದೆ? I could not follow that.
Send FIR.
FIR ನಲ್ಲೇ ಇದೆಯಾ?
Yes. ಕೃತ್ಯ ನಡೆದಷ್ಟು.
ಬಿಳಿಯೂರು ಗ್ರಾಮ. Yes?
Yes, my lord. Biliyur Grama, Bantwal taluk. Dorme.
ಬಿಳಿಯೂರು village.
Dorme.
Perne post. Biliyuru village of Perne, Bantwal Taluk. The informant states that the accused are in the habit of abuses against him, referring to his caste and also attempting to assault him. They even attempted on his life. And a criminal case was registered against the accused in that regard. Next part. The informant further states on 12/1/2020 at 6 p.m. 13 persons have came in different vehicles, including 2 cars. And thereafter, criminally conspiring, they went away. Later at 2 in the midnight, he heard some noise outside. The informant came out after lighting the light, and found one Krishna Raj Bhatt, that is accused number 4, and Venkatramana Bhatt, armed with a talwar, and Ganesh Bhatt, accused number 1, with a sickle. Accused number 5 was armed with a pickaxe, and Lalita was armed with a chopper. They abused the informant in Hindi language, challenged him to come out of the house. Accused number 4 held out life threat. The accused Venkatramana Bhatt challenged the informant to give up his right over the property and intimidated to cause his death with a talwar. Accused number 5 left the air of the scooter and car tire, which were parked in the courtyard of the complainant. Accused number 1 threatened the informant of chopping off his legs and hands. They also abused the wife and daughter of the informant and held out life threat to them. Other 13 accused have surrounded the house of the complainant and threatened of their consequences if they dare to file any complaint. They also threatened of burning the house with a torch. Accused number 1 disconnected the electricity, and thereafter Venkatramana and accused number 1 illegally trespassed over the land belonging to the complainant, destroyed the recognized plants, and taken them in a vehicle. Next part. The informant stated that since accused number 5 has challenged the order of grant made in favor of the informant before the assistant commissioner and got an interim order now she is bent upon to concoct documents and threaten the informant and his family members. Therefore, it is stated that the accused have formed unlawful assembly, illegally trespassed over the land belonging to the informant, abuse the informant and his family members in Hindi language, threatening to cause their death or cause grievous hurt with the deadly weapons, and caused unlawful loss and caused damages of worth rupees 50,000 by destroying the plants and thereby committed the and placed false claim for the land belonging to the informant who belongs to scheduled caste and thereby committed the offense also. After investigation, the FIR was came to be registered in crime number 8 of 2020 of Impleading Police Station for the offenses punishable under sections 143, 147, 447, 427, 504, 506, with section 149 of IPC and under section 31R, 31S of the CST Prevention of Atrocities Amendment Act 2015. After investigation, charge sheet was came to be filed. FIR was came to be registered against accused number 1 to 5 and 13 other persons for the offense. After investigation, charge sheet came to be filed against accused number 1 to 5, who are the petitioners herein. After dropping the names, few names mentioned in the first in the FIR. And naming accused number 2 and 4 afresh in the charge sheet. For the offense punishable under sections 143, 109, 427, read with section 149 of IPC, under section 324, 325A of SCST Prevention of Atrocities. Petitioners being accused number 1 to 5 have approached this by filing the petitions seeking quashing of the criminal proceedings initiated against them. During the pendency of the petitions, accused number 2 and 3, who are the petitioner number 2 and 3, in criminal petition number 7922, have died, and the petition filed by them is dismissed as awaiting the order shipment happening. Third learned counsel, senior advocate for the petitioners for so and so, and learned counsel for respondent number 2, and learned HCGP for respondent number so and so. The senior advocate for the petitioner contended that the incident had said to have occurred at 2 a.m. on incident said to have occurred from 6 p.m. on 12/1/2020 till 4:30 a.m. on 13/1/2020. The FIR was going to be registered on 13/1/2020 at 6 p.m. The first information is a typed one, which runs into 5 pages, filed against accused number 1 to 1 to 5 and 13 other persons for the above said offences. Specific overtaxes were alleged against each of the accused and 13 other persons for having committed the offence armed with deadly weapons, holding out threat to the life and limbs, and also trying to burn the house of the informant with a torch. It stated that accused number 1 disconnected the electricity, and later the accused have damaged the Iconet plants and taken away the same in a vehicle. Next. Senior advocate drawn the attention of the court to annexure E, F, and G, the further statement of the informant and the statements of the wife and daughter of the informant, who are the only 3 eyewitnesses to speak about the incident, where they have stated that even though a detailed complaint is filed, some mistakes have crept in the same in the information. These witnesses have specifically stated that after the incident, they have approached their advocate. They have seen only 3 persons during the night hours of 13/1/2020, but they could not identify any of them as there was no electricity supply. When they approached their advocate for the purpose of filing the complaint, he has drafted the complaint which was given to the police. Placing reliance on these further statements, the senior advocate contended that only on suspicion, the informant approached his advocate, who has drafted the complaint with all his imagination against accused numbers 1 to 5 and 13 other persons for having committed serious offense as stated above. But the further statement discloses that no such incident had ever taken place, except to state that accused numbers 1 to 3 have to state that 3 persons have came and destroyed the Iconet plants and thereby caused damages and loss to the informant. But he could not identify any of them. Since there was a dispute between the informant and the accused number 5 with regard to the land in question, which was claimed by the informant under Akrama Sakrama, and the same was challenged by accused number 5 before the Assistant Commissioner Mangaluru, who ordered to maintain status quo. He suspects that it was accused number 1 to 3 who might have committed the offense. But the investigating officer filed the charge sheet against accused number 1 to 5, citing the very same informant and his wife and daughter as the only eyewitnesses to the incident. Contending that they have came in the dead night, destroyed the Iconet plants, caused loss to the informant. Senior advocate submitted that when specific allegations were made in the first information, which runs into 5 pages, alleging in detail about the old acts committed by various accused and 13 other persons, the charge sheet is silent about the same, and accused members who were dropped in the charge sheet.
Venkatramana, A2 in the FIR, A4 in the FIR.
Accused number 2, Venkatramana, and
A2 and A4 in the FIR.
A4 yaru? Lalita.
Lalita, wife of
A4
A2.
Lalita named in the FIR while filing the charge sheet. Next one. Then the senior advocate contended that the informant had claimed the land in question under Akrama Sakrama, while accused number 5 had also claimed the said land as the same is in her possession. However, the Tahsildar passed an order granting the land in favor of the informant without affording any opportunity to accused number 5. Therefore, the order of the Tahsildar granting that the land in favor of the informant was challenged by accused number 5 before the Assistant Commissioner Mangaluru, who allowed the appeal and set aside the order granting the land in favor of the informant. The said order was challenged before the Deputy Commissioner, who dismissed the challenge the appeal preferred by the informant. The order of the Deputy Commissioner was also challenged before KAT, and the same is pending consideration. But since KAT refused to grant any interim order in favor of the informant, the respondent has approached this court by filing a writ petition, also pending consideration. But no interim order is passed in favor of respondent number 2, either by KAT or by this court. On the basis of these facts, the learned counsel, the senior advocate for the petitioner, contended that this is the root cause for the informant to lodge a false and vexatious complaint, making all sorts of allegations against as many as 18 persons, and thereafter giving the further statement stating that none of the eyewitnesses referred to in the information have ever seen, have ever identified any of the 3 persons who were only present at the spot. They have also not seen any overt act committed by even the unknown 3 persons referred to in the further statement. But in spite of that, the charge sheet was going to be filed against accused numbers 1 to 5, stating that it was accused number 1 to 3 who have committed the offense at the instigation of accused number 4 and 5. Prima facie, it is clear that the complainant is bent upon to arm twist the petitioners by filing the false complaint under the special enactment, which is in clear abuse and misuse of the provisions of the Act. Next, Learned Senior Advocate placed reliance on the decision, on the decision of the apex court in Sarabjit Kaur versus State of Punjab, 2023, 5 SCC 360, wherein the apex court has considered the improved version of the case made out by the complainant when there was no allegations made in the first information at the beginning, and formed an opinion that it was an idea of the complainant to convert a civil dispute into criminal one and to pressurize the accused for return of the amount allegedly paid. Under such circumstances, it is held that the criminal courts are not meant to be used for settling the scores or pressurize parties to settle civil dispute, and therefore, Learned Senior Advocate would contend that the criminal proceedings in the present case is liable to be quashed. He has also placed reliance on the decision of the apex court, decision of the coordinate bench of this court in Chiklal Patel versus another 2023 SCC online Karnataka 47, where the court has observed that the accused were in possession of the property for at least 50 years, and they were in peaceful possession, enjoyment of the land. They never wrongfully occupied the land belonging to the member of scheduled caste or a scheduled tribe. Under such circumstances, it was held that none of the provisions invoked by the informant, either under IPC or under the special enactment, are applicable to the facts of the case. Under such circumstances, it was held that it was a classic illustration misuse of provisions of the special enactment and the penal provisions under IPC, and it is sheer misuse and abuse of process of law. Accordingly, the criminal proceedings were quashed. Placing reliance on this decision, the Learned Senior Advocate contended that it is yet another classic case where the complainant is bent upon to harm twist and bend the petitioners to make wrongful gain in his favor. Since it is in abuse of the process of law, the petitions are to be allowed and the criminal proceedings is to be dropped. Per contra, Learned Counsel for respondent number Respondent number 2, opposing the petition, submitted that admittedly there is civil dispute between the parties. Even after investigation, the charge sheet was deemed to be filed against the petitioners, making specific allegations against accused number 1 to 3, and also stating that it was at the instance of accused number 4 and 5. When such prima facie materials are placed before the court, it is a matter for investigation, a matter for trial, and the trial court will form an opinion as to whether the petitioners are liable for conviction or not. But it is premature at this stage to quash the criminal proceedings, simply because there is civil dispute between the parties. Under such circumstances, she prays for dismissal of the petition. learned XGP submitted that there was serious allegations in the first information filed by the. But however, during investigation, it was found that it was only accused number 1 to 3 who have committed the offence as stated in the charge sheet at the instance of accused number 4 and 5. Accordingly, the charge sheet was going to be filed and placed for passing the appropriate orders. There is the materials on record point for consideration. My answer to the above point in the affirmative for the following reasons. The respondent number 2 as informant filed a detailed first information making specific allegations against accused numbers 1 to 5 and 13 other persons for having committed the offence punishable under section 143, 147, 147, 447, 427, 504, 506, section 149 of IPC and section 31 or 31S of SC/ST Prevention of Atrocities Act. Even though it is stated that the incident had occurred from 6 p.m. on 12/1/2020 till 4:30 a.m. on 13/1/2020, the first information was received on 13/1/2020 at 6 p.m. The typed first information was going to be filed, making very serious allegations against accused numbers 1 to 5 named in the FIR and 13 other persons. The allegations made in the first information is described above as facts of the case. Such as the allegations made against the accused named in the FIR. Their reading of the FIR, the first information, gives an impression that the informant, his wife and daughters are the eyewitnesses and they are the victims, as accused numbers 1 to 5 and 13 others were armed with the deadly weapons and committed the heinous offense, including destroying 250 acre plants. However, the informant, his wife and daughters, who are the only eyewitnesses according to the first information, have given their further statement on 16/1/2020, stating that there was some mistake while filing the first information in narrating the true facts of the case. He states that he is in occupation of 1.61 acres of land in survey number 139/1B, which is a government land, and the same was allotted in his favor. Accused number 5 is also claiming the land in question. However, the informant states that he had planted about 330 acre plants, 250 acre plants in the land which was in his possession. The accused were running granite business by the side of the said land, and they were holding threats to the informant and his family members to vacate the land and hand it over to them. He also states that the accused had challenged grant of the land in favor of the informant before the Assistant Commissioner Mangaluru, who ordered to maintain status quo. As per order dated 27/12/2019, the informant and other two eyewitnesses specifically state that on 12/1/2020, on 13/1/2020, at 2 in the midnight, in the early morning, he heard some noise outside, but there was no electricity. When he came out of his house, he found 3 persons moving in the courtyard, but he could not identify them. Even when his wife and daughter came out, even they could not identify those persons. They are very much afraid, and they went inside and closed the door. In the morning, when they came out, they found that the areca nut plants were destroyed. Later, he came and met his advocate at Opinangadi, who asked the informant as to whether he is having any doubt against any of the persons who might have committed the offense. The informant informed the name of accused number 1 and 5. He also referred to the name of Venkatramana Bhatt and Lalita, who are the in-laws of accused number 1. On the basis of such information, the advocate has prepared the first information, for which he signed and filed it in the police station. The informant further states that Lalita and Ganesh Chandra states that there is reference to Lalita and Ganesh Chandra in the first information, but they never came near his house nor committed any of the offense. He reiterates that 3 persons who were noticed in the moonlight, but he nor his family members could identify any of them, but he suspects that accused number 1 must have damaged the areca nut plants and caused loss of rupees 50,000. Now the charge sheet was came to be filed by the investigating officer that accused number 1, 4, and 5, at the instance of accused number 2 and 3, have came in a Toyota, in a Etios car bearing registration number KA05 MP 4771, destroyed the 250 arecan plants and caused loss of rupees 50,000. And thereby they have committed the offense as stated in the charge sheet. If all these materials are taken into consideration, it is clear that even according to the informant, there was absolutely no basis for making such a specific allegations against accused numbers 1 to 5 and 13 other persons in the first information. Only on suspicion, such a first information was filed. However, very serious allegations with the specific waiver tax are alleged against the accused, when there is absolutely no basis for filing such first information, making specific waiver tax said to have been committed by accused number 1 to 5 and 13 others referred to in the first information. I am of the clear opinion and when all the 3 eyewitnesses said to have witnessed the incident have given their statement before the police, stating that even though they noticed 3 persons moving around in the moonlight, they could not identify any of them, and immediately they gone inside and closed the doors. It is sheer misuse of the process of law by the informant against the petitioners for the reasons best known to him. Next. Admittedly, the informant has claimed 1 point so and so acres of land in survey number so and so of Perne village, which was granted in his favor under Akrama Sakrama scheme. It is also admitted that accused number 5 challenged the said grant before the Assistant Commissioner by preferring an appeal. The said appeal was allowed by the Assistant Commissioner by passing an order in favor of accused number 5, which was challenged before the Deputy Commissioner, who dismissed the claim of the informant. The order of the Deputy Commissioner is challenged before KT, and the same is pending consideration. It is also admitted that KT refused to grant any interim order in favor of the informant, and therefore the informant has approached this court by filing a writ petition, which is also pending consideration. All these admitted facts flinchingly go to show the intention of the first informant in filing the first information, making specific overtax against so many accused persons, and later stating that neither he nor his wife or daughter have ever seen any of the accused persons, and that there were only 3 persons moving around, but none of them could be identified by them on the date of incident. Under such circumstances, I am of the opinion that the petitioner has filed the first information, making very serious allegations with specific overtax, alleging that each of the accused were armed with deadly weapons, only to arm twist and bend the petitioners and to succumb to his demands, as there is dispute with regard to the land said to have been, which was initially granted in his favor, which was claimed to be set aside by the Assistant Commissioner. The Honorable Apex Court in Sarabjit Kaur considered a similar facts of the case and held in para 13 as under. The coordinate bench of this court in so and so considered similar facts of the case and held in para 22 and 23 and 27 as under. In fact, the facts of the present case, which is much more apparent as regards the misuse of the thousands of IPC as well as the SCS to prevention of atrocities. I do not have any shred of doubt about the intention on the part of the informant in filing such complaint and the investigating officer filing the charge sheet alleging offense against the petitioners. When the criminal proceedings initiated against the petitioners is the product of misuse of the process of law. It is the duty of this court to quash the same to avoid dash dash. Therefore, I am opinion that the criminal proceedings initiated against the petitioners is liable to be set aside. Accordingly, I answer the point in the affirmative. Proceed to pass the following petition is allowed, so and so, so and so, so passed. Yes, both the petitions allowed.
Obliged, my lord. Great.
That on submission, my lord.
Yes, sir.
My lord, serial number 19 in the second list, madam. My lord, somebody has mistakenly taken a time. I am for the petitioner. In that matter, my lord, entry mode has to be extended, my lord.
Yes. Yes, sir.
Much obliged.
Entry mode. I don't know.
ಮೇಡಮ್ ಆ ಪಾಸ್ವರ್ಡ್ ಕಳಿಸ್ತೀರಾ ಮೇಡಮ್? ಮೇಡಮ್ ಪಾಸ್ವರ್ಡ್ ತೊಯ್ತಾರಾ ಮೇಡಮ್?
Password. Finally ಇರುತ್ತೆ. Final ಇಂದಿರಾ ಮೇಡಮ್ ಸಾಮಾನ್ಯ Court matter, list one, serial number one, Abhishek K.
When the counsel for the petitioner is absent, no representation, even when the matter is passed over thrice. When it is physically submitted, let the nodi ಅದರಲ್ಲಿ FIR Quashing ಹೇಳಿದ್ದಾನೆ. The petition is filed. When the CGP submission that even though allora prayer nodi petition is prayer. Even though the petitioner has sought for quashing the FIR, now the investigation is completed and charge sheet is filed. The matter is pending before trial court. Submission is closed and the petition is dismissed. Next.
Serial number seven, Nishant Devi.
Before the petitioner, madam.
Done.
Let's have complied with the office objections.
The petitioner submits the case complied with the office objections office to verify. Yes.
I filed an application for dispensation, madam.
Orders, notice, issue notice.
Comply.
Yes.
Serial number nine, Gangabai.
In this case, the charge sheet has not been framed so far.
No, it is his submission that he has pleaded guilty.
Lord, we have filed on the protest petition, we have filed petition, my lord. There was a B report filed in the above matter, and they have filed a PCR. And on the PCR, we have filed we have challenged the order of the PCR, my lord. There is no charge sheet has been framed. It is for evidence.
B report is filed by the police.
B report is filed by the police.
Whether that was accepted by the court,
Yes, my lord, it was accepted by the court, and a PCR was filed.
PCR who filed?
Milords, with your lordship's kind permission, Milords, if I may submit, Milords, some inconvenience because of which I could not come in person. But if I may submit, Milords, the B report was filed. They challenged it by way of a protest memo. Milords, subsequently cognizance was taken, and again, Milords, it is posted for evidence before charge. To the best of my knowledge, Milords, there is no charge sheet that has been filed. Milords.
No.
The internet melody is showing us closed, case is closed. No, it's posted for.
No, Leonard, HCGP submits that as per the information, CIS information is that the case is closed.
Evidence is posted for evidence.
Milords, case is closed. Milords, may I request it may be posted a couple of days later, Milords, we'll check it up and come back, Milords, because once it is withdrawn or closed, Milords, I will not be in a position to recall, Milords, or reopen the case. May I request it be posted?
Submission made in the morning, that is why it is passed over.
Milords, but we could not get the charge sheet. The difficulty is we are unable to get the charge sheet from the magistrate court and it's not there. Milords. May I request at least 2 days time?
Closed, where is the question of filing charge sheet?
Milords, no, Milords, it's not closed, Milords. The case is posted again next month, Milords.
It's posted on
there on 5th of September.
Leonard Counsel for the petitioner. Submits. You also verified.
Yes.
Leonard Counsel for the petitioner submits that the matter is still pending before the trial court. However, both the Leonard Counsel undertake to verify the present stage of the matter. Leonard Counsel for the petitioner undertake to comply with the office objections before next date of hearing. List finally as a last chance. Immediately you have to comply with the office objections.
Yes, ma'am.
Needful will be done.
Yes, ma'am.
Next.
Number 11, shakes out.
Obliged.
Serial number 11, shakes out.
It is same.
This case number charge sheet is filed. Number.
ಇದ್ರಲ್ಲೂ ಹಾಗೆ serial number 1 ಹಾಗೆ dismissed. Next.
Serial number 16, Kumbugi Prabhugod.
Again, counsel for the petitioner.
They have complied the office objection.
My lordship objections are complied with the office to verify. Yes. If
My
complied
lordship
with,
permits not, sir.
Huh?
My lordship permits not, sir.
You know?
IA is there, not, sir. I am seeking.
Noted. Next time noted. Next.
Date.
ಕೊಡ್ತಾರೆ ಆಮೇಲೆ ತಗೊಳ್ಳಿ. Yes, issue notice. Next.
Serial number 19, Bhargav Ji.
Madila. Counsel for the petitioner is absent, no representation. Even though matter is passed over thrice and again called at 2:40 PM. Or sheet dated so and so reads as under. It appears so and so. Dismissed.
Serial number 21, Raghunath Reddy.
Counsel for the petitioner is absent. Counsel for the petitioner is absent when the matter is called for the third time. The case is listed for the seventh time for complying the office objections. The order sheet dated so and so reads as under. In spite of that, there is no compliance. Dismissed.
Serial number 22, Karnataka.
Counsel for the petitioner is absent when the matter is called for the third time at so and so. The case is listed for the eighth time. The petition was filed in the year 2019 and it is listed for the eighth time for complaints of office objections. Order sheet dated so and so reads as under. In spite of that, so and so. Dismissed. Next.
These two, serial number 9, Satyanarayan Telecast.
Paid. Counsel for the petitioner submits that PF is paid for issuance of notice. Office to verify. If PF is paid, issue notice. Next.
Serial number 16, Rajendra K.R. Gopal Krishnamurthy.
For petitioner in this case, Lord.
Yes. Your objection is company is not a party.
Yes, Lord.
Before the trial court. Now they are willing to array the company as one of the accused.
Lord, at this stage, impleading application in the High Court.
It is a
cannot.
procedural lapse.
Yes,
At
Lord.
any stage, it can be cured.
Lord,
No bar for that.
Lord, as per the judgments of the Supreme Court, it may say that impleading.
Company is not a party, definitely the accused is entitled for acquittal.
Yes, Lord.
Whether the Supreme Court says it cannot be cured.
Lord, and the check is issued to the company, Lordship, not for the individual
That is why he
capacity.
is willing to.
And it is a security based, Lordship,
That all
kindly.
defense you can take before the trial court. I am not considering the merits of the case. I am only concerned with this only one point.
My Lord, and the check is issued to the Star Insurance Star Engineering Company, but Sumuka has filed the case before the court, Lordship.
Defense is available.
Yes, Lordship. If
Why should I consider about the defense of the accused? This is not the stage to consider the defense.
if the IA is allowed, Lordship, the final disposing may be taken place based upon the merit, Lordship. The case may be disposed based upon the merit, Lordship.
This one,
Yes,
please
case.
argue the matter. Merits only I am saying,
Yes, Lordship.
not
Yes.
out of that. Yes, what are the grounds?
My first ground is that company has not made party, Lordship, and the work order given to the Star Engineer Company, Lordship. Quotation given by the Star Company, but check got misused by the Sumuka Company. You can, Lordship, kindly see the annexure K. Annexure K, Lordship,
What is
page
your
number
defense? You have
38.
given the blank check to Star Company.
No, Lord, Star, it's not, it's a security.
Name, full name of the company.
Star Insur. Yes, Lord.
Where you have taken such defense?
Lord, annexure K, Lordship.
Alla petition ಅಲ್ಲಿ ಏನು grounds ಇಲ್ವಾ?
ಇದೆ, Lord.
Where is the ground?
Para number 4, Lordship. May I-
Star Engineers.
Yes, Lordship. Page number 5, para number 4. Miss Star Engineer was not completed and therefore no amount was due, and whatever the amount was
Because
due
you
was.
are dealing with the Star Engineers.
For the supply of fabrication and erection of structural material, Lordship. Order was placed on 15/10/2019.
Fabrication and
Fabrication and erection of structural materials. Erection of structural materials.
how many issues here, how many checks you have issued?
Only one check in question, Lordship.
Blank check.
Check was issued for the security purpose for the completion of the work,
Blank check.
Lordship. Yes, Lordship.
Why blank check? You are the managing director of a company.
Yes.
Yes, Lordship.
You issue blank checks.
It's not a security purpose we issued check, Lordship.
Hmm.
It's not a debt oriented check, Lordship. It's not legally bounded.
Even then blank check also give rights to 138. That is the settled position. You cannot avoid.
Yes, Lordship.
You don't be under the impression that any number of blank checks can be issued as a bus ticket. You are liable.
And the amount,
Law is very well settled.
yes, Lordship. And the amount is already paid to the company, Lordship. The remaining amount,
Prove that defense before the trial court.
yes, Lordship.
Yes.
And kindly see the annexure K and L, Lordship. It's a to the Star Engineer Company we have given the
Yes,
work,
that is your defense. You
Yes.
have to prove it.
work order and annexure K page number 38 and annexure L page number 41.
Yes. You
To
have to
Star-
produce all these documents before the trial court and to probabilize your defense. Simply because you have taken a defense, it is not the position of law that the criminal proceedings is to be quashed. No law says so.
Milord,
The trial court has to consider all those defenses.
and for the legal notice also, Lordship, we have replayed that scene.
Yes, then you will
everything.
have a very strong defense. Go before the trial. Those grounds cannot be grounds for allowing the petition.
Milord, the section 141 of the act itself does not attract in this case, Lord.
That is why he is impleading now the company. He is curing the defect.
Please,
Your major grievance is that
correct.
Yes, Lord.
only MD is arrayed as accused, not the company. Now he is curing the defect. I will permit him.
Please.
First. So what? Petitioner.
Milord, if they're
The
permitting and they're impleading also, Lordship, their company is also not taken in.
That is
for-
your defense, Amma. That is
Correct.
what I am saying. Repeatedly, I am saying. Why don't you understand?
Milord, if it is,
If at all that is your defense, you have to prove.
yes, Lordship.
You may
and-
take 101 defense, but you have to prove it. Simply because you produce some document, I cannot rely on that and
Milord,
dismiss the-
whatever the amount is due from the company, we already pay the expenses, additional amount also
Fine,
we have
yes, yes.
we have paid, Lordship.
petitioner being the accused in CC 842 of 2021 on the file of the Leonard Additional Civil Judge and James C. Malur for the offense punishable under section 138 of NA is before this court seeking to quash the criminal proceedings instituted against him. The facts of the case are that the respondent as complainant filed a private complaint in PCR 12 of 2021 against the petitioner alleging commission of offense punishable under section 138 of NA. The trial court took cognizance of the offense. Registered CC number 842 of 2021. Petitioner is seeking quashing of the criminal proceedings initiated against him. So and so. Then counsel for the petitioner contended that the petitioner is the managing director of a private company by name Messrs. Gayatri Structural and Roofing Private Limited. The company is not arrayed as the accused. Under such circumstances, as per under such circumstances, in view of section 141 of the Negotiable Instrument Act, the complaint is liable to be dismissed. Next para. Counsel also submitted that the check relied on by the complainant was never issued in favor of the complainant company but it was issued in favor of Star Engineers for supply of fabrications and erecting the structural materials. The check was issued as a security, and it was a blank check with the signature of the petitioner. Under such circumstances, the complainant could not have maintained the complaint. Therefore, she prays for allowing the petition by quashing the criminal proceedings. For control and counsel for respondent opposing the petition submitted that the check in question was issued by the petitioner towards discharge of legally enforceable debt. However, by mistake, the company, that is Mrs. Gayatri Structural and Roofing Private Limited, was not arrayed as one of the accused before the court in compliance of section 141 of Negotiable Instrument Act. The defect is curable one, and it will not go to the root of the matter. Under such circumstances, the application IA1 of
24.
24 was claimed to be filed before this court seeking permission to implead Mrs. Gayatri Structural and Roofing Private Limited as one of the accused before the trial court. Hence, he prays for allowing the said application. He submits that since an interim order is in operation, the trial court will not accept any such applications for consideration. Therefore, he prays for passing appropriate orders on the application. On merits, he submits that the defense taken by the petitioner could not be considered at this stage by the court, as it is for the trial court to consider the same after full-fledged trial. Accordingly, prays for dismissal of the petition. Review the materials, point for consideration. My answer to the above point is in the negative for the following reasons. IA1, okay. IA1 of whether application IA1 of 2024 is liable to be allowed. Next, petition. The petitioner, being the accused in the CC number so and so, is seeking to quash the criminal proceedings mainly on two grounds. The first contention raised by the petitioner is that the company, that is Mrs. Gayatri Structural and Roofing Private Limited, of which the petitioner is the managing director, is not arrayed as an accused. Under such circumstances, the accused is not liable. Under such circumstances, petitioner is not liable for conviction in view of section 141 of Negotiable Instrument Act. The second contention that was raised by the petitioner is that the check in question relied on by the respondent was in fact issued as a security by the petitioner in favor of Star Engineers for supply of fabrication and erection of structural materials. The said check was misused by the complainant, and therefore section 138 of NI Act is not made out. The respondent has filed IA1 of 2024 seeking permission to implead. the respondent has filed IA-1 of 2024. Badallappa. Huh? One 2024 is filed by the respondent under section 482 of CRPC, seeking permission to implead Messrs. Gayatri Structural and Roofing Private Limited, of which the petitioner is the managing director, as one of the accused before the trial court. It is the contention of the learned counsel for the respondent that the complainant is a layman who does not know the consequences of law, and he realized that there is a mistake in not arraying the company as one of the accused. The said mistake is a curable defect, and therefore the complainant wants to cure the defect by arraying the company as one of the accused. The position of law that the defect pointed out by the petitioner is a curable defect is not disputed by the learned counsel for the petitioner. What is the stage before the trial court? Trial has not commenced.
Not yet commenced.
Admittedly, trial before the trial court has not yet commenced. Under such circumstances, no prejudice would be caused to the petitioner if the application IA-1 of 2024 is allowed, and the company of which the petitioner is the managing director is arrayed as one of the accused. Moreover, it is the specific defense taken by the accused that in the absence of the company as one of the accused, the petitioner is not liable for conviction in view of section 141 of Negotiable Instrument Act. Under such circumstances, I deem it appropriate to allow IA-1 of 2024 and permit the respondent to array Messrs. Gayatri Structural and Roofing Private Limited as one of the accused before the trial court in CC number so and so so and so. Next, the next contention raised by the learned counsel for the petitioner is that the check in question was issued as a security, as a blank check in favor of Star Engineers for supply of fabrications and so and so. The said blank check was misused by the complainant. And the counsel contends that several documents are produced before this court in support of such contention, and the same are to be taken into consideration. At the most, such contention could be the defense that could be raised by the petitioner before the trial court during trial. This court is not sitting as a trial court to consider the defense that could be raised by the petitioner before the trial court. Hence, I am of the opinion that the said contention raised by the petitioner cannot be the ground to quash the criminal proceedings. It is for the trial court to consider the contentions of both the parties and to form an opinion as to whether the complainant is successful in proving the guilt of the accused beyond reasonable doubt or not, and whether the accused is successful in probabilizing his defense. Hence, I am of opinion that the petition is liable to be dismissed. Accordingly, I answer issue number 1 in the affirmative, 2 in the negative. Proceed to pass the following. Petition is dismissed. IA-1 of 2024 is allowed for Madhya Bhakti. IA-1 of 2024 filed under so is allowed. Respondent is permitted to array so and so then relevantly so and so as one of the accused before the trial court in CC number so and so so and so. Action is dismissed.
Great.
And you can
230 matter, serial number 30, Prasanna Kumar S, Sriranga, H.N. Vasudevan.
In 580, my lord, we have completed our submissions. I have to give certain clarifications, my lord, in respect of crime number 486.
I have to argue on 580.
Yes, now you have, I have completed. My lord, only one submission, my lord, on 580 before my learned friend starts. It could have a DRT order. On this 580, my lord, this is my small additional submission.
This challenge in the High Court.
Other
Interim order.
there appears to be an interim order on this.
Hmm.
It appears, my lord, there was a judgment of the DRT, 1 Chennai, which was, my lord, pursuant to an order of this honorable court. This honorable court, my lord, if your lordships would kindly have page number 6, my lord, the pagination is in the bottom. On page number 6, my lord, para 1.8. On 12/3/24, when the connected so-and-so was listed, the learned counsel for the parties have brought to the knowledge of this tribunal concerning the direction issued by the Honorable High Court of Karnataka so-and-so. Photocopy, the copy is still not received with the photocopy of furnished by the applicant. It is found. Learned counsel for the applicant and an order dated DRT1 Bangalore not to this tribunal Chennai by registry of the Honorable High Court of Karnataka. However, the order reads, my lord, the order of our Honorable High Court of Karnataka, my lord, is extracted on page number 7. Precisely, our Honorable High Court, my lord, said DRT2, my lord, dispose of that section 17 petition which was filed by the complainant. My lord, disputing the liability. I'm just producing this, my lord. I'm not saying that, my lord, this has attained finality. For the minimal purpose, I am producing this judgment is, the order of the DRT is, if your lordships could kindly see, my lord, the case before the DRT did hinge, my lord, wholly on the basis of, my lord, this, if your lordships could kindly have page number, my lord, 9.
Now this TSA 9 of 2023 filed by Messrs. Metal Closures.
Yes.
Was dismissed.
Yes, DRT dismisses their case. My lord, before the DRT, the surface action, my lord, was challenged. One of the main grounds for the to lay challenge, my lord, against the surface action was, my lord, all this story.
Yes.
Which is, my lord, available in the complaint.
Same contentions were raised.
Same contentions, which was appreciated by, my lord, the DRT. DRT, my lord, did not get into, my lord, finding whether the contentions raised, my lord, the complaints.
This order is challenged.
This order, my lord, appears to have been challenged, my lord, before this honorable court, and my learned friend says that there is an order of stay. My lord, I am not on that. I'm only on that, my lord, the case of the complainant, my lord, who was the applicant before the DRT is extracted in this order. The case of the complainant, the applicant before the DRT, totally hinged upon, my lord, this criminal cases. It's because all these things happened in the company. There is all these criminal acts, etc., happened in the company.
Where it is stated.
If your lordship could kindly have page number 9, my lord, of this order, paragraph number 2.0, the genesis of the case. My lord, I'll just skip over. If your lordships would kindly have on page number 13, my lord, which extracts the genesis. My lord should kindly have page number 13. In fact, my lord, page number 11 also, paragraph 2.7 in the bottom on page number 11. The applicant company filed a complaint before SHO Ashok Nagar, Bangalore regarding manipulation of accounts on 16/11/2015. Lord, this is that first crime, 486. of the defendant was requested by a letter dated 31/7/2015 with a request to furnish the details and information of its account. The applicants were shocked. Then it said, my lord, after that, paragraph 2.13, 2.13, page number 13. It is submitted that the applicants, after filing of the case, intimated by a letter dated 25/5/2016 intimating the SBI that the security guards deployed by SBI were caught stealing the stocks. SBI was asked to conduct joint stock verification at Bangalore, Kunigal and Himachal Pradesh units, and the same was completed. On 3/9/2016, a complaint was lodged with SHO Subramaniapura Police Station regarding the theft of material by the concurrent auditor, bank officials, and security agency, for which FIR 580 is lodged, consequent to which the charge sheet is filed in CC so and so, wherein it is stated that the loss of rupees so and so is reported. It is also pleaded in FIR 486 of 2015, a charge sheet is filed accusing the consortium banks having deliberately approved the RTGS NEFT transactions without the signatures of authorized signatory, and the loss is reported at 63.4 crores. My lord, this was the ground on which the SARFACI proceedings were attacked. Your lordships could kindly see, my lord, the findings, how the Honorable DRT dealt with it. For a moment, my lords, may kindly have page number 29, paragraph number 8.7. What is appreciated, my lord, factual position by the DRT. It is also pertinent to note that the defendant bank had furnished the minutes of meeting of the Joint Lenders Forum held on 22/7/2014. The same is perused. It shows that Mr. Prashant Hegde, chairman of the applicant number 1 company, and one Mr. Mahesh, GM Finance, had participated in the JLF meeting of the consortium banks, in which 3 officials from the defendant bank also participated. The minutes of the meeting makes it very clear that the chairman of the applicant number 1 company had opined in the JLF. It is noted therein. My lord, I will not trouble your lordships reading that. And finally, what, my lord, the DRT does. If your lordships would kindly now have, my lord, page number 35. Paragraph 8.18. Paragraph 30, page number 35, my lord, paragraph 8.18. The contentions of the application, the written argument is that the company had replied to the demand notice pointing out certain facts. One of the grounds on which the possession notice is challenged is that the defendant bank has not considered the reply given by the borrower. The reply was based on 3 points. Lord, this is their defense to the SARFACI. First point is that there has been a fraud played by CFO of its company with collusion of officials of various consortium banks till 2010. There was no proper authorization of the transactions. It is also their case that a charge sheet is filed in FIR number so and so, which results in a loss of 78.50 crores. On this ground, the company has sought for absolving itself the liability in transaction. It is also pleaded that there has been a theft for which the charge sheet is also filed. Then, my lord, paragraph number 8.19. Though the DRT wouldn't get into, my lord, the correctness or otherwise of the complaints, DRT says that if you have filed a criminal case, we will not look into that. We will only look into whether the action taken by the banks under the SARFACI meets the procedure or not. My lord, on that count, their claim was dismissed. The appeal was dismissed. Therefore, my lord, my humble submission is a minimal point which I want to make out, my lord, by placing this order was that the entire, my lord, story of these 2 complaints, crime number 486, which, my lord, is first in the order of time. Secondly, crime number 580, my lord, is later. Both these complaints, my lord, in succession, my lord, aimed at, my lord, making out certain grounds to somehow or the other, my lord, to lay a challenge to the recovery option that was, my lord, recovery action that was opted by the banks. So the reason for all these complaints, my lord, basically is that how best we can thwart the recovery by, my lord, pushing guilt on somebody else. Lord, I'll just, my lord, ಇದು ಯಾವ ಕೇಸ್ಗೆ ಈ ಎರಡೂ ಕ್ರೈಮ್ ನಂಬರ್ 580ಗೆನಾ If my lord may I just pass on the brief notes, my lord, as your lordship said directed. My lord, both these pertain to my lord crime number 580. My lord, under crime number 580, we have maintained two different petitions. That is the reason, my lord, two notes are placed. This captures, my lord, date-wise. ಅವಿನಾಶ್ ಕತ್ವಾರೆ ಇದಾರ ಇದರಲ್ಲಿ. The first tabular, my lord, tells about, my lord, the petitioner, what is he, etc. The second tabular, my lord, would give, my lord, the general details of the case. My lord, the first tabular, my lord, would be distinctly, my lord, important insofar as the petitioners in particular are concerned. The second tabular, my lord, could be common for all the petitions, because, my lord, it deals with the entirety of this. So I'm so grateful, my lord. One, two, three, four. What are the cases?
This one in the list.
Yes.
Can I request my lord to take this judgment to the DRT first?
You are representing the respondents in all the 5 cases.
Lord, I think the first 5. Mr. Mandigi appeared in the.
Mandigi ಅವರು ಇವತ್ತು ನನಗೆ my lords had particularly said I have to answer certain points in the presence of Mr. Mandigi. Mr. Mandigi.
The purpose will
ಹೌದು
not
ಹೌದು
be
ಅಲ್ಲ
served.
ಇವತ್ತು I believe Mr. Mandigi is not there. My lord, Mr. Dhyan can continue on 580. But in so far as, my lord, other points, my lord, which have been raised by Mr. Mandigi, particularly with reference to crime number 486. My lord, Mr. Mandigi is not there. My lord, whenever Mr. Mandigi is there, my lord, I'll keep my presence.
We have to coordinate.
ಯಾವತ್ ಬರ್ತಾರೆ ವಾಸು ಹೇಳಿದ್ರೆ ಮೊದಲ
He's in Dharwad today, he said.
Excepting
He's in-
27th, my lord, I'm not here.
He's in Dharwad today,
Okay.
so
No, if you can inform him when he is coming.
Excepting
On the
27th, my
day,
lord, I am
fix
here.
it.
I'll inform him. As soon as if the matter gets concluded by now, I'll inform.
Today it is to be adjourned to some
I'll inform
particular
that.
day.
In the course of this thing, I'll inform.
ಇದೆಲ್ಲ ಏನ್ ಹಾಕಲ್ಲ. ನೋಡೋಣ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಹಾಕಿ ಇದೀವಿ ನೋಡಿ first. ಆಮೇಲೆ ಅವ್ರು inform. Yes,
ನಾಳೆ ಇರೋ ಹಾಗಿದ್ರೆ ಒಳ್ಳೇದು, ಒಂದು ಕಂಟಿನ್ಯೂಟಿ ಇರುತ್ತೆ.
may be difficult.
ಆಗ್ಬೋದು. Excepting, my lord, 26th and 27th, where I'm
Him
not here.
inform the date to the court of.
Anyhow, my lords have heard in part, my lord, the matter will remain before your lordships, my lord, any date convenient.
Yes.
My lord, since I have completed my submissions, my lord, in 580, lord, I may take leave, my lord,
Your presence is not necessary when the senior advocate.
I like to, my lord, I'll ತಗೊಂಡಿದ್ದಾರೆ ಇಂದ್ರಿ ಸಾಹೇಬ್ರು.
I don't know if the same.
Yeah,
thing
my lord,
happens
it's a
here,
pleasure to hear my friend always.
Not for any other reasons.
I understand. My lords may kindly allow me, my lord, my lords may kindly allow me 5 minutes, my lord, I'll resume by then, my lord.
It is only for that reason.
I understand that. I understand, my lord. In
Afraid
fact,
of the
hearing my
difficult-
friend is, in fact, my lord, I
He
understand.
says something,
I understand that.
you say something
Howದು,
else.
howದು.
When you address the argument, he will not be there. When he addresses the
ಹೌದು,
argument,
ಹೌದು.
you will not be there.
ಹೌದು.
How to reconcile?
ಹೌದು. I understand that. But there is
the
one.
That's the advantage of being on this side, my lord.
Meaning of a particular word is disputed.
For that, I am carrying some literature. I'll place it. My lord, only 5 minutes, my lords. In the meanwhile, my lord, anyhow, my formidable friend, Mr. Murthy, is here.
Oh, I'm not insisting you, but.
I understand that. My lord. My lord, I wish to remind, my lord, but for 5 minutes, my lord, there is a Supreme Court direction matter. Is
You
before
can
your
go.
lordship
You
justice
can-
Indiresh, my lord, I'll mark my presence and my lord, I'll resume.
You can go.
My lords may kindly allow me for 5 minutes. So great.
So now you are representing the respondent in all the 5 cases.
31, 2, 3.
30,
30.1, 30.2, and 30.3. They relate to 580. In
How many?
4 cases, my lord. The first 4 cases.
1 minute.
The raising of 580 FIR. Second, this is the raising of FIR 580.
Yes, first 5 cases.
First, not not in 30.4,
Huh?
they have not arraigned the complainant as a party. Okay, that's okay. But it'll answer that as well. 30.4.
Prasanna Kumar.
I appear in 30.1 and 30.2, my lord. I'm the petitioners in 30.1.
30.4.
Aure, Shyam sir. 30.4, you've not arrayed us as a.
30.4, huh?
Right.
Vendra, adಕ್ಕೇನು application ಹಾಕ್ಬೇಕಲ್ಲ. There must be a prayer. Yes.
But I want to start my submission, Lord, pointing out that the arguments of my learned friends, although extensive, is almost requesting your lordship to reappreciate everything, to practically appreciate all the evidence that is there, all the material that is collected, and then return an answer which practically may result in almost the lordship having to acquit them rather than quash a proceeding or close a charge sheet on that basis.
Yes.
My lord, at least from my limited understanding, my lord, your lordships will examine the charge sheet to see if material is available, on the basis of which prima facie there can be trial. Not to assess as to whether the truth has been established by virtue of the investigation. Of course not. There is one overarching argument which they have advanced, and that is section 32 of the Surface Act. Whether that will act as a bar.
Yes.
And if it does act as a bar, then of course, my lord, it is a situation which certainly is different. But if it is not a bar, and I think, my lord, we'll satisfy my lord as to how it is not a bar, in which event the proceedings, my lord, in my respectful submission, will have to continue against each of them.
Yes.
But before I do that, my lord, can I request, my lord, to kindly take the order of the DRT, because my learned friends started today's hearing referring to that order.
Yes.
Kindly see para 8.19, the only paragraph, my lord, which you ought to have possibly read. At page 36. It is common prudence and trite law that the proceedings under criminal law can run side by side. The two remedies differ in their content and consequence. The object of criminal law is to punish an offender who commits offense against a person or property of the state. Mere launching of a criminal prosecution or filing of the charge sheet herein upon the allegations made by the borrower company against its own employees and the alleged collusion of the bank officials cannot absolve the liability of the borrower to the lending bank. Bank cannot be prevented from recovering public money. Further, it shows that the management of the borrower company had not kept proper vigil, nor monitored the day-to-day affairs of its finances, allowed the CFO of its own company to meddle with the finances to the detriment of the company. The role of the lending bank in the management of the borrower is unknown, and the bank would have no role to oversee the management, administration, day-to-day affairs of its borrowers. On this ground that its CFO had resorted to malfeasance and embezzlement to the funds of the borrower, cannot give any right or to plead that the owners to repay the debt ceases, same cannot be accepted. What liability is there to the bank and what the officials of the bank have done are two different things.
Yes.
In any event, my lord, now the banks also have been directed to be impleaded as parties, as accused in the criminal proceeding by virtue of an order of this honorable court. And that is now there. Now, my lord, may kindly look at section 32 of the Surface. This order was then challenged by us, my lord, before this honorable court, and this honorable court has granted an interim order. Section 32, my lord, I'll read this. No suit prosecution or other legal proceeding shall lie against the reserve. 32, protection of action taken in good faith. The heading itself is the answer, my lord, to the argument advanced.
Yes.
No suit, prosecution, or other legal proceeding shall lie against the Reserve Bank or the Central Registry or any secured creditor, which is what they are, or any of its officers for anything done or omitted to be done in good faith under the Act. Therefore, my lord, the existence of good faith is almost a sine qua non for the applicability of the section. It didn't say that whatever you do, you are excused. It is almost like a pardon being granted, my lord, for anything under the sun. In my respectful submission, the requirement of good faith is implicit in this. And being a part of the section, if there is a clear, and I'll be able to demonstrate to my lord as to how they've conducted themselves, the officials of the bank have conducted themselves in a manner which goes against every principle of good faith. And they've acted in collusion with officials of the company in order, my lord, to ensure that all its assets are taken away. And a huge amount of assets has actually been taken away. Now, this, my lord, is the, maybe ultimately you may prove it, you may not prove it. But is there material today on the basis of which your lordships can conclude that there is prima facie material on the basis of which you can proceed? Therefore, my lord, in my humble submission, please see how this bank has conducted itself. If my lord kindly takes, I think 5159 of 2018. I'll take your lordships through the 5159.
Yes.
Can I request my lord to kindly come to first page 134 of the petition? This, my lord, is the 13-2 notice, the demand notice for payment. The demand notice for payment, my lord, under the Securitization Act can only happen upon the account becoming an NPA. It has to become a non-performing asset. Would my lord kindly come to the third paragraph of this notice? You have also acknowledged subsistence of the liability in respect to aforesaid credit facilities by executing confirmation of balances and revival letters and other documents from time to time. Operation of and conduct of the financial assistance credit facilities has become irregular, and the debt has been classified as a non-performing asset on 28/5/2014. Therefore, my lord, when they issued this notice on 12/8/2014, they said I was classified as a non-performing asset on 28/5/2014.
Yes.
And then a claim is made for repayment of this money. This is followed by, my lord, a possession notice which is issued. And this, my lord, will find the possession notice not found here. Please come to Annex 139. 139. Paper publication, but I'll also show your lordship the actual possession notice which is sent to us. If I'm filing that list of documents. Some of the documents will not be just filing before your lordships, which are part of the charge sheet. This is, my lord, at page 121, because that anyway is not very clear. The paper publication is not very clear, my lord. Page 121 is the possession notice. Para 2.
Yes.
The borrower guarantor having failed to repay the amount, notice is hereby given to the borrower guarantor and the public in general, undersigned, and please see the language, my lord, used, has taken possession of the properties described here and below an exercise of powers conferred on him under section 13(4) of the Act, read with rule 8 and 9 of said rules, and also the consent or authority given by other members of the consortium of banks, namely Punjab National Bank, Corporation Bank, and UCO Bank on 20th of February 2015. Now, my lord, this is the fact of them taking possession. And that is the same language published in the newspaper. When other banks will not take possession symbolically, the argument was this was only symbolic possession we took. We never took actual possession of the.
This section 13(4) and rule 8(9) enables them to take physical possession.
Yes, ma'am. They can take physical possession. As a matter of fact, the photos are also there on record, where they've taken possession, come there, put up the board. Page number 125. This, my lord, will come to page 126. This is dated 20th of February 2015. The date, my lord, your lordship will see is 20th of February 2015. That's the date on which the possession of the premises was taken.
What is written on that board?
This property is taken possession under Surface Act 2002. The same thing, my lord, lordship will find on the next page. At 127, when they again took possession in December of 2017, a similar board, it seems to be a standard board that State Bank of India puts up when it takes possession. They did it again because your lordship may recollect, in the interregnum, my lord, they said we are withdrawing the earlier action taken and we're restarting the action. But the fact, my lord, was, and it is always our case, that they had taken possession of this property immediately.
Yes.
And it is this possession, Lord, which ultimately resulted in all the other happenings which occurred thereafter. The theft, the removal of material, and the fraud that was played on us.
According to this, the possession was taken on 11/12/2015.
That is the second one, which is why I said, first, my lord, 20th of February 2015, if my lord sees the possession notice, at page number 121 and 122, the date is 20th of February 2015.
Yes.
122, my lord. That photographs are at 126. Then at 125, my lord will see another one on 14 December 2015. Now, what happened was they wanted to take immediate possession of the property, and obviously, my lord, certain officers were hand in glove with certain other officials within the company. So the first thing they did is they took possession. Prior to that, my lord, a certain various steps were being taken to create a whole story of how the stock is insufficient. The stock reporting was not correctly done. All of that, and thereafter, my lord, proceeding with this whole act of taking possession. And once the possession was taken, the entire factory premises came under the control of State Bank of India and its officials.
What the act says regarding taking physical possession?
My lord, 13(4) has been interpreted as a physical possession itself by the Supreme Court. I'll place that judgment. Possession itself. But if there is resistance, then you can go under section 14. My lord, may kindly see. And I'll show you, lordship, what they did after that. To get over all of these problems, (13)(4), my lord. In case the borrower fails to discharge his liability in full within the period mentioned in subsection 2, secured debt creditor may take recourse to one or more of the following measures to recover his secured debt, namely, A, take possession of the secured asset of the borrower, including the right to transfer by way of lease, assignment, or sale for realizing the secured asset. Therefore, the right to take possession is immediate.
Yes.
Then, Lordship may kindly look at section 14.
Yes.
14, where the possession of any secured asset is required to be taken by secured creditor, or if any of the secured asset is required to be sold or transferred by secured creditor, under provisions of this Act, secured creditor may, for the purpose of taking possession or control of any such secured asset, request in writing the Chief Metropolitan Magistrate or the District Magistrate, within whose jurisdiction any such secured asset or other documents relating thereto may be situated or found, to take possession thereof, and the Chief Metropolitan Magistrate, or the case may be the District Magistrate, shall on such request being made to him, take possession of such asset and documents relating thereto. Earlier, my lord, the understanding was that 13.4 is only symbolic possession. 14 is actual possession. That was what the Madras High Court held. Then it was challenged before the Supreme Court. Supreme Court said 13.4 is actual possession taking. If you are and find difficulty in taking possession, then you may move an application. It is up to the bank to move an application before the CMM or the district magistrate for a direction to use force or any means necessary to take possession of the property. Now, when I raised all these questions and pointed out, my lord, that actual possession had been taken and you've done all of these acts of malfeasance, misfeasance and theft, then when the second possession happened in December of 2015, they thereafter made an application under section 14 before the magistrate. And that is there in the memo of documents that I filed. It's there in the, I'm sorry, it's there in the petition, Lord, filed by them. (327), my lord, is that order which is passed after the second possession notice. (327) before the Chief Metropolitan Magistrate. My lord will see 29/12/2015 is when, is after that 7/12/2015.
Yes. What is the order passed?
That's the order. Please see my objections now, Lord, which I have filed, and I'd only request my lord to look at one paragraph, page 343. (343). This is my objection statement filed before the magistrate, where I've specifically pointed out in the middle, my lord. I'm sorry.
Page number?
Page number 343.
Yes.
In the middle, supervisory control and security. Please see after that, second time physical possession not permitted under section 14. Now, my lord, what is most shocking in the conduct of the bank and its officials specifically now is, my lord, the first 13.2 notice which my lord was pleased to see, the date of the account becoming NPA was specifically noticed. That is 28/5/2014.
No, what is the order passed by the learned CJM?
CJM to take possession, but no action was taken after that.
329.
329 is the order. But no possession was taken thereafter. The whole plan law was to make it appear as if they are taking possession for the first time, when they were already in possession.
Yes.
Now, my lord, if my lord comes back to page 134,
Yes.
we were classified, my lord, as a non-performing asset on 28/5/2014, when this possession was taken. Then, my lord, for some reason that no one can understand, that entire action taken under 13.2, action taken under 13.4, and the possession notice were withdrawn. And that, my lord, will find at page 142 of the petition itself. (142). They withdraw it in the possession. No, it says possession notice. Metal closure, so and so, so and so, so and so. And general public are informed that possession notice dated 22/2015, published in New Indian Express and Samyukta Karnataka on 21/2/2015 by the undersigned on behalf of the consortium of banks consisting State Bank of India, Punjab National Bank, Corporation Bank, and UCO Bank is hereby withdrawn.
Why that is done?
Beg your pardon, Lord?
Why that was done?
Now they say that it was done because UCO Bank had not issued a 13.2 notice by that time. They say it now. These are all documents, not internal documents. They're not part of the charge sheet. They're all produced now. And say that we took a decision. Now, they took a decision maybe. We don't know why they took a decision. But each of them, my lord, are in serious doubt. I'll tell you, lordship, why I'm saying this. Because all of them are now placed before the court as if these are, my lord, notifications issued by the government in the official gazette, and they are all documents which have to be believed straight away. We'll come to it, sir. First, let's see what all you've done. Then, my lord, please see, in this, there is a question asked. Let us look at this document also, my lord. Since my learned friend has produced, I'm sure it has some value to it. There is a question asked.
Which is the document?
This is, my lord, 140 that they have produced. This is all not part of the charge sheet. When it has come into existence, God alone knows. And I want your lordship to kindly see para number 2.
Yes.
The conduct of the account is irregular and the account was classified as NPA on 28/5/2014 by State Bank of India. Specialized mid-corporate branch Bangalore, and demand notice under 13.2 was issued by the bank on 12/8 before migrating the account to our branch. PNB large corporate classified the account as NPA on 36 and issued demand notice under 13.2. Corporation Bank JC Round classified the account as NPA on 10/12 and issued demand notice on 7/12/2014. Considering the major share of advance by these banks, about 70 to 80% advance under 13.4 initiated, and symbolic possession of assets pertaining to Bengaluru unit was taken on 22/2015 and paper publication on 21/2. In the possession notice dated 22, UCO Bank outstanding share of 15 lakhs was only mentioned. I'm sorry, my lord God.
Yes.
Subsequently, UCO Bank classified the NPA account as NPA in the books on 31/12 and issued demand notice on 26/2/2015. The possession notice was issued on 22 as a leader of consortium bank considering the major share of 80% of credit facilities by these banks, State Bank of India, Punjab National Bank, and Corporation Bank. Kindly give your opinion whether the possession notice dated 22/2015 is legally valid or it needs to be withdrawn. This apparently is a sudden question which came into their minds after all the action was taken on 10th of June 2015. Then not on the next page. This is reference to your note dated 10/6/2015. Facts stated there are assimilated for better appreciation of the case. Credit facilities have been granted by State Bank of India, Punjab National Bank, Corporation Bank, UCO Bank to the captioned companies. On default of payment by the said companies, said banks have initiated action under SARFAESI on various dates as detailed in the table here under.
Yes.
Individual demand notices they refer to. We understand on behalf of the consortium of bank, the secured interest was taken into possession by issuance of a common possession notice dated 22 and was published in newspaper on 21/2. We find that in the possession notice dated 22 issued under 13/4, liabilities owed to UCO Bank had also been included, whereas on date of possession, while the banks named 1, 2, 3 above had issued demand notice under 13/2, UCO Bank had not initiated any action under the SARFAESI Act. The third para of the possession notice very specifically states that the property is charged to all banks, whereas on date of 22, primary demand under 13/2 had not been initiated by UCO Bank. It is found that UCO Bank, subsequent to issuance of possession notice, had issued demand notice on 26/2/2015. Hence, the said possession notice suffers from infirmity and shall be liable to be set aside by the honorable courts or tribunals if challenged for being premature in respect to the liability to UCO Bank for not adhering to the procedures prescribed under law. We also find, subsequent to the said possession notice, petitions have been filed under section 14 seeking possession of secured asset. Same is also liable to be set aside on the above stated legal position. Hence, it will be advised to withdraw the notice. Now, this is what is there on record now, which they have placed at least before your lordships. Now, kindly see, my lord, the new 13/2 notice which they issue, which my lord will find at page number 162. State Bank of India, my lord, very clearly said that the account became an NPA on 28/5/2014. And that is, my lord, in my respectful submission, most critical. Because now suddenly there's a change. Good faith, my lord, has to be assessed on this basis in my humble submission.
Different banks have treated the account NPA on different dates.
Correct. We'll first look at State Bank of India. 28/5/2014 in the first 13/2 notice, the possession notice, it is said, and even in this letter, which is issued, my lord, for a so-called opinion, this is sent. Now, please see page 162, which is the notice under section 13/2.
Yes.
162, my lord. Last paragraph. You have also acknowledged subsistence of the liability in respect to the aforesaid credit facilities by executing confirmation of balances and revival letters and other documents from time to time. Operation and conduct of the above said financial assistance or credit facilities have become irregular, and the debt has been classified as a non-performing asset on 31/1/2010 by State Bank of India. Now, my lord, I ask myself, when an account becomes an NPA, then, Lord, you take action under law. Till 28/5/2014, you did not say the account had become an NPA. Now, all of a sudden, you tried to shift the date away from 28/5/2014 to 31/1/2010. Because, my lord, from 2010 till 2014, the account had become regular and was being performed fully. It could never have been taken as an NPA date. And you knew on 28/5/2014, it could never have been treated as an NPA. And therefore, State Bank of India, which is the leader of the consortium, issues this notice under 13/2. Well, I ask myself now, between 2010 and 28/5/2014, is it the case that this account, my lord, was not performing and that no payment was being made? It obviously cannot be, my lord, because from 2010 till 2014, there was continuous payments made in this account and the bank had no complaint. Now, why did they change it from 2014 to 2010 to justify the 13.2 action? It can only be, my lord, because there's no good faith. That is where the entire action in my respectful submission shows a mala fide attempt to justify what they have done after they took possession. There is nothing else. I have, my lord, at least in the few years I've practiced, I've never seen a bank saying, I first say it is 2014 and then go 4 years backwards and say in 2010 it became an NPA.
Yes.
And then again they issue that second possession notice, which, my lord, I pointed out at page 208. When I got the 13.2 notice, I sent a detailed reply, which is under 13.3a, my lord, of the Act, which your lordships will find at page number 171. One or two paragraphs, I'll just show you lordships as to how we had pointed out the obvious frauds that were being played. Because not by that time, the first complaint had been filed.
Yes.
Page 186.
One.
186. I'm just showing you lots of one or two paragraphs with respect to the stand taken by us at that point in time itself. It became obvious, 186. It became obvious to everyone that the company was operated by the CFO and the concurrent auditor as per the whims and fancies. I was given to understand by my Vice President Operations and other operation heads, CFO and his subordinates who are now arrested for a fraud of 100 crores formed an intimate group around the concurrent auditor where anything other than rescuing the unit was discussed. It appears that they were out to write the epitaph of the company in the interest of the safe exit and a tacit benefit to a competitor. Then Lord Para 18,
Yes.
concurrent auditor and the CFO managed between themselves to sell an item of machinery belonging to the company without the permission of managing director or vice president, who are the only two authorities for the kind of sale of a fixed asset. In the letter of appointment of the security agency, it was stipulated that no machinery should be permitted to be shifted without bank's permission. However, security allowed the sale of the machinery for 17.75 lakhs without the permission of MD or the vice president, but of the concurrent auditor or CFO. What power the bank had to sell the company's assets without the approval of the MD or the vice president? Therefore, where was the question of obtaining the bank's permission? Similarly, concurrent auditor was not authorized to approve the wages of any of the company's employees. Despite the same, he withheld payment to HP unit for 2 months, making the workers restive at the time of the visit of some interested investors. To give an impression, company also had industrial unrest apart from financial constraints. Even in the case of appointment of security agency, matter was not brought to the notice of MD, except forwarding a copy of the letter addressed to the security agency. It must be noted that CFO's contact number had been provided to the agency for any issues regarding their arrangement. This goes a long way to prove the proximity and their common agenda. Sometimes after the appointment of so-and-so, I was frequently in and out of hospital, and my son Rohan also was not in the management team. Two found themselves in absolute charge of stock and trade. We believe the combination of these have stolen the materials from the factory. Then erroneous issue of 13.2 in itself destroyed the continuity of business, and though definite planning was possible, later as withdrawal along with the notice under 13.4, taking symbolic position brought about a total confusion. This was a major issue. It was not stated why the notice under 13.4 was withdrawn. There was news going around that the title of the property was defective, and actually this was being said. Then, my lord, after this, they finally passed this 13.4 to a 13.3a, my lord. A reply was given at annexure AD 198. After which the possession notice was issued. That possession notice, my lord, is at page 208. 11 December 2015.
In all, how many possession notices were issued?
2 possession notices. The first one and the first one which was subsequently withdrawn,
Withdrawn. And the second one?
and the second one then. And then Lord, this action under 14 thereafter. But nothing was done after that. It was not as if then they came and took possession again. They did not do anything. It was merely a document created, according to us, to try and make it appear as if the first time it was only symbolic. But actually, the possession, control, and everything was under the control of that concurrent auditor who had been appointed, along with the officials of the bank. They were the ones, my lord, who are ultimately responsible for what happened there. They changed the security agency.
Whether you have asserted at the earliest that the physical possession is with the bank. You attended few of the meetings,
Yes.
joint meetings.
In 2014.
Several decisions were taken, resolutions were passed.
Yes.
Of which you are a part of it.
Yes, ma'am.
Whether anywhere in those resolutions, have you asserted that the physical possession was with the bank,
My lord, those are all prior to physical possession.
not subsequent?
If my lord sees, I know the minutes of meeting, my lord, which they have produced before my lord, they were all, please see the dates of those documents. Page? Page 78, my lord. One second. 78 is 21st June 2014. My lord has.
Yes.
This is minutes of meeting of 21st June 2014, my lord. Then, my lord, the next one at page 81 is 22nd July 2014.
According to you, when the physical possession was taken?
When they issued this first possession notice.
When?
June 2000, February 2015, sorry, February 2015. And prior to that, Lord, was appointment of concurrent auditor, appointment of a security agent, and a decision that the concurrent auditor will control all the finances. The instruction was to monitor, but he started controlling because he practically took over the control of the finances. And I'll show you also what there are in terms of documents.
So, in any of those resolutions, whether there was a discussion whether the physical possession was with the bank or?
No, all of them is prior to 2015. All these discussions which are on.
This February 2015.
No, there are no meetings after that.
There are no meetings.
No meetings after that. At least nothing is on record, my lord, to show there were any meetings. All of them, my lord, are up to August 2014.
Yes.
This is one part of it. Then a certain submission was made that there is a complete reduction in stock. And the stock was reduced because the stock, my lord, which was reported was completely false. And lord, the stock auditor was appointed, who also became the concurrent auditor afterwards. Something, my lord, which is normally never done. The stock auditor will never become a concurrent auditor. Stock auditor is there only for the purpose of taking stock because there should not be any conflict of interest between them. Now, the stock auditor takes a particular stand and then becomes a concurrent auditor. And then the concurrent auditor joins hands with other officials to siphon away property. In this regard, my lord, please see the documents which are there before the court in the new memo which I just gave your lordships. Page 7 is the first stock audit report. They are all bank empaneled auditors, my lord. This is, my lord, of the year 2012. in this, not the current status, there are 4 places where the goods are. Page 15, my lord will see.
Date of the report.
This is dated, my lord, at page 9 is the date.
Where it is.
Para 6. Page 9, para 6. 9/7/2012
And completion of stock audit.
stock audit.
Date of report.
Date of report.
Hmm?
No, this is. No, no, this first report is only for 2012. No, that is a different report. 16th August 2012, page 34, my lord. Page 34, 16th August 2012. I've produced each of them are part of the records, not there. Anyway, there are, but the locations where the assets are found and the stocks are found are 4. Page 15. No, it is.
What my learned friend is
I'm not talking of the concurrent auditor. I'm not talking of the concurrent auditor.
Page 7, what my learned friend is pointing out is by P and Pi and company.
Correct, correct, correct.
Not my client, not who has filed a criminal petition. The person who filed a criminal petition is not Mr. Krishnamurthy.
Yes, yes, I'm coming to his audit report finally.
Krishnamurthy is the concurrent auditor.
Mr. Murthy is,
He was a stock auditor.
and then concurrent auditor.
But first time, Mr. Krishnamurthy is appointed as stock auditor.
That was in the year 2014.
14. No, I'm just pointing this out not because these are records which are there.
Prior to that, there was an audit.
Yes, yes, there were several audits, not just one. There were several audits. The figures that are shown there and what Mr. Krishnamurthy's firm shows are completely different.
Who appointed this?
Between 12 and 14 is bound to be different. From 12,000 2012, not whenever a large account is being
Yes.
operated.
No, no, I'm not saying it will not be it will be the same, but
Person monitoring it in 2012, he had given some report. The Mr. Krishnamurthy's role comes in 2014. He was asked to check the stock.
correct. That's what I'm also saying.
At whose instance the measures BNPI conducted audit?
This is for the banks itself. No? Lordship will see on the first page. Page 7. Page 7.
Yes.
State Bank of India, Consortium Leader Bank, along with Punjab National Bank, Corporation Bank, UCO Bank. Then they ask for a report. And then a report is prepared.
Yes.
My lord will come to page 15, the locations where these stock are found. Bangalore factory, Kunigal, then Kala, my lord, is Himachal Pradesh, and then bonded warehouse. They are the 4 locations.
Where this bonded warehouse?
Whitefield.
Yes.
Then Lord may kindly take the next one at page 35. Another entity called Venkatachalam and Associates. They check my lord the stock at page 73. (2013), this is page 73 at the bottom. Whether the total stock value declared in March 23 month's stock statement tallies with the total inventory value reflected in the audit's balance sheet as on 31st March 2013. Yes, details are below. Please see raw materials, including stocks at ICD and consumer. ICD is internal container depot, customs depot. Customs depot. Customs depot. Not container, customs depot.
What was the stock during 2012?
I saw one entry in your this thing saying customs depot. I'm sorry, Your Lordship.
No, why you are relying on?
Why I'm relying is I want to show Your Lordship this report. Finally,
For what?
to say where the location of all the goods were and what the stock audit did not report. His report, my lord, Your Lordships will find this is ours, no? Our reporting, my lord, for 2014 is at page 85. I'm sorry, 55 to 84. This is another auditor, my lord, of the bank for the year 2014. This is 2013. That's what I pointed out at 73. Then, my lord, the report given by us at page 85 is on 31/5/2014, where the stocks are found at page 87.
$80?
87. Statement of stock and book dates as on 31/5/2014. I'm sorry, it has to, I think.
87. There is no pagination. 85
Oh, I'm sorry. I think the pagination is inside, not here. Inside.
Yes.
87.
Yes.
My lord will see at the middle, stock at ICD.
Yes.
And that is there, my lord, across everywhere. Then, my lord, at page 99 is the report of this stock auditor.
Page?
Page 99. He, my lord, at page 109, identifies the stock only with respect to 3 places, not the ICD. Physical verification of stocks. Page 109, aspect 4, valuation of inventory. Physical verification of stock, we have visited the units at Kanakapura Road on 7/7, Unit 2 at Kunigal, Unit 3 at Kala AMP on 19/7 for the purpose of perusal of stock records, also for physical verification of stocks being held over there. Our observation physical verification stocks are stated under. We have observed there has been significant reduction in the value of stocks between the level of stocks declared by MCPL and the stock statement in the banks as on 31st May and the level of stocks held by the company as per physical verification done by us in July 2014. Now, Your Lordship sees our entire statement has also been with respect to ICD. The verification is done only with respect to what is contained in these 3 locations.
Full form of ICD?
Well, it's either container depot or customs depot. Indian container depot or Indian customs depot.
When this report was brought to your notice?
It appears so. It appears it must have been brought to our notice.
Huh?
Might have been. I don't have an answer for whether it was actually given to us at that point in
Have
time.
raised any objection saying that no, this also having stock?
I don't know if it is written in writing or not. That is not.
Natural conduct on the part of the complainant. when the auditor does not visit one of the places and says that there is reduction in stock, naturally the complainant will raise objections.
I'll just check. I'll just check. There must be something. I'll just check. Now, it's inland container depot. ICD is inland container depot, not Indian or customs. It's inland container depot, but it's a
Yes. It is situated in Bangalore.
fine. It is in different parts of the country. Everywhere there'll be one Indian container depot. So now, my lord, please come to the charge sheet now. And I want to show your lordship what the issue is. How it started, my lord, with a complaint against the employees. And thereafter it was found that the concurrent auditor as well as the officials of the bank were involved in this entire fraud that was played on us. This is, my lord, at page 33, Annexure A. Can I request, my lord, to kindly come to page 42?
42.
42.
In the petition.
In the petition.
Yes.
Complainant Prashant Hegde established a company by name of Metal Closures on 7/12/1977, which went into commercial production on 1/4/78. Company has 3 manufacturing plants in Bangalore, Kunikal, and Himachal Pradesh. Manufactures packaging products like wrap caps, crown corks, shoe polish containers, battery jackets, lug caps, flash torches, etc. Company was a market leader in the metal packaging business with a multinational clientele, employed over 600 employees.
Yes.
During the year 92, A1 Mahesh Hegde was appointed accounts assistant manager, who over a period of time rose to become the general manager and CFO in charge of finance. In this role, he was responsible for bank operations like routine correspondence, submitting stock statements, and other regular bank operations except signing checks, RTGS and LC applications. Company had availed finance from consortium of banks of SBI, PNB Corporation, UCO Bank, and the details of advances outstanding balance as in the declaration of NP on so and so, it is under. This is the amounts, my lord. Then please come to next paragraph. Even Mahesh Hegde, who was also CFO with the help of A2 Yogesh Ural, who was deputy CFO during 11 and 2014, fraudulently operated company's bank accounts.
We have to consider the allegations made against the petitioners.
Yes, but I think it's all part of one charge sheet because it's not just their allegations.
These petitioners are all officials.
This petition, Lord,
Officials are auditors.
bank officials and auditors.
Auditor.
And of course, employees of the company as well.
Oh, they are
Their entire collusion is shown, Lord, in this particular fashion. Therefore, your lordship will have to see as to who all have been involved at what all stages.
the charge sheet.
Yes.
Separate allegations
Separate allegations are there, my lord.
against each of the accused.
It is there. That is there. I can show your lordship those. But what I'm humbly submitting is,
The petitioners are accused number 3, 4, 6, 7, and 8.
yes. I'll show that first, my lord, and then I'll connect it to the others. Because ultimately, it's all part of a larger conspiracy. Now, my lord, Mr. Rao Sahib Honakatti, that is the accused number 4.
Before that, Bhaskaran, accused number 3.
Before that, Bhaskaran, Lord. May I just start with Bhaskaran then? Lordship may look at Bhaskaran. What was he and what he did? He was at page 50.
Yes.
50. He was DGM in mid-corporate branch SBI Kumara Park, who took over charge of metal closures sometime in 2012. He was supervising the account in mid-corporate branch and also as head of consortium of banks. He had cleared RTGS and check payments authorized by accused number 1, Mahesh Hegde, and Yogesh Ural, also based on facts and photocopies to help them, but bank had confirmed about the exclusive operation of the bank account by the complainant Prashant Hegde, as per minutes of meeting of the board of directors of the company provided by the bank. First, note is this. He allows accused number 1 and accused number 2 on the basis of faxes and photocopies itself to operate the bank account when the entire minutes of meeting of the board authorized only Prashant Hegde to do it. When accused 1, Mahesh Hegde, in the month of April approached him for enhancement of loan, he was in favor of enhancement. but complainant expressed about fraud by A1 Mahesh Hegde and A2 Yogesh Ural and refused to accept enhancement of the loan. He made sure that the company is closed down by invoking surface action so that the fraud committed by the banks and others does not get disclosed. Then during September 2014, along with other accused persons A1 Mahesh Hegde, A2 Yogesh Ural and A8 Krishnamurthy, he sold stocks worth of US $7,33,181, that is USD 7,33, equivalent to about 4.5 crores, to Zarhak Steel Mumbai from Chennai port by photocopying complainant signature in the letters issued to the customs authority and shipping line giving no objection for transfer and title of goods to Zarhak Steel Mumbai at this time when the complainant was in intensive care at St. John's Hospital and no money was received by the company. It can be made out that the shipment was against LC number so-and-so of PNB and LC number of SBI, in respect to which the earlier bill of lading had been altered, goods have been diverted. Loss suffered by the company is 4.5 crores, which is included in the loss of stock due to misappropriation, and same was misappropriated. Similarly, they sold machinery worth 76 lakhs to Aura Polyflex was 10 lakhs and same was misappropriated. He unofficially asked A8 Krishnamurthy as stock auditor to falsely understate the value of stock carried by the company as on 31/5/2014. A8 Krishnamurthy along with Mahesh Hegde, without carrying out physical verification, understated the stocks at 3 factories as on 31/5/2014 and the report was submitted on 27/8/2014. A3 Bhaskaran, with the help of accused person A4 Honakatti, A1 Mahesh Hegde and A2 Yogesh Ural, forcibly broke open the EDP room and took away the main server containing ERP SAP, that is not the entire software, and tally software for manipulation of accounts, which was proved by RC number so-and-so of CBI FIR, and examination of witnesses, and also removed the LPG installation amount belonging to Total Gas to make sure that company did not restart its operation so that the fraud does not get disclosed. No, the entire software was completely destroyed.
When that all happened? 2014?
That the witness makes a statement that was done in April 2015, after the possession, in February 2015. One witness may not make a specific statement that a CW11 specifically makes a statement about this.
Who is he?
It's Srimati Vatsala,
Who is she?
who was assistant manager in the EDP.
EDP means?
EDP, my lord, is what's the full form? That's that. It's that room, my lord, where it is kept. I'll just give you lordships the full form of EDP. But she is an employee of the company. She makes that statement, and that statement is recorded. Then, next one, A3 Bhaskaran, with help of A8 Krishnamurthy, withheld the salary of workers of Himachal Pradesh unit with no administrative authority to do so, and making the workers agitate during visit of the strategic investor. Similarly, he refused to release payment of PF and ESI deducted out of salary of employees, which brought criminal action against complainant with the purpose to harass him. Then, my lord, the extract section 2313. No borrower shall, after receipt of notice under so-and-so transfer by way of seal, lease, or otherwise any of his secured assets referred to in the notice without prior written consent of secured creditor. Instead of also stating, except in the normal course of business, bank's notice stated without the bank's written consent. By this manipulation of the words, not even regular service was concurrent auditor, without the permission of the bank, which brought about early closure of the unit, even though some dedicated employees wanted to keep the factory going. This was done with the sole purpose of bringing about a sudden death to the company operations. Then 16, thereafter, on 22/2015, para 16, thereafter on 22/2015, he gave notice under section 13(4) of the Sarfazi Act for possession, which is not true since the accused bank had already taken physical possession of 1814 and 5814 by appointing A8 Krishnamurthy and A9 Santanam. At the time of taking possession, he did not conduct any mahazar and inventory, which violates Rule 412 of security interest rules. This shows a mala fide intention. He and A4 Honakatti refused to lodge a police complaint about theft taking place, in spite of complainant's repeated requests to do so, which shows the mala fide intention of accused. He and A4 tried to sell the company's expensive machinery to Shetron Metals and Messrs. Massali. Physical possession was taken on 22, was withdrawn on 7/7 by public notice, without issuing any reason, which shows irresponsibility and illegality of the first notice issued by the accused. Even after withdrawal of the notice, accused bank did not hand over physical possession back to complainant after conducting proper mahazar, but they continued the possession by keeping accused Krishnamurthy and Santanam in their possession. This is a mala-fide action by A3 Bhaskaran along with Honakatti. He has tried to state that possession taken by the bank is symbolic, but there is no word symbolic in Sarfazi Act. But all of the facts here clearly established. Possession taken is indeed physical. In the second demand notice, it was stated that accounts became NPA not on 28/5, but on 31/1/2010, as stated in the second demand notice dated 15/9/2015. In the intervening period from 2010 to 14, company had made payments of 101 crores for all the banks, including interest and installment. Therefore, the second demand notice was illegal and with mala fide intention by A3 Bhaskaran and A4 Honakatti. Routed payment of 8.89 crores, rupees 16.76 crores from April 2014 through Corporation Bank Sarakki branch with the help of A1, A2 and A7, even though there was instruction to operate only through escrow account. Also the fact that Corporation Bank Sarakki was not a member of the consortium. When the second demand notice was issued on 15/9/2015, complaint company submitted an objection as permitted as per section 13(2)(3)(a) of the Sarfazi Act, pointing out that A9 security agency and A8 concurrent auditor were appointed much before issuing 13(2) notice under Sarfazi Act. Therefore, Sarfazi action is illegal. No proper reply was made to the company as required under the Act, but went ahead to take physical possession once again on 11/12 by publishing a public notice on 11/12. Complaint requested the accused to be present for a joint stock verification on 3/6, 6/6 and 8/6/2016 to arrive at the correct stocks. Accused did not appear for joint stock verification. He and accused 4 had removed the bank security by SBI's letter dated 8/5/2017, confirming that the banks had taken physical possession and misappropriating the available stocks and selling the company machinery. This letter came nearly after 2 years, 10 months of taking physical possession, proving that the bank realized illegal action in taking possession in first week of August 2014. It may be seen that SBI had paid the security agency's charges by debiting to the company's escrow account, which proves bank's possession. He, along with accused persons, is responsible for criminal trespass, criminal breach of trust, theft and misappropriation. Other missing assets were 78.5 crores. This is Bhaskaran.
How you made the request for joint stock verification? Para number 24, there are several requests referred to 3/6/2016.
There have been letters. Letters would have been sent because those dates are specific. I don't know if those documents are here, Malone, but those are clearly letters which are issued because the dates are specifically there. I'll check, Malone, it must be there on the records. Then accused 4.
Yes.
Who is, my lord, the petitioner in this 57/59. He was chief manager, authorized officer in stressed assets management branch who took over charge of metal closures account on 3/12/2014. Accused Honakatti was colleague and associate of accused Bhaskaran. For the purpose of taking physical possession under 13(4) of the Sarfazi Act, Rule 412 Security Interest Rules provides for carrying out Panchanama and taking inventory, which was not carried out, which is clearly illegal, criminal breach of trust, paved the way for misappropriation of the movable assets of the company as stated in the complaint. He, with other accused persons, Bhaskaran, Mahesh Hegde and Yogesh Ural, forcibly broke open the EDP room and took away the main server containing ERP, SAP and Tally software. For RC number so and installation belonging to Total Gas to make sure that company does not restart its operations so that fraud does not get disclosed.
What is this RC11 2017?
Copy there. RC11. This is a CBI FIR.
It is stated that it is proved by RC number 11.
RC number 11.
CBI FIR by the bank, is it?
Beyond RC. (316), my lord, lordships will find the FIR lodged before the.
That was at the instance of bank.
Bank.
How that can prove something in favor of the complainant? Huh?
This allegation not there in his complaint.
That is a part of the investigation, not they have.
It says it is proved by RC number 11.
That they are referring, my lord, to RC number 11 of CBI FIR.
That is 316.
FIR filed by bank
Bank, that's what.
against them. In
That is-
that, the investigating officer is apparently not referred to that in so far as this is concerned.
No, but in the FIR filed by the bank, how can there be a proof in favor of the complainant?
Exactly. Can't be there.
ಇಲ್ಲ 316 ಇಲ್ಲೇ ಇದೆ. There 316 of the petition file, FIR number 11.
No, what is meant by this? That's what I mean. Forcible breaking open the room, taking away the main server, software, manipulation of accounts. Proved by RC number 11.
I think not that complaint which they filed. Now investigating officer Allah sir. Nah.
Whether any witness speak
How can I
about
file
this?
I'm sorry?
Whether any witness speak about this?
Yes, my lord. The witness speaks of it. If my lord kindly comes, the witness statements, my lord, which are, the gist is here at page 58 onwards.
Yes.
CW 11, Vatsala, page 61.
She is your employee?
Our employee. Employee.
What she says? All the server during April 2015.
Yes. First, my lord, first part she speaks of physical possession so and so by appointing it. Told her CBI took away all servers from EDP room. They need the password to open all servers. She said, I don't know the password. Again, she joined MCPL after reopen in the month of December 16. There is no information on all the servers. She says SPI took away the servers to tamper the information so that its misappropriation should be disclosed. She says about physical possession and misappropriation by accused. The statements, my lord.
What informed you about this?
This is, my lord, when it was record.
She is your employee.
Yes, ma'am.
She is bound to report it to the complainant.
Hmm?
Not
This-
reported.
This after possession, after taking over of possession.
Yes.
By which time, of course, not the disputes between the parties have escalated to a level where we are not communicating anymore.
You filed the first complaint,
First complaint not was filed.
December.
What is the date? December 2015.
First complaint against the employees.
No. This FIR is 16. This FIR is September 16. The first FIR is July 2015. July 15. Against employees. That's what I'm saying.
This Vatsala is also a witness in that case.
No, I don't know. Maybe she is.
See, many questions will arise because you are making allegations against your own persons. The such circumstances, and the witnesses are also the employees.
Being a company, there can't be any other witnesses.
Yes.
It has to be them.
So the question arises, why they have not informed the complainant immediately?
Well, I can only say this, my lord.
Some of the employees are accused, some
Yes.
of the employees are witnessed.
Witnesses. Now, my lord, if
Whom to believe whom?
well, my lord, that is the submission I want to make to my lords. Whom to believe and whom not to believe, my lord, is not your lordship's, my lord,
Of course,
consideration
may not.
today.
But prima facie, the court must be satisfied.
Lord, when I say prima facie, my lord, it is almost, I would think, the threshold is lower than even a discharge application. The threshold is lower. In discharge, my lord, of course, the court may also look at all the evidence and the material and documents.
The complainant is not a layman. is a qualified chartered accountant.
Yes.
He was running such a big company. He cannot plead ignorance like a layman saying that I was not knowing, I was not informed.
No, not knowing and not informed is one part. But the fact is he was in hospital for a significant amount of time.
Later part, 2015 onwards. I
15 onwards. 15 onwards.
But according to you, the fraud and all that was committed much before.
In 2014-15.
I think it was started 12-13.
Yes, but I would only
Chartered accountant.
when you're running a business of with 600 employees.
And I was mechanically attending the joint meeting with the bank. And I believed the version of the bank officers.
But I think, at least from what we know, no one can fight a bank. It is not so easy to fight a bank.
No,
You have to
maybe
go
it
on.
may be difficult. But as a qualified chartered accountant,
Yes.
being the managing director of such a big company, what was the role, what was the response of the complainant at the earliest point of time?
Lord, there are 2 or 3 ways. I can't really answer the question, Lord, because I can't put myself in his shoes. But I can tell you, Lordships, Lord, that the fight against a bank can only occur when it is found, at least.
See, we find an explanation by the complainant in his complaint, in the first complaint it seems, 2015.
15.
Saying that I was busy with the Himachal Pradesh unit, so I could not concentrate on Bengaluru unit. Can it be believed?
Yes, Lord. If I have faith in my chief financial officer that he's...
Long, sir.
How long, Lord?
Long.
How long? That's how frauds happen, Lord.
Says the company has become the defaulter.
Yes.
Financial constraints, there were, even we were facing difficulty in paying EMIs. Even after facing such financial constraints, if the complainant says, I was believing my CFO.
Lord, from at least my experience with creditors and debtors, the first thing, Lord, that a managing director will do is to try and salvage what is there. To either sell some of his assets, to try and bring the accounts, Lord, to a regularized fashion.
No, as a chartered accountant himself.
My Lord,
Understand, if I and you start a business,
then
you
of
may
course,
believe somebody.
it's bound to doom, Lord.
He being the chartered accountant.
Lord, chartered accountant, Lord, performing his role as a chartered accountant is one thing. Chartered
He
accountant,
was a shrewd businessman because he has established such a
see, I know, my
big,
Lord. Your Lordships know, my Lord, that Mukesh Ambani and Anil Ambani separated at the same time. Mukesh Ambani is the richest man in the world. Anil Ambani is one of the poorest
some
today.
other reason.
No, whatever reason, I'm only saying business acumen and ability, my Lord, to run a business may change with times and may also change with your own ability to run it.
Of course, see, it is all, after all, business.
There can be ups and downs.
Profit or loss,
Correct.
we cannot do that.
But if it...
Can the complainant say that I blindly believed my staff, CFO and other officials?
But there have been...
Number 1 to 11 in the connected case.
But there are so many times, Lord, we've seen that after some...
It's a very peculiar situation. Accused number 1 to 11, your employees.
Yes.
Are they accused?
In the first case, yes.
Yes. And some of your employees are witnesses.
Correct.
What is the first reaction of the employees who are cited as witnesses? They say, I have seen forcibly breaking open the lock, taking away the surveyor, taking away the stock, selling it somebody. What was their reaction? What was their responsibility as an employee? They are paid employees.
True. No, I understand. What I'm...
Say, at that point of time, I kept quiet. And after a year or so, I'm giving this statement.
The breaking open happened only after the securitization action. That is the possession having been taken and all of that. Now, Lord, of course, one can complain of delay in filing the complaint at best. But
not only filing the complaint, sir. All these irregularities, one by one.
Yes, Lord. But now once investigation
never
starts...
brought to the notice of the complainant, according to you. By
Once...
any of the employees.
Once, my Lord, investigation started, a lot of things came out. Much more than what I had complained about. Which, my Lord, is perfectly justifiable because an investigation can lead to many more things.
That can be.
Therefore...
And that is the purpose for...
investigation. And therefore, my lord, like my learned friend said, you never said it in your complaint. Yes, I may not have said many things in my complaint, but the investigation went on for about 2.5 years. And during this, my lord, a lot of material was collected. And with the material and the material evidence which was there, they were able to find out. Because, my lord, I'm sure they looked at the server, there's no material in that. How did it go? There would have been some investigation. They would ask this lady. She said this. Now, my lord, if of course it would be possibly a question in cross-examination if she comes as a witness as to why she did not inform the company or her manager or the managing director or the CFO, or maybe she didn't inform one of them and not all of the others.
When such allegations are being made against the responsible officers of the bank or the auditors, can it be said that it is sufficient if a witness says, yes, they were colluding with one another and committed the offense? Is it sufficient? Is it constitute a prima facie case?
Lord, to constitute a prima facie case, your lordship has to see whether there's some material or there's some person whom,
Material is the version
or
of the
some
witnesses.
version of a statement made, my lord, by a witness, which will have to be tested on cross-examination. Now, my lord, we don't have the benefit of either the witness here or cross-examination of that witness. Your lordship only has a statement. Today, my lord, in my humble submission, at the stage of examining as to whether to proceed to trial, your lordship, my lord, is not going into the question of whether that witness is believable or not.
Not be. That may not be the exercise it is to be undertaken by this court. But at least.
No, my lord, but then your lordship will have to then say, maybe, my lord, there are letters written. Maybe, I'm just saying, maybe there are letters written, but the police has not put it in the charge sheet. I'm just saying, it is possible. It is not there. There could be a circumstance, my lord, and that can't be a circumstance to say that therefore, because the company did not take any action or the complainant at that point in time did not take any action, therefore the crime was not committed.
The investigating officer also, just now you read the charge sheet.
Yes.
He says it is proved by CBI something.
Yes,
What is
ma'am.
proved by that?
We'll ask them. I also don't know.
Material.
That I don't have an answer.
At each stage, some or the other question is cropping up.
Lord,
Who has to answer that?
Lord, if
Of course, I have to look into the overall allegations and
Yes.
arguments made. I need not have to go to the each and every item.
Correct.
It is not the exercise I have to.
which is why I started
undertake.
my submission, Lord, today by saying,
Can I shut my eyes to all those things and say, yes, there are prima facie material? Go ahead.
no, Lord,
It will be of very serious consequences.
yes, they may be convicted, they may be acquitted, Lord. One of the two will happen. Today, of course,
Concerned
today,
about
of course,
that.
the question of
We are not concerned whether they will be acquitted or convicted.
today, my Lord, there is no threat of arrest. All of them are on bail. There is no. This is only a question of trial.
Facing a trial is also very serious, very
Yes.
serious thing. That too for an official.
My Lord, yes, retirement benefits, why it has been withheld, why disciplinary proceedings were initiated against them.
Not only that.
All of
sir,
those, my Lord, also have to be seen.
Consider the embarrassment to that person.
My Lord, if I would respectfully say, my Lord,
FIR is not a simple thing.
yes, my Lord, registration of FIR,
Simple offender, it may be a routine.
yes, registration of FIR, filing of charge sheet, my Lord, and standing trial are all embarrassments. There's no question. But still, my Lord, if a cognizable offense is made out, you have to register a charge sheet.
Seen the witnesses when they were appearing before the district court. Advocates, when they suggest, ನೀವು ಸುಳ್ಳು ಹೇಳ್ತಾ ಇದ್ರಿ, they used to revolt. ಎಲ್ಲಿ ಸುಳ್ಳು ಹೇಳಿದ್ದೀನಿ, ಎಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ. See, a common man will not digest that.
My Lord, Your Lordship, you have seen the FSL report last time, when I think Mr. Mandigi pointed out. There is something, my Lord, which shows that signatures have been forged. Now, my Lord.
Question arises, who has forged? According to you, your own CFO has forged.
Yes.
Accused number 1 and 2.
Correct. What to do? If my own CFO forges my checks and forges my accounts, I have to take action sometime whenever I know.
There was no allegation against the employees. Some substance against the bank officials. But here it is not the case. You make serious allegations against your employee.
Yes. And also.
Thereafter, the second complaint came to be.
Correct. Then serious allegations against the bank employees as well. And those allegations in my humble submission, Lord, are fairly serious.
Such serious allegations were made against the bank employees. That too when the provisions of SARFAESI Act was invoked. You have to justify that.
My Lord, when your Lordships look at Priyanka Srivastava's case,
yes,
and look at this case, there's a world of difference, my Lord. That was a case where simpliciter and allegation was made for the action taken. And therefore, my Lord, Supreme Court said that action is certainly protected under Section 32 of the Sarfazi Act. Here, my Lord, which is why I showed your Lordship how the action was taken. And we are looking at only the Sarfazi action, nothing else. As to how, my Lord, dates change from 2014, it goes to 2010. Between 2010 to 2014, 100 and odd crores has been paid to the banks. Yet you alter it to ensure that you want to now protect the fact that the possession has been taken properly. You then again resort to taking of possession. Then you file a Section 14. You get an order, but don't take action thereafter. And in all of this time, huge amount of assets of the company are frittered away. When, according to us, you were in possession of the company. Now, my Lord, this is to be tested on the basis as to whether there is bona fide action.
To you, the bank has taken physical possession. Is there any document to show that you are relieved of the possession? They are in physical possession. The complainant and its employees were nothing to do in the premises.
My Lord, it's a factory, my Lord. When they took possession, there were two parts to it. One is take control of the finances, take control of the accounts,
Yes.
and then take control of the factory.
Yes.
There are three parts to it, which is why, my Lord, your Lordship will see from 2014.
It is their specific contention that only symbolic possession was taken. Actual possession was never taken. That is their contention.
Yes.
According to you, physical possession was
Correct.
taken. What was their arrangement? What was the understanding?
My Lord,
Because admittedly, the business was running at that time.
this will become a matter of proof, my Lord. Now, I can't say anything more than what is there in the charge sheet. And if I say something, my Lord, it will become my statement before your Lordships, which anyway is not admissible as to what was done. Now, the charge sheet says certain things. And, my Lord, charge sheet makes a clear finding, or at least, my Lord, an investigator has concluded.
Not a empty building for taking possession of
No,
it
no, of
and
course.
saying that you are in possession of it. It is not. It is a running business.
Yes, my Lord, which is why immediately thereafter, very quickly, the business came to a grinding halt. Which is why they said that LPG was removed. It could never restart after that. All of those, my Lord, are contributing factors which should show what is being done. Ultimately, my Lord, the fact that it may cause embarrassment to someone, and if that person has actually committed a crime of this kind, why should a business which was running well come to a grinding halt? 600 employees are on the street at the end of the day.
The charge sheet, of course, there are serious allegations against each of the accused.
Yes.
But many of the disturbing questions remain unanswered.
My Lord, I am sure, my Lord, if your Lordships analyze most charge sheets, that will be the state in our state and our country.
So, at least we should be in a position to connect the accused.
Yes, my Lord. I mean, what is stated here has to be born out of some material.
That is what it is called a prima facie case.
True, my Lord. Now, of course, there can't be a question that there has to be a link or a chain of events which lead to a particular conclusion.
One example is just now you read proved by CBI, complaint.
And examination of witness.
By that.
He says you two things. One is the RC number so and so and examination of witness. The two things which are there.
Is there in CBI complaint.
That CBI complaint, my Lord, I don't know. Maybe there is something which, just see the CBI complaint. I think it is produced. No, one second. Where's the letter written by the bank?
Casually, I cannot say there are prima facie material proceed against them.
Hmm? 294 is the complaint to the charge sheet, to the CBI.
That is by the bank.
By the bank. Therefore, if at all, my Lord, it should be in.
What is there to prove your content?
I think, my Lord, in the checklist of documents, this page 315 is a checklist of documents What is the annexure 3? Just no, it appears that there could be this entire material placed before the CBI at page 315.14, the list of documents,
For the enclosures.
enclosures,
Ah.
it is possible. I can't certainly say what the truth is, but it could be, that point 14, serial number 14. The records which are there is possibly what, the police refers to, because the fact that this tally records possibly was placed before the CBI by the bank. That ERP, SAP and tally software. That I'll have to check whether that is there, because
You have raised this issue regarding whether physical possession was taken, symbolic possession was taken before DRT.
I don't remember, but
When you question the action taken under SARFAESI,
yes.
naturally you will raise that.
What happened was, first, when we challenged it, there were two challenges to the entire action. The first was a challenge under 13.4 when they took action. Then they withdrew it. Then they issued a fresh possession notice or a fresh demand notice. Then both actions were combined and kept. But ultimately, in that order, the court considered the second action, not the
So
first.
when you approach a DRT,
I don't have those dates.
unless these sequence of events are brought to light, it will be very difficult.
I'll make one list of dates for your lordship, which is comprehensive. It has all the dates from the beginning till
When you say that they have not acted in good faith,
yes.
all these dates and events are.
Acted in good faith, ends with the taking of possession and ends with the 13.2 till the taking of possession, and there it ends. That good faith concept, is that. But then the second part of it is whatever is done after the possession is taken. Because the SARFAESI action stops at 13.4 unless they sell the asset, which they never did. They never sold the asset. So the 13.2 to 13.4 is not where the action under SARFAESI is covered. That is the first part of it, which is because they are saying there's a statutory prohibition in taking up prosecution against the bank officials.
DRT.
In the meantime, I approached DRT. There was that went on till 2024.
Order.
I don't know if there's an interim order. I don't think there was an interim order. There was no interim order of protection.
Okay.
There was no interim order. Then your lordship know in 2016, the 14 order to take possession. Order is passed, but no action is taken. But all of this indicate, why would you not take action if you're so confident that you've done nothing wrong? Why would you not take action? You should have said, I'll take possession now. You don't take possession of the action. If you say that was symbolic and actual is after 14, the order is never given effect to. No one goes and takes possession of the property, actual possession. But your security guards are there. Right from 2014.
There was no resistance.
If there's no resistance, then they've taken physical possession. If there's no resistance, then physical
Only if
possession
there
is there.
Resistance, the question of taking police help and all.
No, but what I'm saying is, if there was no resistance in February 2015 when they took possession, why would they go in 2016 and ask the court for protection?
That is for physical possession.
That's what I'm saying. If really, my lord, there was physical possession needed to be taken, then why did they not take physical possession? They never took physical possession after 2016. Otherwise, the order would have been executed. They would have drawn up a mahazar and said, I have now taken physical possession of the property. They did not do it. Clearly indicating that they were in physical possession. All was a charade played, a drama done in order to ensure, my lord, that some records are created to say we are actually going to take physical possession now. If this bank was so keen and so clear as to what they had done, they would immediately the next day gone and taken physical possession after the order was passed. Continue, my lord.
When?
Monday or yeah, Should we do it after vacation now, my lord? Or- Because given the amount of time that we have, your lordship, we have partly heard this
I
matter.
have to file a detailed sequence of events,
We'll do that.
with dates and events.
Yes, that we'll do. I'll file it, no difficulty.
Otherwise, it will be very difficult.
I'll assist your lordship, my lord, in whatever best we can. This is the state of the investigation. Whatever is there is there.
Repeatedly asking, raising the queries to understand myself.
Yes,
Otherwise,
Lord.
it will be very difficult.
of course. Our duty, my lord, is to place whatever we can. But I can't make statements on behalf of these parties, not as to what happened then. Because my,
You may be heard also,
I know.
my learned friend is complaining,
Hmm.
the challenge to the charge sheet, so the state may not must defend whatever action they've done. Most of the questions which is falling to the court, may not, they may not know. It's ultimately for the IO to explain to the honorable court what they have done and how they have
yes,
done. what
IO will have to also argue, my lord. There's no question. Now that I think my learned friend should keep for cross-examination, my lord.
The
Why
state-
particular IO did not ask,
I
look
don't
at a
know
particular
what is the
document.
stand of the state.
Yes, that's why I'm submitting, my lord. If my learned friend, my lord, at this stage can be stopped and let the state answer, my lord. After all, complainant's
But
job,
state may not be interested in this.
then, my lord, your lordship,
Ultimately, the state will say, pass appropriate orders.
if they have no explanation to the doubts of the court, I'm afraid court will have to proceed, that's all, my lord. Complainant cannot, my lord, amplify.
Complainant, my lord, can explain what has happened and what the situation is, what is there in the records, which, my lord, they may not point out. But they, if they turn around and say why he did not examine something, then it is like cross-examining either the
They can
public
file charge sheet,
prosecutor
they
who
can
comes.
investigate, they can arrest, but they can't explain.
No, I'm not saying that. I'm saying if he can't
That's the
explain,
grade.
Regarding the facts of the case, you have to explain.
yes, yes, facts, of course, not we are explaining. I mean, but I can't go beyond what is there on the record today. Of course, there are so many other documents which are placed before your lordship outside the record saying these are there. How much your lordship will examine it at this stage to examine as to whether a case is made out or not to proceed for trial is another question altogether.
See, many of the resolutions were pointed out when the learned advocates, either senior advocate or the other learned counsel has addressed the argument.
Yes,
But all those resolutions will have a bearing on this when the physical possession was taken, whether the possession was symbolic or physical, when the account was declared as NPA, and each bank has declared NPA on different dates. So again and again, we have to go back to that.
yes, my lord, which is all of that is there.
And now the proceedings before DRT, now it is challenged before this court. That is one separate.
That of course,
non-civil
and
side.
anyway, DRT says, I
Yes.
can't, and your lordship now have said, Supreme
Yes.
Court has held, criminal proceedings, civil proceedings can go on, one finding is not binding on the other.
Now this, two complaints are pending here,
Yes,
and one CBI inquiry is pending.
that is
that is
state, that is state, that is state,
Yes.
that is state.
So in the midst of this, I have to find out something.
Very
The charge
obvious.
sheet. And even the complainant says it is a draconian law. But what,
That of course your
for
version.
all practical purposes, it is the final report of the investigating officer.
Yeah.
We cannot jump to the conclusion.
But we can, if we read between the lines, what becomes clear is that is our respectful submission.
All of these reading between the lines, not is good for trial. But now you have to read the lines as they are and then understand where everything is headed.
Not if it's a vexatious proceeding. Repeatedly, my Lord, Honorable Supreme Court has said that Honorable Court at this stage in 482, my Lord, can certainly go into it. If
No,
we-
to hold that it is a vexatious proceeding, some application of mind is necessary.
Most certainly, I respectfully agree.
There's no question. Application of mind, of course, all our submissions before my lord are only to persuade your lordship to my lord, look at a scenario in a particular fashion.
But I have to draw a line where I should stop.
Yes,
Yes.
that of course,
Yes.
that. And how far will your lordship go? I want to place some authorities also for my lord's consideration at this stage.
Under peculiar facts and circumstances. See, on overall approach of the court, if the court forms an opinion, yes, of course, there are some merits in the case. The court will not interfere.
If your lordship finds that there's absolutely no merit, then it must be quashed. There's no question. But
As of now, many questions will arise.
but whether those questions your lordship should reserve for trial, or whether they should be reserved at this stage, is something your lordship will consider.
I will not encroach on the jurisdiction of the trial.
No, which is what I'm
Definitely
saying.
not.
My submission also will be that many questions I may not have an answer today.
Satisfaction of the court is necessary at this stage to
Yes.
allow the trial to proceed.
In-
Mechanically, I can shut my eyes and say, anyhow, these voluminous documents are produced, go before the trial court, face the trial.
Otherwise, we would have possibly not spent so much time trying to persuade my lord. That is certainly not what we are saying, Lord. That your lordship must simply reject it on the ground there is a voluminous material. Your lordship will also see the material. But having seen it as to what...
I'm not discouraging the complainant.
No,
I'm trying to understand what is the allegation.
Yes, of course.
Why such allegations are being made.
Well, anyway, my lord, I think...
When?
Should we do it after vacation?
ಒಂದೆರಡು ದಿವಸ ಮುಗಿಸ್ಬಿಟ್ರೆ ಮುಗಿದೋಗ್ಬಿಡುತ್ತೆ ಇಲ್ಲದೆ ಇದ್ರೆ
ಏನು court officer?
Iವಾಗ hardly 1 week is left.
1 week ಇಲ್ಲ. Working days, 4 or 5 days.
4 or 5 days. There'll be a lot of urgent matters coming up. No problem. Anyway, after spending so much time, I won't
Monday?
hear it.
Please,
Monday.
please.
30th, 31st, I can't. Both days I can't.
ಇದೇನ್ ಮುಗ್ದೋಯ್ತು ಸರ್
ಹೌದಾ?
I thought my learned friend has not finished most of what he had to say.
1,
Please
2,
stay.
3 senior counsel argued over 4 days. And
Thank
one
you.
senior counsel still wants to argue some more.
No, we have had the burden of showing all the record, my lord. Most of the record we have read. So he has to only point out where are the flaws in our argument. That I think he has effectively done till now.
No, not so effectively, sir. Wait a minute.
See, I cannot leave him so easily because the burden will shift on me.
Lordship will fix any day.
But it is not convenient.
Monday, Tuesday, not possible. Sir. Last 2 days.
Then only option after vacation.
Yes. 16.
18th may not be possible. Allela holiday ಬಂತು. Continuous holidays. Only 3 working days ಇದೆ ಅದು.
Dasara Nantara, after the vacation.
Yes, even then, 14th, 15th, 16th, only 3 working days, again holiday.
Again, go.
20?
21st, 22nd. 23rd.
That will be too long.
Hmm?
17th, 18th, any of the working Saturdays.
Didn't really. How will that be?
14, 15, 16,
22nd,
Yes, 22nd.
22nd Tuesday.
22nd.
2:30.
22nd, 2:30.
I'll treat it as part of.
Yes.
I thought it would extend. 20? 22nd or 23rd?
Any day, whatever.
22nd? Yes.
I'm great.
Yes. ಜೊತೆ ಮಿಕ್ಸ್ ಮಾಡ್ತೀವಿ. 15 ಮಾಡಿ ಇದು ಇವತ್ತಿನ.
Then they move CBA macros.
ಇದು ಅದ್ರ ಜೊತೆ ಅದ್ರ ಜೊತೆ ಲಾಸ್ಟ್ ಪೇಜ್.
Client time ended.